CM photo yaar koಟ್ಟಿದ್ದು madam ಇಲ್ಲಿ madam ಅವರ
ಕೊಟ್ಟರು ಸರ್
ಯಾವುದು ಕೊಟ್ಟು
ಕೊಟ್ಟರು ಸರ್ ನಾಳೆ ಆಗ್ತಿರಲ್ಲ ಸರ್
ನಾಳೆ ಮಾಡಿ
Which matters, preliminary matters you can give.
My lord, matter is pending
Which
matter.
matters, preliminary matters you can give.
The GMCTC matter, my lord, it's been pending. The OS has been pending since 2000.
Please give it, sir. If it's a fresh matter, you please give it.
It's not
Lord,
fresh
it's a
matter.
pending matter, my lord. My lord,
I'm not receiving
spot sale and court sale.
memos in respect of old matters. If you have to get the old matters listed, you will have to file an application for earlier.
Application
Lord,
has been filed. sir.
Spot sale and court
One
sale has been
submission.
issued, my lord. There are
You don't
tenants.
have to mention anything, sir. If it's a fresh matter, you please give
Lords,
it.
it's pending, my lords. I've served the respondents.
No.
My lords, the matters on
No, 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 no.
submission
20th of August, my lords.
File an application for earlier. We'll see.
Lord,
Yes.
Application is
My writ will become infractions, my lords. Spot sale and court sale has been issued. There are residents, there are tenants at the residential
No, no,
property.
no.
Only for 9 lakhs, the court has issued a sale proclamation and a spot sale, my lord.
Yes, please follow.
sir number one submission please sir one submission ನಿನ್ನೆ ರಿಲಿಸ್ಟ್ ಅನ್ನ ಅರ್ಜನ್ ಅಂತ ಅಪ್ಲೋಡ್ ಮಾಡ್ತೀವಿ ಅದೇ ತರ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ ಸರ್ ನೀವು ರಿಲಿಸ್ಟ್ ಮಾಡಿ ಅಂತ ಮೊನ್ನೆ 5th ಡಿಕ್ಟೇಷನ್ ಕೊಟ್ಟಿದ್ರಿ
ಹಾ.
ಸೊ ಇವ್ರು ಯಾರು ಟೈಪ್ ಮಾಡಿರೋ ಯಾರು ಅಪ್ಲೋಡ್ ಮಾಡಿರೋ ಗೊತ್ತಿಲ್ಲ
ಏನ್ರಿ ಅದು ಪ್ರಾಬ್ಲಮ್?
ಮತ್ತೆ ಅದರ ಅರ್ಜನ್ ಅಂತ ಅಪ್ಲೋಡ್ ದಯವಿಟ್ಟು ನಾಳೆ ಶುಕ್ರವಾರಕ್ಕೆ ಹಾಕೊಡಿ ಸರ್
ಅಲ್ಲ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದು ನಾನು
ಹೌದು ಸರ್
ಆರ್ಡರ್
ಪ್ರಾಕ್ಟಿಕಲ್ ಸರ್
ಸ್ವಾಮಿ ತಮ್ಮ ಡಿಕ್ಟೇಷನ್ ಗೆ ವ್ಯತಿರಿಕ್ತವಾಗಿ ಸ್ವಾಮಿ ಅಪ್ಲೋಡ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ ಪೋರ್ಟಲ್ ಅಲ್ಲಿ.
ಹಾ?
ತಮ್ಮ ಡಿಕ್ಟೇಷನ್ ಗೆ ವ್ಯತಿರಿಕ್ತವಾಗಿ ಪೋರ್ಟಲ್ ಗೆ ಅಪ್ಲೋಡ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. ನಮ್ಗೆ ಅನ್ಯಾಯ ಆಗ್ತಾ ಇದೆ ಸ್ವಾಮಿ.
ಮ್ಯಾಟರ್ ಬಂದಿತ್ತಂತೆ ಕೋರ್ಟ್ ಮುಂದೆ.
ಹೌದು ಸರ್ 5th ಬಂದಿದೆ ಸರ್ ದಯವಿಟ್ಟು ನಾಡ್ದು ಹಾಕೊಡಿ ಸರ್ ಆಯ್ತು ಆಯ್ತು
ತಾವೇ 7ನೇ ತಾರೀಕು ಕೊಟ್ಟಿದ್ರಿ ಸ್ವಾಮಿ.
All right, let us see. Yes. Please follow.
My lord, in second list, my lord, seal number 12, I may be permitted to withdraw the writ petition.
Follow.
Seal number 12 in second.
Second list. ಯಾವ್ದಾ ಇದ್ರದ್ದ? All infectious, second list. Hey, ask him to go out. Please go out. ಯಾವ್ದು serial number?
12, my lord.
The second list, serial number 12. Learned counsel for petitioner has filed a memo.
ಪೆಂಡಿಂಗ್ ತಗೊಳ್ತಿಲ್ಲ
Matter has been settled before the trial court.
7/8/2024 stating that the original suit in OS number 8778 of 2015, out of which this writ petition arises, has been disposed of. And therefore, the prayer made in the writ petition has become infructuous. Full stop. Next para. The memo is taken on record subject to all such exceptions. Accordingly, the writ petition stands dismissed as withdrawn. The prayer made in the writ petition has become infructuous.
Serial number 3.
Serial number 50.
Second list ಅಲ್ಲಿ all of them are according to us have become infructuous. If there is any memo you are filing in respect of list number 2, you can please give it. I'll pass order.
List number 1, my lord, serial number 3 has rendered infractions.
3. List number 1, serial number 3. Learned counsel for the petitioner has filed a memo. It is 7/8/2024 stating that same order of OS number 68 of 2021. Huh? Yes.
Serial number 59 in list 1, my lords. Serial number 59 in list 1, my lords. Appear for the petitioner. I seek for 1 week's accommodation, my lord.
Unless the other side is
My
here, say
other
no.
side is here, my lords. I've taken his consent.
They have filed their objection.
I have to 59. I have to file my objections to the IA for vacating stay, requesting for next week, my lords.
You are for the,
Petitioner, my lords.
you are for the respondent.
Yes, ma'am.
Mr. Appaya PB,
Yes, your honor.
serial number 29. at the request of learned counsel for the petitioner,
Next week, any date.
this matter on 14th of August.
Great. Interim order may be extended.
Interim order granted earlier stands extended to the
Great.
next date of 56 first list. Serial number 56. Learned counsel for the petitioner has filed a memo dated 7/8/2024 stating that the petitioner does not intend to prosecute the writ petition any further. And therefore, the writ petition may be dismissed as withdrawn. We'll stop. Next paragraph. The memo is taken on record subject to all this text. Accordingly, the writ petition stands dismissed as withdrawn. Yes.
Any adjournments, other side to be present?
Correct.
List number one,
My lord, I
serial number
appear for
one, for being
the,
spoken to.
I appear for the respondent. My lord, the respondent, my lord, we have filed a memo for,
ಯಾಕ್ರಿ ಎಲ್ಲ ಹಿಂಗ್ ನಿಂತ್ಕೊಂಡಿದ್ದೀರಾ? ಕೊಡ್ರಿ. Yes,
my lord, we have,
petitioner,
my lord, I am for the respondent. The respondent has moved an
you are
application.
for the petitioner.
My lord, we are only,
First petition, I am petitioning. Second, I am responding.
Allah, we have filed this memo on the ground that your lordship has allowed the writ petition only for a direction to hold an inquiry within 4 weeks, my lord, and dispose of the execution petition. This is all my prayer.
Huh.
My lord, 2 crores is the decree amount.
What happened?
My lord, the lordship has not observed in the order
Ah.
dated 31/7/2024 with regard to the time frame, my lord. The observation ಇಲ್ಲ enquiry ಗೆ order ಮಾಡಿದ್ರೆ ಸ್ವಾಮಿ. Within a time frame, my lord, within 4 weeks, my lord, your lordship may allow the inquiry to be hold.
Copy ಇದೆಯಾ?
ಇಲ್ಲ, ಇನ್ನು ರಿಲೀಸ್ ಆಗಿದೆ.
ಏನ್ರಿ, what do you say?
ಅಲ್ಲ,
4 weeks
ಅದ್ರಲ್ಲೇ-
is an inquiry, my lord. I am the objector.
My lord, I don't know the work pressure of the commercial court. 2023 execution, my lord.
ಒಂದ್ ನಿಮಿಷ.
2 crores is the amount, my lord, that's why.
One crore, huh?
There is no need.
ಏನಾಗಿದೆ
There is no
ಅಂದ್ರೆ
need.
2 crores 90.
Better.
97,000 is
You are
due.
appearing for whom?
I appear for the respondent plaintiff, my lord.
Huh?
Suit was compromised.
Degree holder.
Yes, my lord. ಅದಕ್ಕೆ ಒಂದು ಟೈಮ್ ಫ್ರೇಮ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ
No, no, no.
ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ
Yes.
my lord, unless he has come into the shoes of the objector, has come into the place of the judgment debtor.
No, no. Yes. Read next matter, correct.
At least your lordship may direct the execution petition to be
So
disposed
the
of.
matter has been disposed of by order dated so and so. At the instance of the learned counsel for
The plaintiff
respondent,
respond.
for plaintiff, for decree holder.
Yes, my lord.
This matter has been listed for being spoken to. Full stop. It is the contention of the learned counsel for the respondent that a time frame has to be fixed for conducting the inquiry. Full stop. Next paragraph. Having gone through the orders passed by this court once again, comma, this court does not feel any need to issue such a direction. Full stop. Yes.
Inquiry my lord, your lordship.
No, sir, not necessary. Yes.
Preliminary serial number 2, Abhinav White.
They served on me, but the first respondent is no more. We filed a memo before the trial court also reporting the death.
That's not by Monday, my lord, then I'll take steps. Relax, sir.
LR is there.
First respondent.
We have filed the LR application also before the trial court. on
By Monday, my lord, I'll file
Even
the
eight
necessary application.
before
For not appearing for response number 2 and 3.
ಇಲ್ಲ, 2 and 3
ಇಲ್ಲ.
galla. They are colluding with them.
R2 and
Only
R3
R1 is the
R2
contest.
and R3, my lord.
So R1 is the only contesting
Contesting. She was
respondent.
the impleading applicant.
Impleading applicant.
Hmm.
She is no more. She
That's
died
what by
on
Monday, my lord, I'll file the necessary
13/7/23.
By Monday, my lord, I'll file the necessary application. I'll take instruction.
Learned Counsel Shri
Pradeep Naik.
Pradeep Naik,
Yes, please.
on whom the learned counsel for the petitioner has served a copy of the writ petition, appears before this court and submits that respondent number 1 herein, who is defendant number 3 before the trial court, and the contesting respondent is no more. Full stop. Next para. Learned counsel for the petitioner submits that necessary application will be filed to bring the legal representatives on record. Ordered accordingly.
Someday next week.
ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಬರುತ್ತೆ.
Great. Serial number 4.
Order passed, serial number 4. Manjunath Avi.
I'm appearing for petitioner in this case, Your Honor. My petition in the lower court, original suit was dismissed for want of jurisdiction. And the petitioner, petitioner and defendants are family members. Who the petitioner had supported the
Impugned notice annexure A.
Yes, Your Honor.
Huh?
Yes, my lord. Petitioner and respondent are family members. And the petitioner had supported the respondents from 97.
Suit for?
Suit for recovery of money of 40 lakhs here.
Ah,
And the petitioner had supported the respondents from 97 till 2021.
pecuniary jurisdiction.
Yes, Your
Ah, what is the problem?
Honor. There was an agreement which was entered in Gadag.
ಹೌದು sir, pecuniary jurisdiction ಮೇಲೆ it has to be presented before the appropriate court. That is the order.
The want of jurisdiction here,
Yes, pecuniary jurisdiction.
not pecuniary jurisdiction.
Ah, then
It is for jurisdiction, want of
what type of jurisdiction, sir?
the filing of the suit, Your Honor, not for pecuniary, for filing of the suit, jurisdictional.
Jurisdiction
Yes,
are two types.
yes, ma'am.
One is pecuniary jurisdiction. Another one is the
Territorial jurisdiction.
territorial
This is for territorial jurisdiction.
territorial jurisdiction. Money suit.
Yes,
Yes.
the petitioner is residing in Bangalore and from the
We'll consider-
respondents.
Issue notice to the respondents. The petitioner is also permitted to serve a copy of the writ petition along with annexures from the learned counsel representing the respondents before the trial.
Much of.
Yes.
Serial number 5, Balraj AC. Withdraw.
This is the lordship. You have to take impleading application, advocate party ಮಾಡ್ತಾ ಇದ್ದೀವಿ. Kindly week time for that.
ಏನು?
Necessary party for that advocate also. For implead ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಇದರಲ್ಲಿ ಲಾಸ್ಟ್ ಕ್ವೆಶ್ಚನ್ ಯುವರ್ ಆನರ್ಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಪಾರ್ಟಿ ಮಾಡಿ ಅಡ್ವೊಕೇಟ್ ಅಂತ ಹೇಳಿ ಡೈರೆಕ್ಷನ್ಸ್. ಹಾಗಾಗಿ ವಿ ಆರ್ ಇಂಪ್ಲೀಡ್ ಇಸ್
Filing another application. Release this matter. At the request of learned counsel for the petitioner, release this matter on 14th.
Much of.
Yes.
Serial number 6, Sadashivaya KG.
Please, my lord, I beg to appear for the petitioner in this matter, my lord.
Yes.
My lord, it is filed by the defendant's writ petition before the honorable court, my lord. An application came to be filed under Order 9 Rule 7 of the Code of Civil Procedure. My lord, the petitioner having purchased the property, 2 items of the properties. My lord, thereafter, my lord, suit for partition. Partition, my lord. My lord,
Which is
my
the
lord, it
impugned
was
order?
impugned order is at Annexure A, my lord.
Annexure?
A, page 31, my lord. 37. The relevant portion is, my lord, the application filed by the petitioner. My lord, in fact, the brief facts of the case are this, my lord. The partition was
Placed
filed.
ex parte.
Yes, my lord. My lord, no notice was produced, given to me. Right, and my lord, Lakshmi kindly appreciate, page 17 may kindly be looked into, my lord.
Huh?
Page 17, my lord. On 4/11/2015, my lord, notice was ordered to appear before the court, but my lord, the shara was that, my lord, unclaimed. At that point of time, the petitioner left the place, my lord, long ago. And immediately, my lord, next day, on 2/12/2015, my lord, the court shara is there. That, my lord, I am
Agree.
blessed expert.
Suit for partition,
Yes, my lord.
all of your family members,
No, I am the bona fide purchaser, my lord.
purchaser,
Purchaser, having purchased the property, my lord, from a person. My lord, I put into the possession of the property. I have been enjoying the property. One of the person, that is the first respondent, filing the suit for against the father and others person who have sold the property in my favor.
yes.
It was the absolute property of the wife of the first respondent here, Narayan Reddy. My lord, in spite of it, my lord, only on the shara, unclaimed, my lord, the court proceeded to the fact that, my lord, they have been served with the notice, and therefore I was placed ex parte, my lord.
Where is your application?
Application is filed at Annexure. Let me kindly see Annexure. F, my lord, page 94, my lord. Got it, my lord.
What have you stated in the affidavit?
My lord, I have stated, my lord, at that point of time, the address which I have mentioned in the plaint was not at all residing in that address. I was not residing at that place. Therefore, I could not receive the notice from the court. Para 3, my lord, page 96.
You have not stated what are you doing, whether you are working,
Please, ma'am.
where, in which address you are shifted.
My lord, in the petition, my lord.
Simply one sentence aste. I
Let
was
me
not
tell you.
residing there.
My lord, because my lord, in the very plaintiff petition copy itself has been produced before the court. The address has been shown in the address, present address. My lord.
What have you said? Which is your address?
You will me kindly appreciate, my lord, the address which I have mentioned.
No
in the
details have
petition.
you were given in the affidavit.
My lord, I will file an affidavit, additional affidavit backup. So otherwise, my lord, the purpose.
Respondents. The petitioner is also permitted to serve a copy of the writ petition along with annexures on the learned counsels representing the respondent before the trial court.
Please, my lord. No, my lord, the matter is posted. My lord, matter is posted for cross examination.
Yen madadre, you don't state anything. You simply file an application. I was not there in that address. Ashte mugdaiti.
My lord,
Kind of a content.
I have produced the order sheet itself.
Release this matter on
Yes.
22nd of August.
Please, my lord. Great.
I appeal. Petition, my lord. Suit for specific performance of agreement to sell. My lord, in the said suit on 21/2022, my lord, the London trial court has directed to plaintiff to deposit 1 crore balance sale consideration amount to the bank. That order has been challenged before this court in page number 82.
You are the defendant.
I am the defendant. Page number 80.
Page number
82. I files an application order 16/14 seeking produce the certain documents which have been fixed deposit in view of the order passed by this court. Page number 82 and WP number 23707 of 22. During the pendency of this suit, the plaintiff counsel has made an undertake to have already deposited the 1 crore amount is not to disperse. Please, my lord, kindly see page number 82. Either the petition has been disposed. The petitioner is directed not to withdraw the fixed deposit referred in the annexure M issued in the Indian Bank, Benson Town, Bangalore till the period of 6 months from today. Thereafter, my lord, after passing of the order, the plaintiff has not furnished any of the documents to fixed deposit in the said bank as undertaken before this court. Therefore, I filed an application order 16/14 seeking directed to produce the fixed deposit statement details. In the said petition, we have produced the fixed deposit statement during the year 2021-22. The petition was disposed on January 2024. As on the date of the disposal of the petition, it has not produced single.
Who filed an application?
I filed an application.
Ah,
That application came to be rejected by the level. But the documents were, I am not stay for further proceedings, only for issues.
to direct the manager, Indian Bank, to produce a
Fixed deposit statement.
statement.
Yes.
Which is the impugned order?
The impugned order is annexure, page number 12, annexure A.
Yes,
The reasoning given by page number 16,
yes,
paragraph number 7.
yes.
The report revealed that on 21/2023, the court is directed to defendant to deposit the balance sale consideration amount of rupees 1 crore in any national bank for a period of 1 year and to produce fixed deposit certificate. Thereafter, the application was filed by the plaintiff seeking order to recall. That order can be rejected. Thereafter, later that order was challenged before this honorable court in WP number 23707 of 2022. That is page number 82.
Yes.
The copy of the order of the Honorable High Court of Karnataka has produced before this court as per the order. The plaintiff has informed the Honorable High Court of Karnataka she has to deposit sum of rupees 1 crore FD in Indian Bank, Benson Town, Bangalore, and she undertakes that she will not withdraw the FD amount till the disposal of the suit. The relevant portion is extracted below. In the writ petition shows that financial capacity also shows. Please.
Next.
Next, my lord, with the similar observation, the Honorable High Court has directed to plaintiff not to withdraw the FD amount till disposal of the suit. While filing of the application, the defendant has specifically prayed that fixed deposits pertaining to the plaintiff in their bank with account details. Along with the application, the plaintiff has furnished copy of the details which are the amount of for different value is kept in deposit in the name of the plaintiff. Moreover, the very plaintiff has undertaken before this honorable court, she will not withdraw the deposited amount of rupees. Please.
Along with the application,
He furnished the
It has
copy of
published.
details, which is of the year 2021-22. He has produced the fixed deposit, date of the disposal of the now 2024 January ವರ್ಗೂ ಅಲ್ಲಿ ಅಕೌಂಟ್ ಇದೆಯಲ್ವ ಅಂತ ಗೊತ್ತಿಲ್ಲ. How 2021-22 the fixed deposit ಇದೆ ಅಂತ ಕೊಟ್ಬಿಟ್ಟು ಕೋರ್ಟ್ಗೆ the undertaken has been given, the writ petition kept to be disposed. Now 2024 this honorable court has disposed the writ petition given undertaken by the counsel for the plaintiff. Thereafterward, he has not produced single documents before the trial court having the fixed deposit in view of the order of this court.
perfect. When was that order passed by this court?
Well, this court on January 23rd January 2024. Page number 82.
The matter may be at the final stages now,
No,
because there is a direction within 6 months disposal.
ಆಗಿಲ್ಲ ಅಲ್ಲಿ ಬರೀ ಎವಿಡೆನ್ಸ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿದೆ. Only PW ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ is
Notice to the respondent.
not
Petitioner is also permitted to serve a copy of the writ petition along with annexures on the learned counsel representing the respondent before the trial. Full stop. Next para. Release this matter on 21st of August.
Please.
Please survey a copy, let them come before the court.
Serial number 8, G.S. Prasanna Kumar. G.S. Prasanna Kumar, serial number 8.
Matter is called out. There is no representation for the petitioner. Release this matter. On 14th of August.
Serial number 9. Kaleshappa case.
My lord, 2 weeks time, Your Honor, objection, Cavitor, husband number 1.
Why are you asking for password?
Senior counsel engage ಮಾಡಿ.
Huh?
Senior counsel engage in the 19th quarter is coming.
Objection, 2 weeks time, Your Honor.
Password.
Cavitor, husband number 1.
KV ಹಾಕದ್ಮೇಲೆ ಅದು ಹೆಂಗ್ರಿ ನೀವು ask for time to file objections. Yes.
Serial number 10. Suresh Babu Raj D.
Hearing for the petitioner. Here the petitioner is filed writ of mandamus directing the learned 20 additional CC and session judge to dispose the IA number 2 of 23 Mellon. The IA is filed on 31/7/23. This is the suit for ejectment. And there are 20 lakhs rent arrears are there, Mellon. They are not neither ejecting they are not vacating the premises, nor they are paying the rent.
What is that IA you have filed?
IA here, IA we filed in OS 2484, IA number 2, that is annexure C.
2 of 2023.
Yes, ma'am.
What is that IA for?
IA for this one, paying the arrears of the rent, 20 lakh. And the ejectment suit. The defendant in that suit, they are threatening me, they are threatening the petitioner that they have the political influence and all. You cannot do anything. You cannot vacate us from the premises. The rental agreement was entered the rental
IA
agreement
number
was
2 of 2000?
suit filed on 2022.
ಅಲ್ಲ ಮತ್ತೆ ಯಾವ್ದಮ್ಮ IA ನೀವು ಹಾಕಿರೋದು?
IA 2 of 23, annexure C.
Annexure C.
Yeah. Page number 21. As of today, 20 lakhs arrears are there. The premises, they are not vacating. That is the only income source for me to run my family. At least if they'll vacate the premises, I can start my.
Furnished the rental agreement?
Yes, please. Yes.
Copy
It is
of the rental
annexure A.
agreement?
Yes, annexure A. Yes.
Perfect.
Can we fix the time frame to dispose the suit itself, Mela, so that I can run my own business and take care of my family.
Having regard to the prayer made in the petition seeking certain directions to the 20th additional city civil and session judge, Bengaluru, bracketally CH number 32, to dispose of an interlocutory application filed at the hands of the plaintiff, this court is of the considered opinion that there is no need to issue notice to the respondents. We'll stop. Next paragraph. The petitioner, plaintiff, has filed a suit for ejectment.
Yes, ma'am.
And an application was filed in IA number 2 of 2023 on 31/7/2023, seeking direction to the defendant to deposit the arrears of rent as agreed in terms of the rental agreement dated 1/12/2016, which has been produced along with the plaint.
Yes, annexure A.
Full stop. Learned counsel submits that no orders have been passed on the said application And therefore, the petitioner is before this court seeking direction to the court, trial court, to consider and dispose of the application within a time frame. Full stop. Next para. Having regard to the innocuous prayer made in the writ petition, comma, this court deems it fit to direct the so and so court CCH 32 to consider and dispose of IA number 2 of 2023 as expeditiously as possible and at any rate. Yeah, the next date, hearing date, no?
14/8.
Huh?
14/8.
14/8.
8. Yes, I filed this one in July
Within a
1st.
period of 4 weeks. From 14th of August 2023, which is the next date of hearing before the trial court.
Yes.
Full stop. Ordered accordingly.
Serial number 11, S.V. Prakash.
Plaintiff's petition. The suit is for partition. But among brothers, the defendants 1 and 2 and plaintiff are brothers. And third defendant is wife of second defendant. My lord, the plaintiff and the defendants 1 and 2, father is Kodaya and grandfather is Dulaya. But he instructed accordingly to the advocate, my lord, who acted for him, my lord, while filing plaint. But unfortunately, my lord, the name of father of the plaintiff and also the defendant shown as Dulaya alias Kodaya, that is apparently wrong. Then, my lord, the plaintiff having become aware of this mistake, informed the advocate who made application seeking amendment to correct this mistake crept in, my lord, in the cast title of the plaint. But unfortunately, my lord, that advocate withdrew it without my consent. Then, my lord, when I questioned him, he said, my lord, he somehow mistakenly he withdrew it. And he, my lord, retired. And I engaged another counsel. My lord, at least, my lord, that order should have been, my lord, an application should have been made to recall, my lord, that order. Instead, my lord, a separate application was filed seeking amendment. But it was disclosed that earlier application was filed, it was withdrawn. But then, my lord, court said once I withdraw the application, but I am not entitled to, my lord, maintain. I filed writ petition also, my lord, similarly, my lord, dismissed. My lord, in fact, my lord, I produced document, any number. What happened is,
Support an order.
no, that's all right, but that has come to an end. My lord, I cannot, what happened is, I produced certain document along with the earlier petition that were not produced. That is to establish that, my lord, his father is Kodaya and defendants 1 and 2 are his brothers. My lord, that application also, my lord, dismissed on the ground that, my lord, the earlier order and that I have not explained why I could not produce. My lord, there is a suit for partition. A suit for partition. My lord, of course, my lord, I can't say that, my lord.
You filed an application.
My lord, I made 3 applications. One
For
is
production of additional document.
additional document. And the other 2 applications for condonation of, my lord, delay for late production and, my lord, reopening of my, precisely, my lord, my application is to reopen my evidence, which is posted for argument. And
why didn't you produce the documents at the time of evidence?
I produced, but in addition to that, certain other documents which would clear
the other documents.
Other document, your lordship kindly see the voter list and, my lord, my Aadhaar card.
What are the documents that you produced earlier?
Earlier, my lord, the documents were produced. It is not that.
Documents.
Not that details I don't have. My lord, your lordship have it, my lord. Friday, I let me, my lord, come up with what are the, I understand, my lord, certainly, my lord, I should have.
Application dismiss
Yes,
yes. You could have tendered documents to show that the name of your father is so and so, and merely because a mistake was committed in the plaint, that cannot be held against you. You should have produced the documents at the time of evidence.
my lord, my evidence is over and the poster.
ಅವಾಗ ಯಾಕೆ produce
ಅಲ್ಲ,
ಮಾಡ್ಲಿಲ್ಲ?
no, my lord, furnished the details. What are the documents I have produced already?
Have, in the written statement at the earliest point of time, have they denied the relationship?
My lord, they denied me. They denied, my lord.
ಹೌದಾ?
Page 26, annexure
There
B.
is something
My
there.
lord, what denied is what they say, my lord, not in they said that their father name is not Dulaya, their grandfather name is Dulaya, father name is Kodaya. My lord, I am their brother and my lord, all the three, our father, my lord, sold the property and under PTCL Act, he made application, he got the land. During pendency of that, he died. All the three were shown as, my lord, LRs. And in voter list, my father name is shown as Kodaya. In my
Why
Aadhaar
didn't
card,
you produce all these documents at the time of evidence?
my lord, there is a proceedings before Tahsildar, RRT.
Ah.
There also, my lord, I was there along with them.
Produce ಮಾಡ್ಲಿಲ್ಲ ಈ documents.
ಅಲ್ಲ, ಅದ್ ಮಾಡಿದ್ದಾರೆ. I am not in a.
Then if it is there, it's
No,
enough then.
no, I am not in a position to bring to your Ashok notice what are the documents already produced and what are the documents now sought to be produced. For which, my lord,
Judgment post ಮಾಡ್ಕೊಂಡಿದ್ದಾರಲ್ಲ.
is a judgment is ಆಗಿಲ್ಲ.
That is what is said in the impugned order.
ಇಲ್ಲ, judgment ಗೆ ಹೋಗಿಲ್ಲ. Argument ಅಂತೆ.
The
Page
present
60.
application has been
Page
filed at the stage of arguments.
ಅಲ್ಲ, ಇಲ್ಲಿ page 61 ಅಲ್ಲಿ
ಹಾ.
posted for argument, my lord. Now it is
ಏನಪ್ಪ?
ಅಲ್ಲ, ಫ್ರೈಡೆಗೆ let me try, my lord. once.
At the request of learned counsel for petitioner, release this matter on 9th of August for preliminary hearing.
Published.
12, Basavanna.
Here for the petitioner. The petitioner, the plaintiff before the trial court. They have filed a suit for declaration and recovery of position against the state. The state has not appeared before the court, place ex parte. Thereof evidence are recorded, documents are marked. In meanwhile, the SPPR filed a memo as per annexure F, my lord, page 36. Stating that in view of the Karnataka Land Grabbing Prohibition Act, Section 10A is bar to
Suit
continue
cannot
this
be
suit,
filed.
please.
Ah.
Based on that, we filed the objection. Annexure F. The court has passed the order.
Yes.
Transferring the file to special court.
Yes.
Which is annexure A, my lord, page 12. The relevant order, my lord, page 15. This lordship, the division of this honorable court, my lord, page number 62.
Ilri,
Annexure H, my lord.
learned AGA is directed to take notice for all the respondents. Learned counsel for petitioners is directed to serve 2 sets of copies of the petition along with annexures on the learned AGA.
In meanwhile,
What is this matter?
my lord, in meanwhile, interim statement.
If the matter is allowed, the matter will be restored.
Last
So
occasion,
stay ಮಾಡಿ ಏನ್ ಪ್ರಯೋಜನ?
item number 71
Same.
and 72 is the same. One date may be
Release this matter on
72.
14th of August.
published.
ಯಾವುದು?
72 item number 1 and 2, last.
Same,
Please, madam. All three is the same.
72 ಅಲ್ಲೂ ಸೇಮ್.
Please,
ಅದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿದೆಯಾ ಆಗ್ಲೇ?
notice
ಆಗಿದೆ.
ಇಲ್ಲಿ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂತ ಹೇಳಿದ್ರು, ಆರ್ಡರ್ ಆಗಿಲ್ಲ.
ಇದ್ರಲ್ಲಿ ಆಗ್ಲೇ ನೋಟಿಸ್ ಆಗಿದೆ.
ಅಲ್ಲ, ಯಾವ್ದ್ರಲ್ಲೂ ಆಗಿರ್ಲಿಲ್ಲ.
72 ಅಲ್ಲಿ
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂತ ಹೇಳಿದ್ರು, ಅಷ್ಟಕ್ಕೆ ಬಿಗ್ ರೂಪ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಬೋತ್ ಸೇಮ್ ನೋಟಿಸ್ ಮಾಡು.
72 ಅಲ್ಲೂ ಸೇಮ್ ಮಾಡು.
ಐ ಫರ್ನಿಶ್ ದಿ ಕಾಪಿ.
Number 13. Abhinav Ramanandi.
Yesterday, my lords were pleased to dispose of 3 writ petitions.
Similar matters.
3 writ petitions yesterday,
yes.
my lord. Similar matter, my
ಯಾವ್ದು
lord.
ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್?
My lord, it is 19506 of 2024.
ಸಾಕು, ಒಂದ್ ಸಾಕು.
Please, my lord.
ಸೇಮ್ ಆರ್ಡರ್.
Same.
Same.
ನೆನ್ನೆ ಬಂದಿತ್ತು, ಆರ್ಡರ್ ಮಾಡಿದೀನಿ, ಸೇಮ್ ಆರ್ಡರ್.
Published.
Number 14, Nayak NR.
I'm not aware of the matter.
I beg to appear for petitioner, my lord. I have sought for amendment, my
You are
lord,
appearing
for
for whom?
partition suit.
ಒಂದ್ ನಿಮಿಷ ನಾಯಕ.
Serial number 13, sir.
ಯಾವ್ದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್?
Abhinav Ramanandi. Serial number 14, Nair.
Yes, Mr. Naik.
Naik.
Please, my lord, this is
Yes.
the case I have filed a partition suit. In the said partition suit, I have sought for amendment to incorporate some of the properties, my lord. Since the document you have not placed, therefore amendment application has been rejected. my lord.
2016 suit.
Yes, my lord.
2016 suit.
How those?
ನೀವು when did you
Evidence
file the
start.
application?
Evidence ಆಗಿದೆ ಸ್ವಾಮಿ. Evidence
ಮತ್ತೆ?
ಆದಾಗ some of the property left out during the.
You will have to convince the court that despite due diligence, you are not aware of these documents and therefore you have sought to place it now. Without
Document
explanation, it is not possible, sir.
because evidence has been led by me, my lord. Some of the properties left out,
Proviso
my
to
lord.
rule 17, you will have to fulfill.
Yes, my lord.
Therefore, if you don't make any such statement in the application, it is bound to be rejected.
The observation, my lord, no document has been placed, my lord.
Issue notice to the respondents. The petitioners are also permitted to serve copies of the writ petition along with annexures and the learned counsels representing the respondent before the trial.
Please.
Serial number 15, Balraj AC.
ಇದ್ರಲ್ಲ ಪಾಸ್ ಓವರ್
Serial number 16.
For the petitioner, my lords, annexure A is the impugned order, my lords. A money suit has been filed, my lords, by the respondent plaintiff, my lords, under the Commercial Courts Act. I am before my lords because, my lords, ex parte order, my lords, has been passed by the learned judge, my lords, exempting the plaintiff from complying section 12A. Being aggrieved by the same, my lords, I am before my lords. My lords will find the impugned order, my lords, at page number 17, my lords. There, my lords may kindly permit me to read paragraph 2, my lords. The plaintiff has filed the IA number 1 under section 12A1 of the Commercial Courts Act, praying to dispense with the filing of pre-institution mediation application before the DLSA by it. In support of the application, an affidavit of the authorized signatory of the plaintiff is filed, wherein he has contended that at the present plaintiff company has filed the interim application against the defendant for seeking interim relief against the defendant in respect of the petition scheduled property, and as such, he prays to dispense with the compliance of pre-institution mediation. In the second paragraph, peruse the records. On perusal of the records, it discloses that plaintiff has filed IA number 2 under section 151 of the Code of Civil Procedure, read with order 39 rule 10 of the CPC, and also filed IA number 3 under order so and so for the to pass an interim order against the defendant. Considering the above facts and looking to the relief sought for IA number 2 and 3 and looking to the provisions of section 12A1 of the Commercial Courts Act, I am of the opinion that at this stage, if permission is granted to the plaintiff for filing of the suit without institution of PIM application before the DSLA, certainly it would meet the ends of justice. My lords, if at all the interim order is seen, my lords, the learned judge, my lords, has come to the conclusion that the interim prayers have been sought by the plaintiff, my lords. For that reason, it has to be dispensed with. If at all, my lords, see section 12A of the Commercial Courts Act, my lords, the specifics of this section 12A says, my lords, when may I read? Section 12A, Chapter 3. A suit which does not contemplate any urgent interim relief under this Act shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation in accordance with such manner and procedure as may be prescribed by the rules made by the central
It does not contemplate any urgent interim.
urgent interim. My lords, the word specifically used, my lords, contemplation, urgent interim relief. 4 words, my lords, have been used.
Which does not.
Please.
Yes.
Now, my lords, I have to establish before my lords. In IA number 2 and 3, my lords, the plaintiff has not contemplated any urgent interim relief. If at all, my lords may kindly permit me to draw my lord's attention to page number 48, my lords, which is IA number 2, filed by the plaintiff before the trial court, which is filed, my lords, under order 39 rule 10, my lords. At page number 51, my lords will find at paragraph 9.
Please to issue direction to the defendant to furnish bank guarantee.
Please.
To the tune of rupees 20 crores.
Please.
Odd.
Please. at page number 51, my lords, at paragraph 9. At page number 51, paragraph 9. May I read? I state that the plaintiff has invested huge amount and spent huge amount. The defendant is trying to protract the matter without clearing the bill amount. Hence, it is necessary to direct the defendant to furnish bank guarantee. This is the only reason they have assigned. Now, my lords may kindly see IA number 3, my lords, at page number 53, which is filed, my lords, for attaching the property of the defendant. Now, my lords may kindly see para 8, my lords, at page number 56, wherein, my lords, the reason has been assigned for the IA, my lords. I state that the defendant Shilpa Biologicals Private Limited is the owner of the scheduled property situated at plot number so and so. The plaintiff is having merits in the above case. He has got very good chance of success. If the Honorable Court deems decrease the suit, the defendant may avoid payment as well as he may avoid fruits of the decree. Hence, the attachment of the scheduled property before the passing judgment is necessary. My lords, the only reasons which the plaintiff has assigned, my lords, are that he has invested huge amount of money and there is a possibility that he may, the decree may be passed in his favor. If at all I may be permitted, my lords, to produce certain citations, my lords, wherein, my lords, the Honorable Supreme Court has considered all these aspects, my lords, yes, and has mentioned that section 12A, my lords, is the mandatory provision, and this provision is a toddler and needs to be expanded, my lords, by the courts of law. My lords, first judgment, my lords, is Yamini Manohar. It is in 2024 judgment, my lords. If I may draw my lord's attention to paragraph 5 at page number 5. Please. Section 12A of the Commercial Courts Act does not contemplate leave of the court, as is clear from the language and words used therein. Nor does the provision necessarily require an application seeking exemption. An application seeking waiver on account of the urgent interim relief, setting out grounds and reasons may allay a challenge and assist the court. But in the absence of any statutory mandate or rules made by the central government, an application per se is not conditioned under Section 12A of the Commercial Courts Act. Pleadings on record and oral submissions would be sufficient. So, my lords, under Section 12A, there is no scope for the plaintiff, my lords, even to file an application seeking exemption. If at all, my lords, he has contemplated any urgent interim relief, the court, my lords, is obligated to, my lords, allow him to continue, my lords. In the absence of it, my lords, there is no scope, jurisdiction for the trial court also, my lords, to do it. Now, my lords, may kindly turn to paragraph 11, my lords, at page number 7. Yes. Having stated so, it is difficult to agree with the proposition that the plaintiff has the absolute choice and right to paralyze Section 12A of the Commercial Courts Act by making prayer for urgent interim relief. The camouflage and the guise to bypass the statutory mandate of pre-litigation mediation should be checked when deception, falsity is apparent or established. The proposition that the commercial courts do have a role, albeit a limited one, should be accepted. Otherwise, it would be up to the plaintiff alone to decide whether to resort to the procedure under Section 12A of the CC Act. An absolute and unfettered right approach is not justified in the pre-institution mediation under Section 12A of the CC Act.
No, it's all right, but after you entered appearance,
Please.
you did not insist that the matter is to be sent to the DLSA?
Now, my lords, what has happened is, there is no scope for that. Only, my lords, DLSA, my lords, Section 12A says, my lords, pre-institution mediation. Once the suit is filed, my lords, that pre-institution mediation stage is over. Now, my lords, Section 12A says, my lords, before filing of the suit, a mediation process should be initiated. The objects of that act, my lords, has been beautifully explained by the Honorable Supreme Court, my lords, in Patel automation case. If I may draw my lords' attention to paragraph 83 of the third judgment, my lords will find it.
Yes.
At page number 107. My lords, I may be permitted to read 4 paragraphs of this judgment, my lords, which are very relevant.
Yes.
107, my lords, 83.
Yes.
We may proceed on the basis that if a suit is brought without complying with Section 12A, where no urgent interim relief is sought, may not in one sense affect the legal right of the defendant. But this argument overlooks the larger picture, which is the real object of the law. This object is not to be viewed narrowly with a reference to the impact of the parties alone. This is apart from also remembering that if the parties were to exhaust the mediation under Section 12A, the opposite side may be, if mediation is successful, saved from the ordeal of a proceeding in the court. which undoubtedly would entail cost, whereas the mediation cost, as we have noticed, is minimal. And what is more, a one-time affair, and still further, to be shared equally between the parties. Each time the plaintiff is compelled to go in for mediation under Section 12A, there is a ray of hope that the matter may be settled. The chief advantage and highlight of mediation is that it is a win-win for all sides. If the mediation is successful, therefore, it cannot in one sense be argued that no legal right of the defendant is infracted. Further, on the same logic, Section 81 CPC and Section 69 of the Partnership Act would not be mandatory. This is, however, not the case. 84 minutes. One of the arguments of so-and-so is that if the plaintiff is rejected under Order 7 Rule 11, the plaintiff would be saddled with the deprivation of the court fee paid. He would contend that this aspect may be considered when the court decides the question as to whether the provision is mandatory or not. Whenever a plaintiff is rejected on the ground that the suit is barred under any law, this consequence is inevitable. Now, my lords, the court has said, my lords, in the event the pre-mediation process is not followed, I am entitled to file 711 application. Now, my lords, may kindly see in this matter, my lords, ex parte order has been passed, my lords. If at all I file 711, it would amount to reviewing the same order passed by the trial judgment, which I cannot do. Now, my lords, may kindly turn to paragraph 91, my lords, at page number 111.
Yes.
Section 12A of the Commercial Courts Act provides for mediation. This is a provision which was inserted as per the amending act so-and-so enacted in the year 2018, and it came into force with effect from 3/5/2018. By the said amendment, in fact, Chapter 3A was inserted and Section 12A is the sole section in the said chapter. A plain reading of Section 12A makes the following position clear. Section 91(1). The lawgiver has declared that if a suit under the Act does not contemplate any urgent interim relief, then it cannot be instituted unless the plaintiff seeks pre-litigation mediation. The pre-litigation mediation is to be done in the manner, procedure which is to be prescribed by the central government. The pre-litigation mediation is to be completed within a period of 3 months from the date of the application made by the plaintiff under subsection 1. Now, my lords, may kindly see 91(4), my lords, at page number 112. Which has spread over 5 subsections. This standalone section in Chapter 3(1), no doubt supported by the rules in our view, substantially manifests a definitive scheme to effectively deal with the perceived urgent problem of acute clogging of the justice delivery system, which had to be decongested. Section 12A cannot be perceived as merely intended to reach quicker justice, and what is more, on terms which are mutually acceptable to the parties concerned. Even more importantly, it was to produce a vital and significant effect on the very interest of the nation. We have perused the statement of objections reasons to attract foreign capital by enhancing its rather low standard in the ease of doing business. It was and is still necessary to showcase an efficient and quick justice delivery system in commercial matters. In fact, India, which was ranked at 142 out of 189 countries in the ease of doing business index, in 2015, climbed up to only 130 in the year 2016. By 2020, India stood at 63rd position. Number of the very object is, Malos, to improve the ease of doing business in the nation, Malos. Now, Malos, may kindly see paragraph 19.
Purple. Issue notice to the respondent. The petitioner is also permitted to serve. Some other petitions had come up in respect to the same parties.
No, Malos. This is the first writ petition, Malos, which has been filed. Malos, suit was filed, Malos, in April 24, Malos. The last transaction, Malos, happened in May 23. It was cancelled in May 23, Malos.
Shilpa Biologicals.
Malos, this is the only petition I am aware of, Malos.
I think come up last week. Issue notice to the respondent. Learned counsel for the petitioner. The petitioner is also permitted to serve copies of the writ petition along with annexures on the learned counsel representing the respondent before the trial. Full stop. Next paragraph. Learned counsel for the petitioner submits that the impugned order at annexure A has been passed ex parte at the instance of the respondent plaintiff. on an interlocutory application filed at the hands of the plaintiff. Where is the express order?
My lord, sir, Tanishar A. But page number 24. Plus it is issue emergent notice on IA number 2 and 3 and suit summons to the defendant. However, my lords, in paragraph in page number 18, my lords, it is mentioned that IA 1 filed by the plaintiff under section so and so commercial court is hereby allowed. Page number 18, my lords, at in paragraph 2, my lords, at the foot of the paragraph 2, it is mentioned, my lords, that IA has been allowed.
Granting permission to the plaintiff to file the suit without instituting an application for pre-litigation mediation before the DLSA, District Legal Services Authority. Full stop. Next para. Learned Counsel submits that in a recent decision of the Honorable Supreme Court, in the case of Yamini Manohar versus TKD Kirti, bracket 2024, close 5 SCC 815, the Honorable Supreme Court has held the plaintiff does not have an absolute choice and right to paralyze section 12 capital A of the Commercial Courts Act by making a prayer for urgent interim relief. Stop. It has been held that a camouflage and guise to bypass the statutory mandate of pre-litigation mediation should be checked when deception and falsity is apparent or established. Full stop. In another decision, in the case of Patil Automation Private Limited and others versus Rakeja Engineers Private Limited, bracket 2022, close 10 SCC, page 1. The Apex Court has elaborately dealt with the requirement, the mandatory requirement of the plaintiff going through the pre-litigation mediation in terms of section 12 capital A has been inserted after amending the statute with effect from 3/5/2018. Full stop. It has been held that section 12A cannot be perceived as merely intended to reach quicker justice, and what is more, on terms, which are mutually acceptable to the parties concerned. Full stop. The Supreme Court has reiterated the need for the parties to undergo pre-litigation mediation. Full stop. Moreover, it is submitted that the two applications filed by the plaintiff are merely to issue directions to the defendant to furnish bank guarantee and
attachment of property.
and to pass an order of attachment to the immovable properties belonging to the defendant. Please. Full stop. On a plain reading of the affidavit filed along with the applications, it is clear that the plaintiff has not made out any grave urgency, and therefore the commercial court could not have passed the impugned order. Full stop. Next paragraph. Consequently, there shall be an interim order of stay of the impugned order dated 27/4/2024, passed by the 11th Additional District and Session Judge, Bangalore Rural District, on IA number 1 in commercial OS number 13 of 2024 till the next date of hearing. Great.
Number 17, Vivek Kolla.
For the caveat.
ಆಗ್ತೀವಿ ರೆಡಿ ಇದೆ
ಗೊತ್ತಿಲ್ಲ ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ಮೇಲೆ ಮತ್ತೆ ನೀವು
ಇಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನೋ ರೆಡಿ ಇದೆ ನಂದು
ಗೊತ್ತಿಲ್ಲ ನಮ್ಮ ಚಿತ್ತ ಯಾಕಂದ್ರೆ ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕ್ತೀನಿ ಟೈಮ್ ತಗೊಂಡ್ರಿ
ಅಲ್ಲಲ್ಲ ನನ್ನ ಹೆಸರು ತೋರಿಸಿಲ್ಲ ಅಂತ ಟೈಮ್ ತಗೊಂಡು I filed a caveat.
Your objections are ready.
My objections are ready. But
then you give a copy to the other side.
I will give a
Let them also go through the objections and we will hear you.
Even
Senate counsel for the respondent submits that the statement of objections are ready. Full stop. Please serve a copy. A copy of the same is served on the learned counsel for the petitioners. Full stop. Release this matter on 12th of August, Monday. Please. Yes.
18, Abu Narana PS.
Therefore, the petitioner, my lord. In an arbitration proceeding, the petitioner has suffered an award, and that is being challenged before the district court at Chikkalapur. During the course of the memorandum of appeal, certain grounds are not taken at the time of filing of the appeal. I have come on record recently. I felt the necessity to introduce and add 5 additional grounds of appeal in the memorandum of appeal. I filed an application for amendment. That amendment application is dismissed by the district court.
Yes.
So therefore, this writ petition is filed. I am not introducing any new grounds. And I do not propose to lead any further evidence on these additional grounds. They're only for the sake of convenience and to show that, establish that those grounds are taken in the memorandum of appeal. So on this point, my lord,
Where is your application?
application is annexure F, my lord, at page 48.
Forty-eight is the order sheet.
I'm sorry, my
Your
lord,
application
page
is
43, 43.
43.
43.
Yes. What is the reasoning? What is the reasoning in the order?
Is that we find it at page 51, my lord.
Yes.
Peruse the application and the decision cited by the legal counsel for the petitioner in it can be noticed that the present application is filed for seeking additional grounds, such as the arbitrated, all the grounds are set out, my lord.
Yes.
And at the last paragraph, considering the reasons mentioned in the application and the material on record, it can be noticed that the petitioner has raised 12 grounds in the original petition, and out of which the petitioner has raised the grounds pertaining to the execution of the documents, and also the arbitrator wrongly understanding the exhibits and findings of the arbitrator is not sustainable, and also refers to the proceedings taken place before the arbitrator on 24/5/2015, and now the present application is seeking for the ground in respect of the documents which the petitioner has already taken in its original petition. And regard to the provision of section 16 and 20 of the Specific Relief Act is concerned, the same is the question of law, and the petitioner has questioned the entire arbitration proceedings in the original petition. And the same is also found in the grounds at 8.1 to 8.12 of the present amendment is not necessary and filed only to protract the legal proceedings. Decision cited by the learned counsel for the petitioner is pertaining to the amendment, which is necessary for disposing the real controversy between the parties. This court has already observed that the grounds is already included in the original petition, and now the petitioner is only invoking the provision as section 16 and 20 of the Specific Relief Act, and mere inclusion of provision is not necessary, as the court can look into the question of law while deciding the matter on merit. There is no ground made out for allowing the amendment application.
What is wrong with the order?
So these grounds,
You have already been given the permission to urge this provisions of section 16 and 20.
Apart from
that is all you wanted. The other grounds are already there.
The specific grounds are not there, my lord.
They have pointed also to the paragraph, sir. Issue notice to the respondent.
Caveator
is
is
also
there,
permitted to serve a copy of the petition. along with
Caveator,
annexures
my
of
lord, caveator is already on
the
record.
learned, huh?
Caveator is already in record. In fact, there is an order passed by this honorable court on the last date of hearing on 31/7. It has not appeared.
Oh, all right. Issue notice to the respondent. Yes.
And matter is posted tomorrow, my lord.
No, sir.
Number 19,
Yes.
Sunil Kumar SP.
Matter is called out. There is no representation for the petitioner. Release this matter on 14th of August.
Number 20, Vinay N.
AP for the petitioner.
Not suit not for possession. But I am a tenant. But the
Stamp duty.
stamp duty and registration.
Huh.
The lease it is at page 23. Relevant clause is not clause 3.
But the defendant.
I am the defendant. Page 25 not is the relevant clause, clause 3. But it says that the lease will be for a period of 3 years. My lords have it, no?
Yes.
3 years from 1st of March 2017 with annual escalation as per agreement. The lease will be extended for a further period of 2 years. Not in all 5 years, so it requires registration. But we had filed an application not at page 44 under section 33 not of the Act, Stamp Act. Will also please turn to page 45, para 3. But we have pointed out that the plaintiff has produced a copy of the lease agreement, para 3, dated so and so, which is not registered and is not duly stamped. Hence, the agreement is liable to be impounded. Now, my lord, the trial court not passes an order, but at page 50 on 28/5/2024, relevant page is page 51. On perusal of the file, it is noted that the suit is filed for ejectment and the suit is valued for 12 months rent. Accordingly, court fees paid, thereupon held court fees sufficient. Matter passed over plaintiff evidence. Matter called out. Plaintiff counsel has filed IA number 8 seeking leave to produce documents. The reason stated IA number so and so allowed. But then not in chief examination PW1, one original lease deed was produced, which has been objected on the ground it is insufficiently stamped. Therefore, matter should be now be posted for hearing on question of stamp duty. And since question of stamp duty is being heard, IA number 7 is rendered superfluous and accordingly disposed of. For trial court note, there are two things that we mentioned. Of course, the provision is section 33.
For hearing on stamp duty.
Hearing on stamp duty. Then note 5 on the next page, page 52. On 5/6/2024, note the court says, note counsel for the plaintiff has filed IA number 9, producing document the said IA is allowed, keeping open question of admissibility and relevancy of documents produced. IA so and so examined, note 2 documents are marked. Then note page 53. Please turn to note page.
Third counsel for plaintiff on stamp duty payable on lease deed dated so and so. For hearing defendant.
But then note page 54 is the order. Note, I will not trouble reading the entire order. I'll straight away take notes to the operative portion at page 57. Note, the learned judge relies upon the judgment of this honorable court at para 8. And at page 57, in light of the above law laid down by the Honorable High Court of Karnataka, it is clear that the 5 years after execution of document, the state loses its right to recover the short.
Please read this extracted portion of the.
Yes, Lord, I read that. Learned counsel of the plaintiff rightly read upon the ruling of the Honorable High Court of Karnataka in
extracted portion.
How? Thus, the statute itself prescribes a time limit of 5 years for the state to recover stamp duty which is not levied or short levied. It would therefore follow as a natural consequence as an instrument which was insufficiently stamped 5 years before. It would.
Yes, I've read this. Someone else had on this one.
I can place the judgment on. In fact, what the learned judge did not notice is that there is a division bench judgment of this honorable court in Digambar Varati.
Yes.
But the court said if a document requires registration, then this section 46A will not come to his rescue. But that is not the judgment of this honorable court.
Yes. Then the very provision for impounding documents would be rendered.
Yes, my lord, sir, absolutely. But according to me, my lord, 46A, my lord, stands on a complete different footing. And 33 and 34, my lord, it's an obligation of the court not to impound.
Yes.
But can I request, my lord, so please turn to my lord, para 69, my lord. Last but one page, my lord. But para 68, my lord, the court refers to section 46A as well. But I'll just not read the last sentence in para 68 and then not continue para 69. But it says therefore the bar of limitation prescribed under section 46A is applicable. The proceedings under section 46A is to recover the stamp duty is clearly barred by limitation. However, under the scheme of the Act, the said benefit could be extended only to such instruments which are not compulsory registrable. If an instrument which is not compulsory registrable, but on which a person relies upon to prove his title, and it is to be rendered in evidence in a court of law. Unless proper stamp duty and penalty payable thereon, it is inadmissible. Therefore, the said document would be of no use to enforce a right of a person.
If the documents require registration.
Yes, Lord. However, not para 69, the first sentence itself says, under the scheme of the act, the benefit could be extended only to such instruments which are not compulsory registrable. Here, Lord, the document is admittedly compulsory registrable under section 17. Therefore, Lord, the judgment which is relied upon by the trial judge, Lord, not apply, Lord, in the matter. And Lord, with due respect, Lord, 46A, Lord, may require not some consideration.
Someone pointed out the similar orders were passed.
Yes, Lord.
Berkeley. Issue notice to the respondents. The petitioner is also permitted to serve copies of the petition along with annexures on the learned counsel representing the respondents before the trial. We'll stop. Next para. Learned counsel for the petitioner submits that the commercial court has passed the impugned order declining to impound the document, only based on a decision of this court in the case of Anil versus Babu in WP number 112448 of 2017, rendered at the Dharwad bench on 15/12/2022. Full stop. However, what has not been noticed is that a division bench of this court in the case of Digambar Vati and others versus district registrar from a Bangalore urban district and another reported in ILR 2013 Karnataka 2099 has held that the benefit flowing under section 46 capital A of the Stamp Act could be extended only to such instruments which are not compulsorily registrable. Full stop. However, in the present case, the document is compulsorily registrable, and this aspect of the matter has not been noticed by the trial court. Full stop. Next para. Consequently, there shall be an ad interim order stay of the impugned order dated 11/6/2024 and 11/6/2024 and all further proceedings in commercial OS number 1575 of 2022 on the file of additional series 58.
58. 58.
88.
Or 84.
83.
83, quotal number 84. CCH 84.
83. 83rd additional city civil and session judge, Bengaluru. Bracketly CH 84, till the next date of hearing.
Wait.
21. Ravi Shankara.
Lord's petitioner's application for grant of ex parte order of injunction
ex parte order of injunction had not been granted, my lord. That is why we are in this petition before this honorable court. Lord, the matter pertains to survey number 1. Not in Ramnagar district, my lord, of Lakshmi Sagara village. Lord, I am the purchaser of the northern portion of survey number 1, measuring 4 acre 26 guntas in Lakshmi Sagara village in Ramnagar. Challenging district. which order? Annexure A. Yes, my lord. On grant of ex parte order of injunction. Lord, I am owner of the northern portion. The defendant is claiming to be owner of the southern portion, my lord.
This is a order passed by the principal civil judge
Yes, my lord.
and JMFC.
Yes, my lord.
Unit
Then I-
division.
Rejecting my
You have
request.
appeal remedy.
No, my lord. They have not concluded the IA. Only ex parte order has been rejected. It's
Ah.
an order under 39 Rule 3. So therefore, a writ petition will lie. my lord. It's not that the other side had appeared and IA1 was finally decided under 1 and 2 of 39.
Ah.
It does not come under order 43 Rule 1R, my lord. So therefore,
We will see.
therefore a writ will lie, my lord. Lords may kindly see
Notice to the
page,
respondents.
Lord,
The petitioner is also permitted to serve copies of the writ petition along with annexures on the learned counsel.
ಇಲ್ಲ ನೋಟಿಸೇ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ ಅಲ್ಲಿ.
Issue notice to the respondents. Release this matter
My lord, kindly, my lord,
22nd of August.
there is an emergency, my lord. They have broken. Let me just point out to certain photographs, my lord. They have broken my compound wall, my lord.
No, sir.
If they encroach
I've
my
given a date,
property,
please come on that
the
date.
suit itself will become infructuous. my lord.
Yes.
My suit will become infructuous, my lord.
No,
Thereafter, I'll have to
no.
change the nature of the suit and seek for possession if
Let us see.
encroach
Yes.
my property, my lord.
Ajit Kashyap, TN.
I've given a date, you please come on that date. Sir. Yes.
Ajit Kashyap, TN.
Application under 6 Rule 17 seeking amendment of the plate has been rejected.
Ah.
My lord, what was sought, the amendment that was sought, my lord, was change of the survey number. My lord, the survey number This Pahani,
21 guntas.
21 guntas. Next Pahani is there, my lord. The Pahani that I have given to my lord, next Pahani is there where it is 21 guntas. ಮೂರು ಪೋರ್ಷನ್ ಆಗಿದೆ ಅದು. ಇದರಲ್ಲಿ 33 ಗುಂಟೆ ಇದೆ, ನೆಕ್ಸ್ಟ್ ಪಾಣಿಯಲ್ಲಿ 21 ಗುಂಟೆ ಇದೆ, ಇದರಲ್ಲೂ 23 ಗುಂಟೆ.
Berkeley. Issue notice to the respondent. The petitioner is also permitted to serve copies of the writ petition along with annexures on the learned counsel representing the respondents before the trial. Stop, next para. Learned counsel for the petitioner submits that the application filed by the petitioner plaintiff under Order 6 Rule 17 of the CPC has been dismissed on the ground that the plaintiff is intending to add a different survey number to the schedule, but the plaintiff has not produced any documents to prove his contention. Full stop. However, learned counsel submits that the Pahani copies of the Pahani at annexures E and E1 were in fact produced along with the application.
It was not produced. I have produced it before this. It was not produced before.
Submits that although it is true that the documents were not annexed along with the application, nevertheless, before this court, the petitioner has furnished the documents at annexures E and E1 to substantiate the contention of the petitioner. Stop. At annexure E1 is the computerized RTC of the year 2024-25, which shows that the petitioner is the owner and khatedar in respect of survey number 122/3B, measuring 23 guntas. Full stop. Learned counsel submits that by mistake, instead of showing survey number 122/3B, the petitioner has shown survey number 122/3A1, which also belongs to the petitioner.
Measuring 21 guntas.
And it measures 21 guntas. Full stop. Full stop. Learned counsel submits that the petitioner has tried to explain to the trial court that the petitioner is only intending to correct the survey number having regard to the documents which shows that the petitioner was the owner and khatedar of the said property also, and by mistake some other survey number has been shown in the plaint and the schedule. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order dated 9/7/2024 in OS number 131 of 2017 on the file of the civil judge and JMFC, Turvekere, and all further proceedings thereto, till the next date of hearing.
Great.
It वापस को पढ़ो.
Number 23, Manjunath case.
My lord, and for the petitioner, my lord, defendant number 2 to 5 referred this writ petition.
23 na?
Serial number 23. My lord, defendant number 2 to 5 are before your lordship as petitioner assigning the order of the learned suit for partition, my lord. The learned judge was pleased to.
You are all family members.
We are all family, that is not in dispute, my lord. Insofar as my application to recall the witness PW1 and permit me to lead further evidence, though it was allowed, in fact, at the instance of the learned friend, the plaintiff has no objection to allow my application to lead further evidence. It was allowed, but however, the learned judge insisted on me to lead evidence on the same day, that is on 26th July. I was not knowing that the other side would say no objection to my application. But however, the learned judge, the moment the other side plaintiff has said no objection to my application, the PW1 was not present before the court. Not because of his age, he was not able to come due to personal inconvenience. But however, the learned judge insisted on him to lead the evidence immediately on the same day after allowing the application. Just because PW1 was not present before the court, the learned judge was of the view that since you have not read the evidence, your application is rejected with cost of ₹1,000. That is the order passed by the learned judge. And against that order, I am before your lordship. I am seeking your lordship's indulgence to kindly permit me to lead further evidence as a lost opportunity, my lord.
Sir, in this case, appeal for petition. The matter shut down for arguments. Plaintiff arguments ಆಗಿದೆ, other defendant arguments
I should be
ಆಗಿದೆ.
grateful to my learned friend. He has said no objection.
ಸ್ವಾಮಿ ಇವತ್ತಾಗ್ಲಲ್ಲ, ನಾಳೆ ಆದ್ರೂ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ಅವ್ನು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ಈ ಶುಡ್ ಹ್ಯಾವ್ ಅಕಾಮಡೇಟೆಡ್. ಹೌ ಇಸ್ ಇಟ್ ದಟ್ ಇಲ್ಲ ನೀವು ಇವತ್ತು ಮಾಡಿಲ್ಲ ಅಂತಂದ್ರೆ ರಿಜೆಕ್ಟೆಡ್? One date of hearing should have been given. What do you say? Let them proceed. Let them pay costs and proceed.
Please, Lord. Please,
Lord.
Matter may kindly be disposed of on the ground that so far as respond number 2 to 4 is only a formal parties, my lord.
Learned counsel, Shri PM Gopi has entered appearance for
Kevetar, first respond.
Kevetar plaintiff.
Kevetar respond number 1.
Please.
Who is the plaintiff and the existing respondent. Full stop. Next para. The petitioners who are defendants number 1A,
2 to 5
and 2 to 5 are before this court aggrieved of the impugned order dated 26/7/2024 passed by the Principal Senior Civil Judge in JMXC at Anekal, rejecting IA number 25 and 26 filed by the petitioners herein to
First instance it was allowed and subsequently it was rejected.
That's what I
for
said.
cross-examination.
No, for
For the
further
chief of
evidence.
DW2.
For leading further evidence.
Of
to
DW2.
mark on document.
PW.
Not PW. Not PW, their evidence.
DW1, I'm sorry.
Their evidence, please. Lord.
Their evidence, my evidence. I want to produce some document through DW1. I need
recall the defendant witness DW1
please,
for further examination.
please.
Full stop. Learned counsel submits that it is true that earlier too such an application was allowed by the trial court. Full stop. Nevertheless,
At the instance of the plaintiff, my lord. The two application was allowed at the instance of plaintiff.
but the said application was allowed at the instance of the plaintiff and not at the instance of the defendants. Full stop. This time, when such application was filed by the defendants, the trial court immediately, when the application was filed by the defendants, the learned counsel for the plaintiff said the plaintiff will have no objection to allow the application, and therefore the trial court directed
that DW1 shall be examined immediately. Full stop. However, owing to the old age of DW1, comma, who was not present before the court, comma, the learned counsel for the defendants sought for a short accommodation. Full stop. However, the trial court has declined to oblige and has rejected the application. Full stop. Next para. At the on the asking of this court, comma, learned counsel for the first respondent, plaintiff, fairly submits that the application may be allowed and the defendants may be directed to examine DW1 on the next date of hearing. Full stop. Next para. Accordingly, the writ petition is allowed. The impugned order
matter. 2006 matter.
The impugned order dated 26/7/2024 is set aside. Full stop. IAS number 25 and 26 filed by
Different number.
defendants number 1A and 2 to 5 are allowed. Full stop. However, the defendants shall further examine for the trial court.
That is on 13th, my lord. Coming 13th.
While paying cost of rupees 2,000.
No, 1,000 is already ordered. 1,000 is already ordered in the trial court.
Reject ಮಾಡ್ಬೇಕಾದ್ರೆ allow
1,000 rupees cost ಹಾಕಿದ್ದಾರೆ.
While paying the costs that were directed by the trial court.
Please, I'm going to pay it, my lord. So far as the notice to D2 to
2006 suit.
Please, my lord.
also.
So you want a direction.
It already set down for arguments. Arguments also heard. But after arguments heard from the plaintiff and 8 defendant,
is
he has
returning
filed
stage,
the
my lord.
application.
It is a returning stage. We are going to complete the process the moment the evidence is laid in.
We will direct the disposal within 4 months.
Please.
Full stop. Having regard to the matter was set down for
Arguments.
comma, the defendants are directed to proceed with the further examination of DW1 and permit cross-examination of DW1 and thereafter proceed to conclude the arguments without seeking any adjournment.
Please move.
Full stop. The trial court of the suit as a copy of this order.
My lord, yes, because there are only formal parties. Please.
It depend, respond on one is the contesting.
Contesting part.
Yes.
Please, my lord.
During the course, after the conclusion of the trial, my lords, the defendant had found out a agreement copy wherein, my lords, the earlier transaction between the same parties were concluded in that agreement. So the defense set up by the defendant in the written statement is that, my lord, that the money, it's entirely a money transaction and already has discharged the entire liability with the plaintiff in the earlier transaction. My lords, since the documents were not readily available on the date during the course of trial, he could not persuade the client to produce that along with the application or cross-examine on that point. Hence,
But you have raised that contention.
Yes, I have just referred to the written statement contentions, my lord. Page 16. page 17, my lords, paragraph 18. After receipt of the letter dated 29/1/2020, defendant came to know that an agreement was bought about by the plaintiff, and defendant is always ready to refund the entire genuine loan amount received by the defendant as soon as possible. Further, the defendants already paid the entire amount of 3 lakhs along with interest borrowed by him. So, my lord, in order to ascertain this,
This was the earlier agreement.
this was the earlier.
Which, ಯಾವ agreement?
ಅದು 2013
Where have you mentioned?
My lord, that agreement copy was not readily available on that day, my lord.
ಇದು ಈ agreement ಯಾವಾಗ ಆಗಿರೋದು?
2017, my lord.
2017.
2017.
Earlier agreement?
2013.
But you have not said so.
I do admit, my lord, the application is very vague. They have not given any particulars. But, my lord, due to the lack of the legal knowledge, my lord, they could not particularly insert this particular aspect in the, I do admit, my lord, it should be very specific whenever.
To the respondent. The petitioner is also permitted to serve a copy of the writ petition along with annexures on the learned counsel representing the respondent before the trial court.
Date may become so that arguments go good.
Release this matter on 22nd of August.
Obliged.
25, M. Venkatappa.
Petitioner.
Yes.
The suit is filed by petitioners, plaintiffs for relief of partition and declaration. The
Defendants are all family members.
ಅವರು ಫಸ್ಟ್ ವೈಫು, ನಾವು ಸೆಕೆಂಡ್ ವೈಫ್ ಚಿಲ್ಡ್ರನ್ನು ಡಿನೇ ಮಾಡಿದ್ದಾರೆ. ಬಟ್ ಎಕ್ಸಿಬಿಟ್ D13 ಇಟ್ ಈಸ್ ರಿಲೈಡ್ ಬೈ D3 ಈಸ್ ಅ ಪರ್ಚೇಸರ್ ಆಫ್ ದಿ ಎ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ. ಅದರಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಬರೆದಿದ್ದಾರೆ, ಮೊದಲನೇ ಹೆಂಡತಿ ಮತ್ತು ಎರಡನೇ ಹೆಂಡತಿಯವರು ಒಪ್ಪಿಗೆ ಸಾಕ್ಷಿಗಳು ಹಾಕಿದ್ದಾರೆ ಅಂತ. ಐ ಹ್ಯಾವ್ ಎನ್ ಅಕೇಶನ್ ಟು ಎಕ್ಸಾಮಿನ್ ದಿ D3 as a DW2 and genuinity of the that sale deed.
ಆಯ್ತು, ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ಹೇಳಿ.
ಇದರಲ್ಲಿ ಗಿಫ್ಟ್ ಡೀಡ್ ಒಂದು ದೇ ಕ್ರಿಯೇಟೆಡ್ forged the signature of my father. So after the conclusion of the evidences.
It's unregistered gift deed.
Registered.
Created ಅಂದ್ರೆ ಅರ್ಥ ಏನು?
ಅಲ್ಲ, forged ಇದೆ, ನಮ್ಮ ತಂದೆ ಹೋಗಿ ಮಾಡಿಲ್ಲ. ನಮ್ಮ ತಂದೆ ಸಿಗ್ನೇಚರ್ಗಳಲ್ಲ ಅವು. You compare to exhibit sale deed.
ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ಹೇಳಿ.
And ಇದು after the conclusion of the evidences, I filed an application to refer the matter for handwriting expert. That application has been rejected. So that is the reason I filed the writ petition.
Registered document.
ಹೌದು, ಸಿಗ್ನೇಚರ್ ಅವ್ರು ಹೋಗಿ ಮಾಡ್ಕೊಟ್ಟಿಲ್ಲ. ಅದನ್ನ ಸಿಗ್ನೇಚರ್ಸ್ ಎಲ್ಲ ವೇರಿಯೇಷನ್ಸ್ ಇದೆ.
ಫೋಟೋ ಇರುತ್ತಲ್ಲ ಸರ್?
ಫೋಟೋ ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದ್ರಲ್ಲಿ ಫೋಟೋ ಇಲ್ಲ.
ಎಲ್ಲಿದೆ? ವೆರಿ ದ ಡಾಕ್ಯುಮೆಂಟ್?
ಡಾಕ್ಯುಮೆಂಟ್ ಐ ನಾಟ್ ಪ್ಲೇಸ್ ಇಟ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್. ಸಿಗ್ನೇಚರ್ಸ್ ಒಂದ್ ನಿಮಿಷ ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ. ಇಲ್ಲಿ ಕೊಡಿ, ಸಾಹೇಬ್ರ ಕೊಡಿ. ಇದು ಗಿಫ್ಟ್ ಡೀಡು, ಇದರಲ್ಲಿ ಸೇಲ್ ಡೀಡ್. ಇದರಲ್ಲಿ ಐ ಹ್ಯಾವ್ ಅನ್ ಅಕೇಶನ್ ಟು ಎಕ್ಸಾಮಿನ್ ದಿ ಜಿನ್ಯಾನಿಟಿ ಆಫ್ ದಿ ಇದು. ಇದರಲ್ಲಿ ಐ ಹ್ಯಾವ್ ನೋ ಅಕೇಶನ್. ಡೋನರು ಸತ್ತೋಗಿದ್ದಾರೆ, ಡೋನಿನೂ ಸತ್ತೋಗಿದ್ದಾರೆ ಗಿಫ್ಟ್ ಡೀಡಲ್ಲಿ. ಫಸ್ಟ್ ವೈಫುನು ಸತ್ತೋಗಿದ್ದಾರೆ, ನಮ್ಮ ತಂದೆನೂ ಸತ್ತೋಗಿದ್ದಾರೆ. ಸೊ ಐ ಹ್ಯಾವ್ ನೋ ಅಕೇಶನ್. ನೋಡಿ ಅಲ್ಲಿ ಹನುಮಂತಪ್ಪ ಅನ್ನೋದು ಒಂದು, ಅದಕ್ಕೆ ಮಾನ ಇಲ್ಲ, ಒಂದು ತಾನು ಇಲ್ಲ, ಒಂದು ಪಾನು ಇಲ್ಲ.
ಯಾವುದು? ಡಾಕ್ಯುಮೆಂಟ್ ಆಫ್ ದಿ ಇಯರ್ 1996.
96 I admitted now because 2001 ಅದು ಗಿಫ್ಟ್ ಡೀಡ್. ಅದರಲ್ಲಿ ನೋಡಿ ಸ್ವಾಮಿ, ಸಿಗ್ನೇಚರ್ಸ್ ಒಂದು ಟ್ಯಾಲಿ ಆಗಲ್ಲ.
ದೇರ್ ಇಸ್ ನೋ ಫೋಟೋಗ್ರಾಫ್.
ಅಷ್ಟೊತ್ತಿಗೆ ಬಂದಿರ್ಲಿಲ್ಲ, 2002ಗೆ ಏನೋ ಬಂದಿತ್ತು ಸ್ವಾಮಿ.
ನೋ ಸರ್.
ಹೌದು ಸ್ವಾಮಿ.
ನೋ.
I think
when the time I started practicing in the year 1994 itself, photographs were there. Yes sir.
ಹಾಗಾದ್ರೆ ಇದರಲ್ಲಿ ಅದು ಬಂದೇ ಇಲ್ಲ, ಫೋಟೋಗ್ರಾಫ್ಸ್ ಇಲ್ಲ. ಅಲ್ಲ, ನನಗನ್ಸೋದು 2002 ಇಂದ ಏನೋ ಬಂತು ಅಂತ. ಆ ಫೋಟೋಸು ಅಂಟಿಸ್ತಾ ಇದ್ವಿ ನಾವು. ಆಮೇಲೆ
ಫೋಟೋಸ್ ನಾನು ಹೇಳ್ತಾ ಇರೋದು. ಐ ಆಮ್ ನಾಟ್ ಟಾಕಿಂಗ್ ಅಬೌಟ್ ದಿ ಕಂಪ್ಯೂಟರೈಸ್ಡ್ ಫೋಟೋಸ್.
ಅದೇ
I'm saying photographs now, ಅನ್ಸ್ತಾ ಇದ್ದಿದ್ದು.
ಅದು 2000
That was there even before I started practicing.
ನನಗೆ ಗೊತ್ತಾಗ್ತದೆ.
Yes, yes.
ಮೇ ಬಿ ಅದನ್ನು ನಾನು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
Let us see. Issue notice to the respondents.
26.
The petitioner is also permitted to serve copies of the petition along with annexures on the learned counsel for the respondent. Release this matter on 22nd of August.
ಸ್ಟೇ ಮೇ ಬಿ ಗ್ರಾಂಟೆಡ್.
No, sir.
ಅಲ್ಲಲ್ಲ ಮೇನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಬಂದಿದೆ.
22nd date ಕೊಟ್ಟಿದ್ದೀನಿ.
ಅಲ್ಲ ಅದು ಸ್ಟಿಲ್ ದೆನ್ ಅಲ್ಲ ನನ್ನ ಮೈ ರಿಕ್ವೆಸ್ಟ್ ಇವ್ರ
Possible.
ಅಲ್ಲಲ್ಲ ಅಲ್ಲಿ ಸಾಹೇಬ್ರು ಮಾಡಿದ್ರೆ ಮಾಡಿ ಇಲ್ದಾರೆ ನಾನು ಜಡ್ಜ್ಮೆಂಟ್ ಹಾಕ್ತೀನಿ ಅಂತ ಇದ್ದಾರೆ. ದಯವಿಟ್ಟು ಡೇಟೆ ಕೊಡೋದಿಲ್ಲ ಅಂತ ಮಾಡ್ತದೆ. ಅಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ ಅಲ್ಲ ಇದು ವೆರಿ ಡಿಸ್ಪ್ಯೂಟೆಡ್ ವೆರಿ ಸೀರಿಯಸ್ಲಿ. ಅದಕ್ಕೋಸ್ಕರ ಟಿಲ್ ದೆನ್ ಸ್ಟೇ ಮೇ ಬಿ.
No.
Serial number 26, Pawan R. Javali.
A suit is filed in the year 2021 against the company, which is the tenant. Along with the company, the directors have also been arraigned. Ejectment.
Ejectment.
Please.
Filed by the company.
Filed by the HUF against the company which was the tenant. The contention of the plaintiff was that the tenant has not been paying rent. He has not paid the GST.
Suit has been decreed.
Suit has been decreed on 25/4/24. However, during the pendency of the suit, they filed some IAs that the deposit arrears may be deposited. Now that IA is sought to be executed by filing of an execution petition post the judgment. If the execution would have come to a halt because the orders get merged with the final order. Separately maintaining proceedings under those IAs.
IAs?
Yes, IA file, IA number 5 and 9. Your lordship will find that on page 146. Bottom. OS number so and so, orders on so and so, and orders on. These are the two orders. And your lordship will notice that the order is issued on the application is also of the filed in 23. The order is passed as can be seen from the page number 15 on date. The date is not seen. However, the attachment order issued is dated at page 14.
Which is the impugned order now?
Impugned order is at next page 8, page 15, your lords. On operative portion is on 16. IA1 is filed for so and so, it is contained so and so. Filed a memo with latest, issue arrest warrant, attachment warrant in respect of so and so, returnable by 14/8.
For order of attachment of the
19/7. 19/7/24, this order is passed post the judgment.
Application was filed seeking order of attachment of the scheduled property.
Please. Which is the personal property of the director defendant. Not concerned with the company. Entire thing is rotating or revolving around about the company, which is the tenant, the rents payable, the GST payable, whatever be the contentions. Why are they moving against the director property?
Company also has a property?
Company itself is the tenant. The company has assets, other assets. It's a medical diagnostic center. So they have moved against the director's asset.
Yes.
Personal asset.
Yes. What is the law on this aspect?
The point is how much when the tenant is the
decree is passed against the company
and the directors.
Then if the company has no assets, then what to do then? You can't frustrate the decree by saying, no, you can't proceed against the directors. Anyway, there is a decree against the directors.
But then this is, IAs have got merged with the final order, Your Lordship.
Whatever it is,
No, but how can they seek execution of an IA order post the judgment?
it is along with the decree, sir.
No, Your Lordship.
Yes.
Your Lordship will see that applications order is
If you are able to point out that, no, there are assets of the company, let them proceed against
the assets of the company is that the medical equipment is, everything is there. They're all in the name of the company.
Have you filed such an application? Or a memo before the executing court?
No, they are never, it was ex parte passed.
Go and file the list of assets of the company and ask the court to proceed against the company. We will direct the court.
Please.
Perfect.
They have already, I'm instructed that the Mazar has been drawn and the list of equipment has already been drawn by them. By the executing court.
And no orders have been passed against the.
No, nothing. On the contrary, this asset, which
movable
is already
assets?
mortgaged to the bank, is sought to be attached.
Huh?
This property which they have sought for attachment is already mortgaged to the bank for the loan that I have taken.
In your individual capacity?
In my individual capacity. Housing loan I have taken, that is attached. And that I have produced along with my.
That is already attached. There.
Yes, to the ICICI home loan. Which is at page 175, your Lord.
Anyway, if it is already attached, then what is there?
No. Lordship,
this
what
order.
What will happen is.
Will not be able.
No, Your Lordship, what will happen is the bank will get agitated and may make my account immediately recoverable.
If that order of attachment is earlier in point of time.
That's earlier.
Then they will
It's
have
always, liability of the bank
first
is earlier. Your Lord, that has also to be
Don't
mentioned.
worry about that. Issue notice to the respondent. The petitioner is also permitted to serve copies of the writ petition along with annexures on the learned counsel representing the respondent before the executing court. Full stop. Next para. Learned senior counsel appearing for the petitioner submits that the impugned order has been passed by the executing court directing issuance of attachment warrant in respect of the property belonging to the petitioner, who is a director of the judgment debtor company.
Defendant one.
Full stop. It is submitted that the judgment debtor has furnished a list of the assets of the company which has suffered the decree, and instead of proceeding against the assets of the company, the impugned order has been passed attaching the property belonging to
personal property of the petitioner.
Personal property of the petitioner. Full stop. It is further submitted that the property in question already stands attached in another proceedings at the instance of the bank where the petitioner had borrowed loan in his individual capacity and not as a director of the company. Full stop. Next para. If the property in question is already attached at the instance of the bank where the petitioner had borrowed loan, then obviously the order of attachment, which is at a prior point of time, will have precedence over the subsequent order of attachment. Full stop. Nevertheless, the executing court is required to consider whether such an order could have been passed without directing the attachment and sale of the assets of the company.
And without hearing the petitioner.
Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order dated 19/7/2024 in execution petition number 1997 of 2023 till the next date of hearing. Yes.
27, Vivekes.
For petitioner in this case, my lords, defendant's writ petition, suit for recovery of money, my lords. An application was filed for recalling the order dated 19/7/2024, taking defendant evidence as nil, my lords. So said application was rejected, my lords, by the trial court.
Suit for?
Suit for recovery of money, my lords. It's a commercial.
You are the defendant.
You are the defendant, my lords. The plaintiff has
Wanted
filed
to reopen the.
No, recall the order dated 19/7/2024, taking defendant evidence as nil and posting the matter for arguments, my lords.
Permitting you to examine defendant witness.
So said
This was the
application
first
was,
time or such orders already passed?
Yes, my lords. In the 19/7/2024, defendant evidence was taken as nil and matter was posted for arguments. On 31/7/2024, we filed an application for.
Earlier, whether such an order was passed, closing the side of the defendants.
Yes, my lords.
So this is second time.
No, earlier there was no order, my lords. This is the first time. In fact, observations made in the order is not proper, my lords. Even DW1 was cross-examined in part also. The copies of the depositions also are furnished, my lords. At page number 134.
Impugned order?
It's on page number 50, man.
Yes, please read it.
Counsel for defendant has filed IA number 10 under section 151 of CPC and IA number 11 under order 18 rule 17 of CPC to recall the order dated 19/4/2024 and permit DW1 for cross-examination. Counsel for plaintiff also present. He perused the order sheet dated 15/12/2022. On the said date, case was posted for cross of DW1 and thereafter several opportunities given for defendant to appear for cross-examination, but he was absent. On 8/11/2023, court commissioner was appointed for cross-examining DW1. Till the state court commissioner has not made any attempt to obey the order passed by this court on 8/11/2023. Hence, on 14/6/2024, this court closed the stage of cross-examination of DW1. Now, defendant has filed the present application without any valid reason as to why court commissioner has not executed the commissioner warrant in view of this IA number 10 and 11 filed by the. In fact, counsel for plaintiff also, even they had filed an application to recall this order dated 14/6/2024, my lord. But trial court did not receive that application and it orally instructed us to file an application.
Why are you not permitting the cross-examination?
No, my lords. In fact, on two occasions, he was cross-examined in part, my lords. And DW1 has appeared before the trial court on 6 to 7 occasions, my lords. And subsequently, on 2-3 occasions, matter did not reach due to paucity of time, my lords.
No, the court commissioner has been appointed.
Yes, my lords.
Why?
On the basis of suggestion made by the court, we filed an application to appoint court commissioner, my lords. Since witness was traveling from Gujarat, my lords. Like 3 or 4 times he appeared before the court and the matter did not reach actually. And on couple of occasions, even counsel for respondent, he had sought time, my lords. So then the court suggested us to file an application, my lords. Like oral suggestion was made, my lords. On the basis of the same.
Court commissioner will go to Gujarat and.
No, my lords, before witness was supposed to come down.
Then where is the need for appointing court commissioner then?
Then subsequently, my lords, so even we had made a submission before the trial court also, my lords, that evidence of DW1 may be recorded also. But the trial court was the opinion since the order was already passed appointing court commissioner. So let commissioner only record the.
Where will the court commissioner go and examine the witness? If you are saying he is in Gujarat.
No, witness was willing to come down to Bangalore.
Then why court commissioner then?
Since because court only suggested us to file the application, my lords, because on 2-3 occasions matter did not reach since certain technical issues were also involved, my lords. So that's the reason upon suggestion made by the court we had filed the application, my lords. So if this application is allowed, my lords, so we'll keep DW1 present before the court itself, my lords.
The respondent. The petitioner is also permitted to serve copies of the writ petition along with annexures from the learned counsel representing the respondent before the trial court.
No, matters posted for judgment only on
commercial court. We'll stop. Next para. the petitioner is aggrieved of the impugned order dated 31/7/2024, whereby the application filed by the defendant in IA number 10 and 11 to recall the recalled DW1 for cross-examination. Has been rejected. Full stop. Learned counsel submits that it is evident from the impugned order that the plaintiff was not able to cross-examine DW1. And in fact, the plaintiff has also filed such an application seeking to
Copies
recall.
in producer page number 128, my lords. I produced the copies of the application filed by plaintiff, my lords. But that was not taken on record and
To recall and permit the cross-examination of DW1, as could be seen at Annexure G. Full stop. Nevertheless, such an application filed by the plaintiff was also not taken on record. Full stop. Learned counsel submits that it would be in the interest of justice that DW1 should be recalled and enable the plaintiff to cross-examine DW1. Full stop. Next para. Consequently, there shall be an addendum order of stay of all further proceedings in commercial OS number 747 of 2022 on the file of the 87th Additional City Civil and Sessions Judge Sessions Court, Bengaluru, CCH number 88 till the next date of hearing. Full stop. Release this matter on 22nd of August.
by request for hand delivery of a request for hand delivery.
It will be uploaded tomorrow. You can show it to them. Yes. Huh?
Serial number 9, Pleshappa case.
Sorry, Melody.
Aspirant number 1, Your Honor.
Yes.
But it's a defendant's writ petition, my lord.
Suit for?
Defendant suit is, my lord, a declaration filed by the respondents, my lord, seeking the declaration to declare or nullification of the compromise decree entered into with the petitioner housing society and landowners. There was a compromise decree interstate between a dispute between landowners and the society in the earlier suit OS 360. Now that decree, according to that decree, my lord, we have to pay 640 lakhs and it was at 6 crores 40 lakhs. It was fully and finally settled. That was the compromise. That compromise decree was challenged by some of the members of the society before the civil court in present suit, my lord, OS 731 of 2019, in which, my lord, they made an application for injunction. A relief nature of injunction they sought for is the society be restrained from releasing any amounts to the landowners in furtherance to the compromise decree. That was the application. Of course, it is opposed by the society and other things, including the other landowners also. Ultimately, my lord, the trial court passed an order. Your lordship may kindly see the order passed by the trial court. Is, my lord, that Annexure P, my lord, page 197.
My lord, operative portion of the order at page 209, typed page is 13, my lord. Can I read it, my lord?
This is the impugned order.
It is the impugned order. It is not the impugned order. Impugned order is passed by the appellate court, but in miscellaneous appeal.
Trial court.
Yes, it is an injunction application. In the injunction application, this is the interim order passed by the trial court after contest. IA 3 filed under 39 Rule 1 and 2 by the plaintiff is allowed. Defendants 1 and office bearers of defendant number 1 society are hereby restrained by this order of temporary injunction from releasing the amount agreed under compromise decree number so and so in favor of defendant number 2 to 9 till further orders. The plaintiff shall execute bond of indemnity submitting that they will repay the interest on the amount which is kept with the defendant number 1 along with the profit which would be accrued on the said amount in case of failure of the plaintiff to succeed in the suit. This is the interim order passed by the trial court. This order we have not, society have not challenged that. Landowners have challenged in an appeal before the first appellate court, before the district and session judge. Next page may kindly be seen, Connection Q, page 211. Yes, in which, my lord, the order is modified by the first appellate court. Your lordship may kindly go to page 229. The appeal preferred by the appellant plaintiff under order 43 Rule 1R is partly allowed. The orders passed on IA number 3 by the learned additional senior civil judge JMFC Nelmangala in so and so following modification. The order passed by the learned court directing plaintiff to execute indemnity bond by undertaking to repay the interest along with the profit which would be accrued on the account of kept with defendant number 1 society in the case of their failure to succeed in the suit is set aside. Then, my lord, the defendant number 1, that is the first respondent society, the defendant number 1 society directed to deposit the compromise decree amount on the learned trial court within 2 months from the date of this order. After deposit, the learned trial court is directed to deposit the said amount in any nationalized bank as FD in the name of the court till disposal of the suit. Same shall be released in favor of the rightful owners after deciding the suit. But this order we challenging the, it says for more than 4 crores and that. The court is directed us to deposit. It is not our appeal. It is landowner's appeal. If the trial court find the order of the trial court find fault with the first appellate court, they can set aside and pass a necessary order. Instead of now, the burden is imposed upon the society to deposit the money. If the entire amount is deposited, how to run the society is a question. It's house building cooperative society. Therefore, this order we challenge. We have not challenged the order of the trial court. Landowners have challenged.
You have filed a written statement?
Yes, written statement we have filed.
What is the ground that you have raised? You have not raised the question of maintainability of the suit?
No, it is maintainable, my lord. There is no dispute. That is the question because it's an interest between owners who are not members of the society and the other issues are also there, of course. And 118, my lord, it is debarred of filing of the suits. 118 of the cooperative society.
There is an express provision which says no suit is maintainable raising a challenge to a compromise decree.
That is, my lord, order 23, rule 3 capital A.
Yes.
It debars filing of the fresh suit.
Yes.
On any ground, and any person having a complaint against the compromise decree, they are to observe the same court under section 151. They should get relief under the such procedure.
Then why did you not raise that?
That we have not. We said the suit itself is not maintainable. Generally, we have taken a contention. That contention we have raised in our written statement.
Order 23.
Order 23, rule 3, capital A. Order 23, rule 3, capital A.
Then why have you not raised that?
That we have raised it, my lord. That question, it is pending reasons.
Then that should have been taken as a preliminary issue.
That now, my lord, your lordship is aware, by virtue of the larger bench judgment of our High Court, no preliminary issue could be adjudicated. It was the bar. This honorable court taken the view that all the issues to be tried and primary, if any issue relating to jurisdiction, that had to be dealt independent. That was the view taken by the larger bench, my lord.
Yes, what do you say?
CRP dismiss ಆಯ್ತು 117 ಹಾಕಿರೋದವರು ರಿವಿಷನ್ ಡಿಸ್ಮಿಸ್
ಅವ್ರು ಹಾಕಿರೋದಲ್ಲ, ಅದನ್ನ ಹೇಳ್ತಾರದವ್ರು. ಅಪೀಲ್ ಹಾಕಿರೋದು ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ಸ್. ಇವಾಗ ಡೈರೆಕ್ಷನ್ ಇಸ್ ಇಶ್ಯೂಡ್ ಟು ದಿ ಸೊಸೈಟಿ.
ಅರ್ಲಿಯ ರಿವಿಷನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಸರ್ ಯಾಕೆ ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್
ಏನ್ ರಿವಿಷನ್?
CRP ಸರ್ 117
ರಿಗಾರ್ಡಿಂಗ್ ವಾಟ್?
ಅದಕ್ಕೂ ಇದು
ಮೇಂಟೈನಬಿಲಿಟಿ ಮೇಲೆ ಸರ್, ಮೇಂಟೈನಬಿಲಿಟಿ ಮೇಲೆ.
ಅಲ್ಲ, ನಾನು ಅವ್ರನ್ನ ಬೇರೆ ಪ್ರಶ್ನೆ ಕೇಳಿದೆ. ಬಟ್ ನಾವು ಇವಾಗ ಬಂದಿರೋದು ಇವ್ರ ಕೋರ್ಟ್ ಮುಂದೆ ಈ ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ ಪಾಸ್ ಬೈ ದಿ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್.
Annexure Q.
ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಮುಂದೆ ಹೋಗಿದ್ದು ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ಸ್.
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್
ಡೈರೆಕ್ಷನ್ಸ್ ಇಶ್ಯೂ ಮಾಡಿರೋದು ಸೊಸೈಟಿಗೆ. ಪೂರ್ತಿ ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬಿಡಿ ಅಂತಾರೆ. ನಮ್ಮ ಹತ್ರ ದುಡ್ಡಿಲ್ಲ, ಹೆಂಗ್ ಡೆಪಾಸಿಟ್ ಮಾಡೋದು ಅಂತ ಅವರು.
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಎಂಗೇಜ್ ಮಾಡ್ತೀನಿ. ಸೊ 2 weeks ಟೈಮ್ ಕೊಡಿ ಸರ್.
Senate Council Shri B.M. Narayana
BMNG sir. BMNG. Respondent number 1.
B.M. Narayana Gowda.
House.
Has entered appearance for
R1.
Respond number 1.
1 sir. Okay, with us.
Obrera. ಹೆಂಗ್ರಿ ನೀವೆಲ್ಲ ಮೆಂಬರ್ಸ್, ಸೂಟ್ ಫೈಲ್ ಮಾಡೋರು ಎಲ್ಲ ಮೆಂಬರ್ಸ್.
ನಂಬರ್ ಒಬ್ರಿಗೆ ಹಾಕಿರೋದು.
ಒಬ್ರಿಗೆ ಮಾತ್ರ ಹೆಂಗ್ ಹಾಕ್ತೀರಾ ನೀವು?
ಉಮೇಶ್. Sri Umesh C.
Well, dependent number 1.
Original suit plaintiff number 1 Samino.
1, 2, 3 are the members. They are the plaintiffs in OS 731. Page annexure A.
You have filed caveat for respond number
1.
That is dependent number 1.
Plaintiff number 1 sir.
Umesh Anta.
Original
suit. Plaintiff number. All the plaintiffs are members of the society. ಅದೇಂಗ್ ನೀವು ಒಬ್ರಿಗೆ ಮಾತ್ರ ಹಾಕ್ತೀರಾ?
ಡೈರೆಕ್ಟರ್ ಹಾಕಿದ್ದಾರೆ. ಡೈರೆಕ್ಟರ್.
ಹೌದ್ರಿ, ಎಲ್ರು ನೀವು ಮೆಂಬರ್ಸು, ನೀವು ರಿಲೀಫ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ ಕೋರ್ಟ್ ಮುಂದೆ. ಈಗ ಒಬ್ಬೊಬ್ರು ಸಪರೇಟ್ ಆಗಿ ವಕಾಲತ್ ಹಾಕಿದ್ರೆ ಹೆಂಗೆ?
ಬೇರೆ
issue notice to all the other respondents. The petitioner is also permitted to serve copies of the writ petition along with annexures from the learned counsels representing respondents number
1,
2 to 13 before the trial court. Full stop. Next para. Learned senior counsel Shri M.R. Rajgopal, appearing on behalf of the petitioner, submits that the petitioner society, which is defendant number 1 before the trial court, did not question the orders passed by the trial court. On IA number 1 of
IA number 3, IA number 1. IA number 3 under order 39 rule 1 and 2, page 199. IA 3 is injunction application. Plaintiff have filed
IA number 1 ಅಂತ ಕೆಳಗಡೆ I number 3 ಅಂತ ಹೇಳ್ತಾರೆ.
ಏನೇನೋ ಸ್ವಲ್ಪ ಕನ್ಫ್ಯೂಷನ್ ಇದೆ.
IA number 3 under order 39 rule 1 and 10, 1 and 2 of the CPC, where the trial court had directed the petitioner herein, restraining them from releasing the decretal amount under compromise decree in OS number 360 of 2012 in favor of defendants number 2 to 9, comma, till further orders. Full stop. In fact, the plaintiffs were directed to furnish bond of indemnity that they will repay the interest on the amount which is kept with defendant number 1 along with profits which would be accrued, which would accrue on the said amount, comma, in case of the plaintiffs failing to succeed in the suit. Full stop. The landowners, defendants number 2 to
9 men.
2 to 9 filed an appeal before the district court in MA 118 of 2023, and the district court has passed the impugned order directing the petitioner society to deposit the decretal amount with the court, with the trial court within a period of 2 months from the date of the order. Full stop. Learned Senior Counsel submits that the owners of the property who had entered into a compromise with the society have not sought for execution of the decree, and such an order could not have been passed by the appellate court directing the society to deposit the entire amount within a period of 2 months. Full stop. Next para. Consequently, there shall be an identity mode of stay of the impugned order dated 22nd of March 2024 in MA number 118 of 2023 till the next date of hearing.
Number 15, Balraj AC.
Much obliged.
For the petitioner, my lord. For the respondents 1 and 2.
My lord, this petition is filed, my lord, against the order passed by the trial court on IA number 1, my lord, issuing delivery warrant, my lord. My lord, the respondents 1 and 2 herein, along with her mother, claiming that she is the second wife of one William, filed a suit for partition, my lord.
You are the judgment debtors.
I am the judgment debtors, my lord.
Respondents are the decree holders.
Please.
1 and 2.
1 and 2, my lord.
1 and 2.
1 and 2, my lord. My lord, they filed a suit for partition, my lord.
3 to 9 also judgment debtors.
No, 3 to 9 are the tenants, my lord. They were not the parties before the
4
in
to 9
OS
are
and
tenants.
FDP proceedings.
What was the suit that you had filed?
Suit for partition,
and separate
partition suit.
Partition.
Partition and
separate possession.
Ah.
Let's came to be filed in the year 2015. Very same, let's judgment debtors have contested the suit. Suit came to be decreed and granted.
That was only between family members.
Family members.
yes.
Subsequently, during the pendency of the suit, the very same judgment, the petitioner's hearing, have sold one of the item, that is third item in favor of the third respondent hearing. But subsequently, we have implemented. She has not contested. 1 and 2 minutes, the petitioners have hotly contested, the suit came to be decreed, granted the partition of our offshare. Then, the final decree proceedings we have initiated. Final decree, even in the final decree, they have received the notice, they have not represented. Commissioner has been appointed. Commissioner has demarcated our offshare in respect of all the 3 items. Report has been submitted. Then, decree has been drawn. Decree has been registered. Kathas have been affected. Then, they have not delivered the possession. Then, execution petition came to be filed. Then, the execution petition, one unnecessary applications have been filed. Then, we have filed the application to recover the possession. In respect of one of the item, we have already recovered the possession. Only in respect of item number 1, now they have, after lapse of 2 years, now they have come before this court. Now, after the issuance of delivery warrant, today, RFS, challenging the judgment and decree, now they have filed the appeal. Now the appeal today, it has been listed before the quarter number 23, it is passed over. Now, the prior to this filing of this writ petition, respondent number 3 has also filed the very same similar writ petition. This honorable court, now consider the interim prayer and given direction to approach any of, we have filed the writ, appeal. You seek remedy, already you have very similar, the relief has been sought. You go and approach the appeals. That's now subsequently this JDRs have filed this writ petition.
My lord, they have filed an
Tell
application.
that, have they furnished a copy of that order passed by this court?
Connected writ petition, my lords.
What is? You have filed that writ petition.
No, my lords, one of the respondent number 3 area. She's also one of the JDR.
No.
In respect of item number 3 is concerned.
Where is that? The order passed by this court?
Let's in the order sheet notice, similar emergent notice has been issued. Emergent notice had been issued in the connected this writ petition.
Allala. You said earlier also there such an order has been passed by this court.
No,
No, not let's this respondent number 3 has challenged the order passed by the trial court in this writ petition. This writ petition, my lords, court has not considered the interim prayer and notice has been issued to the all the respondents.
So you
Even as on the date of filing of the writ petition, my lords, RFAs have already been filed. They have challenged the judgment and decree. There also, my lords, they have sought the interim prayers.
My lord, my
Now, in view of the appeals are pending, my lords, the first appeals. Now, this execution petitions, my lords, this writ petition is not maintainable.
Yes, what do you say?
My lord, my submission, my lord, no, my lord, after the passing of this order, they have filed one more application for police assistance, my lord. And my lord, that matter is being listed tomorrow, my lord. My lord, for police assistance is granted, my lord, my entire proceeding RFA as well as this petition will become infructuous, my lord.
You
My
are the subsequent purchaser.
No, I am not I am the one of the legal heir of the William. I am the first 5 children.
Then you have already sold the property.
Well, I am not only with regard to item number 3, my lord. That is my absolute property of the petition number 1, my lord. That has been.
Contest property and
there are
contest in the RF only.
my lord, there are 2 more properties are there, my lord. There are scheduled item number 1 and 2 properties are there, my lord.
Council.
My lord, I sought for my lord interim protection, my lord.
Shivshankar has entered appearance for
1 and 2.
Respondents number 1 and 2. Are you filing a memo for a dispensation of notice to the others?
My lord, they are the tenants, my lord, tenants in possession.
Issue
And my-
notice to the other respondents.
Please, my lord.
The petitioners are also permitted to serve copies of the petition along with annexures on the learned counsels representing the respondents before the trial court. Full stop. Next para. Learned counsel Shri K. Shivshankar submits that a similar petition filed in WP number 19336 of 2024 has been listed along with this petition today. Full stop. No interim orders have been granted by this court in the said petition on the ground that the petitioners or the judgment debtors have filed a regular first appeal which is pending consideration before this court. Full stop. It was therefore directed that appropriate orders may be secured at the hands of this court in the pending RFA. Full stop. Next para.
My lord, till my application is considered in the RFA, my lord. Interim protection, my lord.
ಇವತ್ತು pass over ಆಗಿದೆ. Today it
At
is
least, my
passed
lord, tomorrow, my lord, delivery warrant has already been issued, my lord.
The learned counsel would further submit that the said RFA has been listed today before the court. Full stop. Next para. Release this matter on 22nd of August.
Non-compliance for office objection, first time.
2
Serial number
weeks
28, 15 BS. Serial number
for
29.
complaints of office objections.
Serial number 29.
Two weeks, same order.
Serial number 30, Nandish Gowda, GB.
Same order.
Non-compliance for second time. Serial number 31. Yes, Vishwaji Shetty.
Matter is called out. There is no representation for the petitioner, full stop. Nevertheless, a week's time is granted for complaints of office objections.
Non-compliance for third time. Serial number 32, Somshekara, Naidu B.
Same order.
Non-compliance for fourth time. Serial number 33, Prabhakara SK.
Same order. Fourth time idu.
Fourth time.
What is order sheet put? Release this matter on 14th of August. Full stop. If office objections are not complied, the writ petition will be dismissed.
Orders. Serial number 34. Hari Krishna Yasola, PF for R2 second time.
A week's time is granted to the petitioner to take fresh steps for service of notice on respondent number 2 while furnishing the correct address.
35, N Kumar.
A week's time anta helidna 2 weeks madi. Yes.
Serial number 35, N Kumar, FEF for respondent second time. Serial number 35, N Kumar.
Same order.
Serial number 36, KS Ramesh, FEF 11, 14, 16 for second time.
Finally, 2 weeks are granted to the petitioner to take fresh steps for service of notice on respondents number 11, 14 and 16 while furnishing the correct address. Full stop. At the same time, steps will have to be taken to bring on record the legal representatives of deceased response number 15 and 18.
Serial number 37. M. Srinivas Murthy, FEF R4 second time. Serial number 37.
Finally, 2 weeks time. Yes.
38, MR Vijay Kumar, FEF 2, 3, 4 and 5 for second time.
It was finally 2 weeks time.
Serial number 39, Girish P. Baladare, FEF R10 third time.
It was finally 2 weeks time.
Serial number 40.
In a day's time, my lords, I'll do the needful, my lord. There is some objection with respect to the deficient process fee, my lord.
40.
Learned counsel for the petitioner submits that the needful will be done in the office during the course of the day. Yes. If process fee is paid, office is directed to issue notice. Yes.
For petition,
41, Om Kumar.
for petitioner.
No, filed by petitioner, not pressing writ petition.
Yes, sir. Because the original suit is already disposed of. The June. This petition will become infructuous.
The petitioner and learned counsel for petitioner have filed a memo dated 24/2023 stating that the petitioner does not press the writ petition. Suit dispose of since the suit, original suit out of which the writ petition arises has been disposed of.
Yes,
Stop. Next para. The memos taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition stands dismissed as withdrawn.
Macho.
42. Chandra Tarika K, FF, or 1 to 8. First time. Serial number 42.
A week's time is granted for taking steps for service of notice on the unserved respondents.
43. Kamdolli Manjula Devi.
Petitioner in this case, my lord, notice is not served to respond number 3, 4 and 7. 4 is dead, my lord. The respond number 3 and 7, my lord, they placed the expert before the trial court. And my lord, they are not necessary to the disposal of the case, my lord, because
File a memo then.
I have filed a application for dispensation, my lord.
Application act.
Memo for dispensation. IA for dispensation, I have filed it. They are not necessary parties. They are placed expert. Devamma, she is sister of late Javre Gowda. Only contesting parties are respond number 1 and 2. Suit for
Order on IA number 1 of 2023. This application has been filed by the petitioner seeking dispensation of notice to response number 3, 4 and 7.
Yes, ma'am.
Full stop. Learned counsel submits that the said respondents have been placed ex parte before the trial court and no relief is sought against them in the writ petition.
No, my lord.
Huh?
No, my lord.
Full stop. Next para. At the risk of the petitioner, notice to respondents number 3, 4 and 7.
7.
Is dispensed with.
Please.
Forty-four. Sigmalappa, PM, FF, R3 for second time.
Lordship, I need a week time, Lordship.
A week's time is granted at the request of learned counsel for petitioner for taking steps for service of notice on respondent number 3.
45.
For the petitioner.
Same order.
Yes, Your Lordship.
In respect of respondent number 6. And to take steps to bring the legal representatives of deceased respondent number 1 on record. So 2 weeks, ma'am. 2 weeks.
Right.
Yes.
46.
That's week's time to take first steps, my lords.
46,
Weeks.
Giridhar SV.
Week's time to take fresh steps, my lords.
A week's time is granted at the request of learned counsel for petitioner to take steps for service of notice on respondent number 1.
47. Sigmalappa.
For the petitioner, Your Lordships.
FF.
Week's time.
Week's time, Your Lordships.
Yes. For taking steps in respect of response number 3.
3
3
to 12.
3 to 12.
Yes, Your Lordships. Lordship, in WP number 240 of 21 ನಲ್ಲಿ
270.
270 of 21 ನಲ್ಲಿ ನಾವು ಫೈಲ್ ಮಾಡಿರೋ ವಕಾಲತ್ ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೋತೀವಿ ಸ್ವಾಮಿ. ಅದು ಸ್ವಲ್ಪ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ.
But file wakalat for whom?
For
In respect of petitioner.
R4, 5 ಮತ್ತೆ 6 ಗೆ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ. ಅದನ್ನ ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೋತೀವಿ. R4 to 6.
Is returned with office objection representing respondent number 4, 5 and 6.
Yes, Your Lordships. ಅದ್ ಮಿಸ್ಟೇಕ್ ಹಾಕಿದ್ದಾರೆ. ಸೊ ಅದು ಬೇರೆಯವ್ರ ಕಡೆಯಿಂದ ಹಾಕ್ಸ್ತೀರಿ ಅಂತ ಹೇಳಿದ್ರು ಸೀನಿಯರ್ಸ್. ವಿಲ್ ವಿತ್ಡ್ರಾ ದಟ್ ಆನ್ ದ ನೆಕ್ಸ್ಟ್ ಡೇಟ್.
Allama, what are you saying that R4 and 4, 5 and 6 ನೀವು
Yeah.
ಮುಂಚೆ ವಕಾಲತ್ ಹಾಕಿದ್ರಿ
ಹಾಕಿದ್ದಾರೆ your lordships.
ಬೇರೆಯವ್ರು ಯಾರು ಹಾಕಿದಾರಾ?
No, your lordship, we have filed it. The thing is, we will withdraw that wakalat
Ah.
on the next date. That's all, your lordships.
You cannot be permitted to withdraw your wakalat like that.
ವಕಾಲತ್ ಯಾರಿಗೆ ಹಾಕಿದ್ದಾರೆ ನೋಡಿ
4, 5 and 6.
ನೋಡಿ ಇಲ್ಲಿ ಕಾಸ್
Response number 4, 5 and 6.
ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಪಿಟಿಷನರ್ ಅಂತೆ.
ಅದು ತಪ್ಪು. ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ PM ಸಿದ್ಮಲ್ಲಪ್ಪ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4 to 6 ಅಂತಿದೆ. ಇಲ್ಲೂ ಅಷ್ಟೇ ಕೆಳಗಡೆ ನೋಟ್ ಅಲ್ಲಿ ರೆಪ್ರೆಸೆಂಟಿಂಗ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4, 5 and 6 ಅಂತ ಇದೆ ಕರೆಕ್ಟ್ ಆಗಿ.
Lordship, I was told that WP is 7280 of 23 ಮತ್ತೆ ಇದು ಎರಡು connected case. WP 7280 ಅಲ್ಲಿ ನಾವು petitioners ಇದೀವಿ ಯಾವಾಗ್ಲೇ.
ಹೌದು.
So since in this case, I was told that we would be withdrawing the wakalat in the second case, that is WP 270 of 21 ಅಲ್ಲಿ withdraw ಮಾಡ್ಕೋತೀವಿ ಅಂತ.
Conflicting interest
Yes, your lordships, it's conflicting. So if you grant me a week time, I'll rectify that, your lordships.
But you should inform the party. If you simply withdraw the wakalat like this, they should know that you have withdrawn. Ilandra Papa, we have noticed, we have issued notice earlier. Now we'll have to issue notice once again.
But in this case, my lord, the respondent.
Please ensure that some other advocate files wakalat on their behalf.
Yes, your lordship, definitely I'll do that.
The list is between, my lord, the petitioner on the one hand and the respondent number 1 and 2 on the other hand. In the FDP proceedings, my lord.
Problem ಏನಾಗಿದೆ ಅಂದ್ರೆ
ಅಲ್ಲ,
they have filed wakalat
please
on behalf of the petitioner in the connected writ petition.
please
ಈ writ petition ಅಲ್ಲಿ
respondent.
whether the same parties are respondents number 4, 5 and 6 or they are different parties. ಅದೇ ಕನ್ಫ್ಯೂಷನ್ ಆಗಿರೋದು. It will be conflicting interest if they are filing wakalat on behalf of the other party.
Your lordships.
Not in
Let them clarify it. We do not know.
writ petition 270 of 21. Not an application is filed seeking for vacating the stay. But it is on the application filed by the petitioner Shanta Amma seeking for the to get her imputed as the one of the respondent in the FDP proceeding. That has been rejected. But against which one the writ
ಅದರಲ್ಲಿ ಇವರು ವಕಾಲತ್ ಹಾಕಿರೋದು ಯಾರಿಗೆ? 4, 5 and 6. Who is that?
They are not contesting parties, my lord. It is the respondent.
Who is this petitioner in the other writ petition 7280?
No, I am not appearing in the connected.
He is appearing, sir. Sidmallappa is appearing. So whether there is conflict of interest, I do not know. That is why they are saying they want to withdraw the wakalat. But then you will have to ensure that some other council files wakalat.
I'll definitely do that, your lordship. by
Please
next
tell
week.
the party or let the party come before the court
Yes, your
on the
lordship.
next date of hearing.
Yes, your lordships, definitely.
As regards the office note put up in the connected writ petition, WP number 270 of 2021, that office objections have been raised in respect of the wakalat filed by Shri PM Sidmallappa, who has filed wakalat for response number 4, 5 and 6, learned counsel Shri PM Sidmallappa is requested to ensure that alternative arrangements are made by the parties. Full stop. Release this matter on 14th of August. ಅಲ್ಲಿ ಎಷ್ಟು ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀವಿ ನಾವು?
1 week.
Taking steps 1 week ತಾನೆ ಆಯ್ತು. ರಿಲೀಸ್ ದಿಸ್ ಮ್ಯಾಟರ್ on 14th of August.
Number 48, Savant BS.
None of the defendants are the parties in OS number 1128 of 2019. That's why we are not made as them as a party. And
Dependents number 1 to 7
Yes,
Invoice number 333 of 2016 are not made parties. Why?
yes, Your Honor, the application had been rejected in OS number 1128 of 2019.
Huh?
The application, that is IA number 3, where the writ petition is preferred, is filed against the order passed in OS number 1128 of 2019 on IA number 3, and none of the defendants are parties in OS number 1128 of 2019. And there is no relief against those defendants. That's why they are not made as a party, Your Honor.
This writ petition arises out of OS number 1128 of
1128 of
2019.
2019.
Only these defendants in the other suit are not parties.
No. They are not parties.
Which is the impugned order?
IA number 3, Your Honor, that is for 151 application for clubbing both the cases.
Which is the where is the impugned order?
Page number 54, Your Honor. That is CIA. And then page number 59. Orders on IA number 3, annexure H.
Regarding office objections, Common Learned Counsel for the petitioner submits that this writ petition arises in OS number 1128 of 2019 and therefore the defendants in OS number 333 of 2016 cannot be made parties in these proceedings. Full stop. The submission of the Learned Counsel for petitioner is accepted. Office objection is overruled. List this matter.
Your Honor, can I move?
Huh?
You want to move on? Your
Ah,
Honor,
yes.
it's a suit for declaration and possession. Earlier, the petitioner herein had filed a suit bearing number 3333.
Declaration and possession.
Declaration and possession with respect to scheduled properties in OS number 333 of 2016, Your Honor. Later on, the respondent herein.
You know,
Declaration and possession.
Declaration.
Possession.
Yeranta declaration.
Declare that she is entitled for she is the owner, absolute owner of the suit scheduled properties. And later on, in the year 2019, the respondent herein had filed a suit for bare injunction with respect to item number 1 of the suit scheduled property in OS number 333 of 2016, Your Honor. And after filing of
That's a older one.
no, 2016 was the
3 of 2016 adu.
2016 only
to 2019.
2019 ali. And after filing of the respondent file ಮಾಡಿ ತಕ್ಷಣ suit na, the respondent was impleaded. I filed an application under 1 Rule 10(2) and made she as a party, and the Honorable Trial Court had allowed the application, and respondent herein was impleaded as defendant number 8 in OS number 333 of 2016. Subsequently, then I prefer an miscellaneous application to transfer the case. That is OS number 1128 of
filed 333 of 2016.
Yes, I have filed the petitioner herein.
Ah.
And OS number 1128 of 2019 was filed by the respondent for bare injunction. Later on, after filing of the suit, I preferred an application, that is the petitioner, preferred an application under 1 Rule 10(2) to implead the respondent as one of the defendant in OS number 333 of 2016. And the same was allowed. After allowing the application, I preferred an miscellaneous appeal under section 24 to transfer the case. That is, both was in different courts, transfer the case. And the same was allowed by the order passed by MA number 9 of 22, Your Honor. And there, the Honorable District Court had clearly, in page number 51, it has observed that the petition filed by the petitioner under section 24 of CPC is hereby allowed. Consequently, the suit in OS number 1128 of 2016, pending on the file of second civil judge, JMFC, Mysore is ordered to be withdrawn and transferred to the court of 8th Additional Civil Judge JMFC, Mysore, to try along with OS number 333 of 2016. Based on this order, I filed an application under 151 to club both the cases.
ತಿರ್ಗಾ ನೀವೇನ್ರಿ ಅಪ್ಲಿಕೇಶನ್ ಕೊಡೋದು ಕ್ಲಬ್ಬಿಂಗ್ಗೆ? There is already an order.
Yes, but the court doesn't implement me. ನಾನು ತಗೊಳ್ಳಿಲ್ಲ submission. They advised to make an application. I filed an application under 151 to club both the cases, and that application was rejected.
Which is the impugned order?
That is in page number 59, Your Honor. 59 and 61, orders on IA number 3. And the reason is in 63, and point number 1, Your Honor, paragraph 8. There, the court has observed that on perusal of the plaint and written statement and IA number 3, averments and also documents available and record, it is seen that the suit schedule property in present suit is the house property bearing number door number 302/1, site number 10, property number 35, 35/6, situated at second cross Krishna Nagar, and second stage so and so Mysuru city, and bearing so and so, Your Honor, in land property measuring 5 guntas, and it is also observed in the same line, Your Honor, in OS number 333 of 2016 for declaration and possession. It is further seen that the suit schedule site number is carved out of 35/5, 35/6, but the suit schedule property in OS number 333 of 2016 carved in survey number 35/6 only. The observation made by the trial court is also same, that suit schedule property is carved out in 35/6, Your Honor. Even by making such observation, the application had been rejected.
Already, but there is an order passed by the PDJ.
Yes, that order had been not considered by the trial court, Your Honor.
Not considered.
Even I filed the memo with the order sheet. Everything had been filed before the trial court. And in para 9 also, the district court had clearly made observations,
There
Your
will be
Honor.
need for you to file this application when they're already passed by the PDJ.
Yes, but the trial court doesn't oblige my submission.
Our ಏನ್ರಿ oblige ಮಾಡೋದು? Office ಅವರು they will place the suit before that court in terms of the directions.
But ಮಾಡ್ಲಿಲ್ಲ, Your Honor.
Then you should have gone and complained to the PDJ. How can you file an application and it is not within the powers of that court?
Yes, Your Honor. Even the order in presence of the order, they are not applied.
Where has it noticed the orders of the PDJ? In the impugned order, it has not noticed the order of the PDJ.
They have not noticed, Your Honor.
ಮತ್ತೆ?
Simply they have
We
rejected.
should presume that then the court doesn't know about that order.
Yes, but the certified copy had been filed before the trial
Nothing
court
has been
also.
said in the order.
Yes, they have not filed. And the same court, while allowing the application under 1 Rule 10(2), made an observation that both the properties are equal.
Issue notice to the respondent. The petitioner is also permitted to serve a copy of the writ petition along with annexures from the learned counsel representing the respondent before the trial court. What's up next paragraph? Learned counsel for the petitioner submits that at the instance of the petitioner, the principal district and session judge, Mysuru, has passed an order in miscellaneous petition number 9 of 2022 on 12th of September 2022 directing that OS number 1128 of 2016 is withdrawn from the court of the second additional civil judge and JMFC, Mysore, and transferred to the court of the 8th additional civil judge and JMFC, Mysore, to try along with OS number 333 of 2016. Full stop. That being the position, firstly, there was no need for the petitioner to have filed one more application under section 151 to club OS number 333 of 2016 along with the OS number 1128 of 2019. Full stop. It is also necessary to notice that in the impugned order dated 27/1/2024, 9/2/2024, 9/2/2024, there is no reference. ಇದೆಯಲ್ಲ ಇಲ್ಲಿ ಏನಿದೆ that an objection has sought to be raised by the respondent herein, that although there is an order passed by the principal district and session judge transferring and clubbing the two matters, nevertheless, the 8th additional civil judge and JMFC has upheld the objections raised by the respondent, which would be contrary to the directions issued by the principal district and session judge. We'll stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order dated 27/1/2024 in OS number
1128 of
2019 on the file of the 8th additional civil judge and JMFC and all further proceedings thereto till the next date of hearing.
And in OS number 333 of 2016.
ಅದೆಲ್ಲ ಅವ್ರ ಮುಂದೆ ನೀವು ಅದನ್ನ ನಡೆಸ್ತಾ ಇಲ್ಲ.
ಎರಡು ಒಂದೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ, ಕ್ಲಬ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಷ್ಟೇ ಇವರು.
ಹೆಂಗ್ರಿ ಒಂದೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ? ಎರಡು ಬೇರೆ ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇತ್ತು.
ಎರಡು ಬೇರೆ ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇತ್ತು.
ಇವಾಗ ನೀವು ಬೇಡದೇ ಇದ್ರು ಹೋಗಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ ನಾವು ಟ್ರಾನ್ಸ್ಫರ್ ಆಗ್ತು, ಟ್ರಾನ್ಸ್ಫರ್ ಆದ್ಮೇಲೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಅಂತಂದ್ರು ಕ್ಲಬ್ಬಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಂದ್ಮೇಲೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರು.
There is already a order, sir. You please read that order.
Yes, there is an order, but the trial court is not making any.
And the OS number 333 of 2016 till the next date of hearing.
What?
Yes.
ಅದನ್ನು ಹಾಕ್ಬೇಕು. ಫುಲ್ಲು. ಅದಾದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಅವ್ರು ಈಗ ರೆಡಿ ಫಾರ್ ಈವ್ನಿಂಗ್. ಏನು ಪಾಸ್ವರ್ಡ್ ಆಗೋಯ್ತು. ಎರಡೂವರೆ. ಅದಾದ್ಮೇಲೆ ತಗೋತಾರ ನೋಡೋಣ ಸರ್, ಮಧ್ಯಾಹ್ನ ನೋಡ್ಬೇಕು. ಮಧ್ಯಾಹ್ನ ಕೇಳ್ಬೇಕು ಸರ್. ಯಾವುದು ಇಲ್ಲ, ಎಲ್ಲ ಮುಗಿದು. ಯಾವ್ದು ಪಾಸ್ ಕೇಳೋದ್ರಲ್ಲಿ ಒಂದು ಮೀನಿಂಗ್ ಗೊತ್ತಾಯ್ತಿಲ್ಲ. ಬೋರ್ಡಲ್ಲಿ ಇದೆ 230 ಅಂತ ಇದೆ. ನೋಡಿಲ್ಲ ಸರ್, ಬಿಡಿ. ಯಾವ ಸರ್ ನೋಡ್ಬೇಕದನ್ನ, ನಿಮ್ಗೆ ಹಾಕಿರೋದು
230 serial number 2.
Serial number 19 ಇದೆ.
What of sir? Number 19, 14-8.
What of sir? Serial number 2.
What of sir?
ನೋಡ್ತೀನಿ.
ಮ್ಯಾಟರ್ ಇನ್ಫೆಕ್ಷಸ್ ಆಗಿದೆ ಸರ್ ಅದು. ವಾಯ್ಸ್ ಹಸ್ ಬೀನ್ ಡಿಸ್ಮಿಸ್ಡ್.
Serial number 2 ಸರ್, ಲಿಸ್ಟ್.
ಹೌದು, ಅದನ್ನೇ ಹೇಳ್ತಿರೋದು.
ವಾಯ್ಸ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಇಲ್ಲ ಪೆಂಡಿಂಗ್ ಇದೆ.
ವಾಯ್ಸ್ ಹೋಗಿದೆ ನೋಡಿ, ಅದು ಚೆಕ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದು ಮಧ್ಯಾಹ್ನ ಹೇಳಿ.
31/6/18.
ಆಯ್ತು ಸರ್, ಅದನ್ನೇ.
What of sir? ಹೌದಾ?
ವಾಯ್ಸ್ ಹೋಗಿದೆ
ಹೇಳಿದ್ರು, voice ಹೋಗಿದೆ ಅಂತ
ಹೇಳಿದ್ರು. ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಇನ್ಫೆಕ್ಷಸ್ ಇದು.
ಹೌದು.
What of sir? ಎಲ್ಲ ಮ್ಯಾಟ್ರಸ್ ಅದೇ, ಎಲ್ಲ ವಾಯ್ಸ್ ಹೊಟ್ಟೋಗಿದೆ ಅದು. ಆಲ್ ಮ್ಯಾಟ್ರಸ್ ಇಸ್ ಬಿನ್ ಇನ್ಫೆಕ್ಷಸ್, ಎಲ್ಲ ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ.
ಎಲ್ಲ ರೆಪಿಟೇಷನ್
ಎಲ್ಲ ಮ್ಯಾಟ್ರಸ್
ನಮ್ದು ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ನೋಡ್ತೀನಿ ಸರ್. ಆಯ್ತು.
ಇದ್ರೆ ವಾಯ್ಸ್ ಏನಿದೆ ತಕ್ಷಣ ನಿಮ್ಗೆ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಹೇಳಿ ಕೋರ್ಟ್ ಮುಂದೆ. ಅದ್ರ ಲಿಸ್ಟ್ ಮಾಡಿ ಇಟ್ಟಿದ್ದಾರೆ, ಎಲ್ಲ ವಿತ್ ಲಿಸ್ಟ್ ಇದೆ.
ಇಲ್ಲೇ ನೋಡ್ತೇನೆ ಸರ್.
ನೋಡಿ.
ಕೋರ್ಟ್ ಆಫ್ ಸರ್ ಅವರೇ,
ಹೇಳಿ ಸರ್.
ಈ ಸೀರಿಯಲ್ ನಂಬರ್ 66 ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಟೈಮ್ ಏನಾರ ತಗೊಂಡಿದ್ದಾರಾ?
66 ಯಾವ್ದು ತಗೊಂಡಿಲ್ಲ ಅಂತ ಕಾಣಿಸ್ತೀವಿ ಸರ್.
66 ಬಿ ಗ್ರೂಪ್.
ಇಲ್ಲ ಸರ್.
ಇಲ್ವಾ?
ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಿರೋದು ಮಧ್ಯಾಹ್ನಕ್ಕೆ 2:30 ಫಸ್ಟ್, ಅದಾದ್ಮೇಲೆ ಕಂಟಿನ್ಯೂಷನ್ ಅಲ್ವಾ
ಸರ್? ಸೀರಿಯಲ್ ನಂಬರ್ 48 ಸ್ಟೇ ಆಯ್ತಲ್ವಾ?
ಈ 230 ಲಿಸ್ಟ್ ಮುಗಿದ ಮೇಲೆ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಬರ್ತಾರಾ?
ಜನ ನೋಡ್ಬೇಕು ಸರ್, ಗೊತ್ತಿಲ್ಲ ಸಾಹೇಬ್ ಹೆಂಗ್ ತಗೊಂತಾರ.
ಓಕೆ.
ನಮ್ದು OS ನಂಬರ್ ಅದಲ್ಲ ಸರ್, ಅದ್ರಲ್ಲಿ ಏನ್ ನೋಡ್ತಿದೆ ನಿಮ್ಗೆ ಡಿಸ್ಪೋಸ್ ಅಂತ ನೋಡ್ತಿದಲ್ಲ, ಆ OS ಅಲ್ಲ ನಮ್ದು. ಕಾಪಿ ತಗೊಳ್ತೀನಿ, ಸ್ಟೇಟಸ್ ಕಾಪಿ ಸ್ಟೇಟಸ್ ತೆಗ್ಬಿಟ್ಟು ಕೊಡ್ತೀನಿ ಅಷ್ಟೇ ಸರ್. ಏನಂದ್ರೆ ಅದೇ ಇದ್ರ ಪ್ರಕಾರ ನೋಡಿದೆ, ಇಲ್ಲಿ ಬೇರೆ ನಂಬರ್ ಇದೆ OS ನಂಬರ್. OS 58656 ಅಂತ ಇದೆ, ಬಟ್ ನಮ್ದು OS ನಂಬರ್ ಆನೇಕಲ್ಲು.
ಯಾವ OS ಮೇಲೆ ಇಲ್ಲಿ ಬಂದಿದ್ದೀರಾ ಅದು ಇಂಪಾರ್ಟೆಂಟ್.
ಹೌದು, ಇದೇ OS ಮೇಲೆ ಬಂದಿರೋದು ನಾನು ಇಲ್ಲಿ. OS 658/2006.
ಹೇಳಿ ಅಲ್ಲ.
ಓಕೆ ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಸರ್. ಹಾ ಹೌದೌದು ಸರ್. ಸರ್ ಅದಲ್ಲ ಆಫ್ ಸಬ್ಜೆಕ್ಷನ್ಸ್ ಏನ ಅಂತ IA OS ನಂಬರ್ ಸ್ಟಾರ್ಟಿಂಗ್ 649/3 ಅಂತ ಕೊಡ್ತಾರೆ, ವಿಚ್ ವಾಸ್ ರೀನಂಬರ್ಡ್ ಆಸ್
OS ನಂಬರ್
658 ಸರ್. ಇವಾಗ ಪ್ರೆಸೆಂಟ್
ನೋಡಿ ಡಿಸ್ಮಿಸ್ಡ್.
ಅದೇ ಇದ್ರಲ್ಲಿ ನಾವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇದ್ರಲ್ಲಿ ನೋಡಿದ್ರೆ ಪಿಟಿಷನ್ ಅಲ್ಲಿ
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 14
ಓವರ್ಸೈಟ್ ಅದು ಕೊಡ್ದು 5856 ಅಂತ ಹೊಡೆದ್ರೆ ಡಿಸ್ಪೋಸಲ್ ಅಂತಾನೆ ಬರುತ್ತೆ. ಬಟ್ ನಮ್ ರಿಟ್ ಪಿಟಿಷನ್ ಕಾಪಿ ತೆಗೀರಿ ಸರ್, ಅದ್ರಲ್ಲಿ ನೋಡ್ರಿ ನಿಮ್ಗೆ ನಾನು OS ಚಾನೆಲ್ ಮಾಡಿರೋದು 658/6 ಕ್ಲೈಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಬಟ್ ಅನೆಕ್ಷರ್ ಆರ್ಡರ್ ಬಂದು ಅನೆಕ್ಷರ್ A ಸರ್, OS 658/6 ಅದ್ರ ಕ್ಲೈಂಟ್
2006. ಅದಾ
ಇದ್ರಲ್ಲಿ ಅದೇ ನಾನು ನೋಡಿದೆ, ನಾನು ಇವಾಗ ಡಿಸ್ಪೋಸ್ ಅಂತಾನೆ ಬರ್ತಾ ಇದೆ. ನಾನೇ ಸರ್ 6/17 ಮೇಲೆ ಬಂದಿರೋದು.
5856 ಏನಂದ್ರೆ
ಅದೇ ಅದು ನನಗೂ ಗೊತ್ತಾಗ್ತಲ್ಲ ಹಿಂಗೆ ಅಂತ. ಅದು
ನಿಮ್ಗೆ ಯಾವ್ದು 5856 ಯಾವ್ದು?
ಅದು ಯಾವ್ದಿಲ್ಲ ಸರ್, ನಮ್ಮ ಪಾರ್ಟಿಸೇ ಎಲ್ಲ ಅನ್ಸುತ್ತೆ.
ಬಟ್ ಅಲ್ಲೂ ಪಾರ್ಟಿ ನೇಮ್ ಸೈಯದ್ ಶ್ರೀದ್ ಅಂತ ಬರುತ್ತೆ. ಪಾರ್ಟೀಸ್ ನೇಮೇ ಡಿಫರ್ ಸರ್.
Respondent Hemalata, Syed Irshad Ahmad.
ಹಾ, ಈ ಪಾರ್ಟೀಸೇ ಬೇರೆ, ಆ ಪಾರ್ಟೀಸೇ ಬೇರೆ. ಮೋರ್ ಓವರ್ ಸಿಟಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅದು. ಇದು ನಮ್ದು ರೂರಲ್ ಕೋರ್ಟ್ ಬೆಂಗಳೂರು ಆನೇಕಲ್.
Change ಮಾಡಿ ಅದು ಹೇಳಿ.
ಸರ್ ಆಮೇಲೆ ಅದು IM ಏನ್ ಆಫ್ ಸಬ್ಜೆಕ್ಟ್ಸ್ ಅಂತ ನಾನು IM ಒಂದು ಹಾಕಿದ್ದೀನಿ.
ಕಾಪಿ ಸರ್ ಮಾಡಕ್ ಹೇಳಿದ್ದಾರೆ. ಅಫಿಡವಿಟ್ ಕಾಪಿ ಹಾಕಿ.
ಸರ್ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದೀನಿ,
ಮಾಡಿ.
ಸ್ವೇರ್ ಮಾಡಿಲ್ಲ ಸರ್. ಸ್ವೇರ್ ಮಾಡಿಲ್ಲ ಹಂಗಂದೆ ಸರ್. ಇವಾಗ ಈಸ್ಕೊಂಡು ಮಾಡ್ಕೋಬೋದಾ?
ಎರಡಕ್ಕೆ ಎರಡು ರಿಜಿಸ್ಟರ್ ಕೇಳಿ.
ಓಕೆ ಸರ್, ಆಯ್ತು. ಬಟ್ ಇದ್ರ ಬಗ್ಗೆ ಹೇಳ್ತೀನಿ.
ಇದು ಮೆನ್ಷನ್ ಮಾಡಿ ನೀವು ಅದು. OS ಹೆಂಗ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ನಮಗೂ
ಸರ್ ಆಮೇಲೆ ಅದನ್ನ ನೋಡ್ರಿ, ಬೇರೆದಲ್ಲ ಅಸ್ಮತ್ ಏನೇನ ಎಲ್ಲದಲ್ಲೂ ಆ ಥರ ಏನೇನು ಆಗಿದ್ದ ಅಂತ.
ಹಂಗೇನಿಲ್ಲ, ಇದ್ರೆ ಹೇಳ್ಬೇಕಾಗತ್ತೆ ನೀವು
ಅಷ್ಟೇ.
ಅದಕ್ಕೆ ಕರೆಸಿರೋದು. ನಾವ್ ಮಾಡಕ್ಕಾಗತ್ತ ಕೆಲಸ? ಇದು ಹಾಕಿರೋದೇ ಅದು. ಯಾರು ಬಂದಿಲ್ಲ ಅದು ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ, ಇಲ್ಲಾಂದ್ರೆ ಯಾವ ಟು ಮೆನ್ಷನ್ ಇಟ್ ಅಷ್ಟೇ. ಅದು
ಓಕೆ, ನಾನು ಮೆನ್ಷನ್ ಮಾಡ್ತೀನಿ ಬಿಡ್ರಿ. ಸ್ಟೇಟಸ್ ಒಂದು ತಗೊಂಡು ಕೊಟ್ಬಿಡ್ಲಾ?
ಹಾ ಸ್ಟೇಟಸ್
ತಂದು ಕೊಟ್ಬಿಡ್ತೀನಿ. ಅದು ಬೆಟ್ರ್ ಅದೊಂದು
ನೋಡಿ, ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಈ ಸ್ಟೇಟಸ್.
ಗೊತ್ತಾಯ್ತು ಸರ್. ಅದಕ್ಕೆ ಆ ಸ್ಟೇಟಸ್ ಇದೆ, ಅದಕ್ಕೆ ನನ್ನ ಸ್ಟೇಟಸ್ ನಾನು ಏನಿದು ಕೇಸ್ ಇದೆ
ಅದನ್ನ ಕೊಡಿ.
ಕ್ಲೈಂಟ್ ಜೊತೆ ಇದೆ.
ಬಟ್ ಈ ಕೇಸೇ ಇಲ್ವಲ್ಲ, OS ಹೆಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ನನ್ಗೂ ಗೊತ್ತಾಗ.
ಪಾರ್ಟೀಸು ಡಿಫರ್ ಆಗ್ತದೆ.
ಕೇಳಿಸ್ಬಿಟ್ಟು ಕೇಳ್ತೀನಿ ಅದನ್ನ.
ಇಲ್ಲ ಸರ್, ಅವರು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಡೀಟೇಲ್ಸ್ ಅಂತ ನಾನು ಇವಾಗ ಇದ್ರಲ್ಲಿ ಹೋದೆ ಹೈಕೋರ್ಟ್ ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ. ಈ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಡೀಟೇಲ್ಸ್ ಅಂತ ಹೋಗ್ತಿದೆ, ಬಟ್ ಆ OS ನಂಬರ್ ನೋಡ್ತಿದೆ ನನಗೆ. ಇವಾಗ ಇದನ್ನ ಒತ್ತದೆ, ಇಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಡೀಟೇಲ್ಸ್ ಅಂತ ಬರುತ್ತೆ, ಅದೇ ಬರುತ್ತೆ. ಅವಾಗ ನೋಡ್ರಿ, ಇಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಡೀಟೇಲ್ಸ್ ಅಂತ ಕೊಟ್ಟು ಏನ್ರ ಮೇಲೆ ಬಂದಿರೋದು ಅಂತ ಅಲ್ಲ. ಅವಾಗ OS ನಂಬರ್ 56 ಅಂತ ಬರ್ತಾ ಇದೆ. ಆಕ್ಚುಲಿ ನಮ್ಮ ನಂಬರ್ ಹಾಕ್ಬೇಕು, ಇವ್ರು ಹೆಂಗ್ ಹಾಕಿದಾರೋ ಅದು ಗೊತ್ತಿಲ್ಲ. ಕಂಪ್ಯೂಟರ್ ಅವ್ರು ಮಾಡೋವಾಗ ಮಿಸ್ಟೇಕ್ ಏನೋ.
OS 5856
ಬರ್ತಾ ಇದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಡೀಟೇಲ್ಸ್ ಅಲ್ಲಿ ಹೊಡೆದೇನು. ಅದಕ್ಕೆ ಅವ್ರು ಏನ್ ಮಾಡಿದಾರೆ ಅಲ್ಲಿ ಒತ್ತಿದೆ ಡಿಸ್ಪೋಸ್ ಅಂತಾನೆ ಬರುತ್ತೆ. ಬಟ್ ಅವ್ರ ಆಫೀಸರ್ ಚೆಕ್ ಮಾಡ್ಬೇಕಾಯ್ತು, ಈ ಕ್ಲೈಂಟು ಈ ಕಾಪಿ ನೋಡಿದಿದೆ ಗೊತ್ತಾಗ್ತಾ ಇತ್ತು. ನಾನು ಸ್ಟೇಟಸ್ ತಗೊಂಡ್ಬಿಟ್ಟು ಸರ್ ಇಂಥ 220 ಸ್ಟಾಕ್
ಬರ್ತಾರೆ ಹೇಳಿ. ಮೆನ್ಷನ್ ಮಾಡಿ, ಇದನ್ನ ಮೆನ್ಷನ್ ಮಾಡಿ.
ಹಾಂ ಸರ್.
So, I have been registered with the Karnataka High Court. I'm from Bombay, but while I'm trying to log in through VC, I'm not getting the.
What do you require, madam?
List number 2.
My lord, list number 2, serial number 23, the infectious, my lord.
Serial number?
23, my lord.
Serial number 23. Learned counsel for the petitioner has filed a memo stating that the original suit out of which the writ petition arises has been disposed of, and therefore the prayer made in the writ petition has become infructuous. Full stop. Next para. The memo is taken on record subject to all just exceptions. Accordingly, the writ petition stands dismissed since the prayer made in the writ petition has become infructuous.
Much of obliged.
Same order. 6.
Serial number 16, my lord. Memo.
Serial number?
16.
16. The original suit has been disposed of. Ali memo beda learned counsel for the petitioner submits. Same order.
Serial number 28, my lord.
The submission of the learned counsel for petitioner is placed on record.
Serial number
Serial
20.
number 11, my.
11. Same order.
No, my lord. We have
That's-
taken steps in that. It's for posted for orders. We've taken steps in the matter, my lord. It's coming up for third time. We'll take people.
Please take instructions as to whether the suit has been disposed of.
No,
All these matters are listed.
Yes.
Since it is the office has found that the suit have been disposed of.
Please.
Please take instructions.
Serial number 2, my lord, list 2.
Huh?
Serial number 2, list 2.
Disposed of.
It's not, my lord, it's not disposed.
Huh?
I'm giving the status of the trial court pending.
Not
It's pending.
disposed of.
Yes, my lord. But oversightlly in OS number 5868 has been taken, ma'am.
We'll call it up. We'll call it up.
Serial number 28, my lord.
We'll call
Serial number 28,
Yes.
appearing for the respondent. Infractious also. Dismiss agade.
8.
Also. WP 51809 of 19.
Learned counsel for the
Respondent.
contesting respondents. Antakoi. Huh? Yes.
20.
20.
Arises out of execution proceedings.
Ah.
The proceedings are closed on 1/12/20.
The execution proceedings have been closed.
Please.
Huh?
Serial number 15 minutes. I am for the respondent. I will ascertain whether the matter is disposed of, whether the suit is disposed of now.
My lord, I appear for petitioner in serial number 15. It is pending, my lord. It is next hearing date is 28/8
Pending.
before the trial court. It is pending, my lord.
We'll call out those matters.
Next.
We'll call out those matters and adjourn it. So Ishtana?
My lord, serial number 9, my lords.
Yes,
The matter has been disposed of.
disposed of. Serial number 9. Pariri.
List number 2 for order serial number 1. HR Ananta Krishnamurthy.
My lord, for the petitioner, weeks time, my lord, to take steps.
Allari, whether the
ಇಲ್ಲ, my lord, pending ಇದೆ, my lord. It's
Pending,
pending, it's pending. Section 24 application, my lord, miscellaneous ಹಾಕ್ಬಿಟ್ಟು tried in same matter.
it has been disposed of.
It's the other matter, my lord.
Huh?
It's the other matter which the respondent has
ಯಾವ್ದು?
filed. ಇದು ಬಂದ್ಬಿಟ್ಟು 333 ಅಂತ. Lord, OS number 3333 of 16.
Miscellaneous. Miscellaneous than.
Yes, my lord.
Miscellaneous also is disposed of.
My lord, miscellaneous was filed to club two suits, my lord, which pertain to the same property. So the miscellaneous was disposed of. We have challenged that order.
You challenge that order.
Yes, my lord. Section 24 are late to be heard because the subject matter is pertains to the same property.
A week's time is granted at the request of learned counsel for petitioner to furnish the correct address and take steps for service of notice on respond number 2.
Yes. Public.
Serial number 2,
For petitioning,
Nibandan G.
trial court is not, it does not dispose, madam. I'm giving the status of the trial.
What is
OS number wrongly mentioned.
Huh?
In this OS number wrongly mentioned.
ಪ್ರಕಾರ ಯಾವ್ದು OS number?
ನನ್ನ ಪ್ರಕಾರ OS number 658 of 6, my lord.
658.
658. I'm giving the status of the trial court. Case status, they given a OS number 5886 of 15, but it's a different case number, my lord. Our case is OS 658 of 6, my lord. Part is also different.
Section raised on IA number 1 of 2023 for amendment filed by the petitioner.
I have served the copy.
Huh?
I have served the copy and the other.
When
the-
you served or you want to
No.
serve? A week's time is granted at the request of learned counsel for petitioner to comply with the office objections raised on IA number 1 of 2023.
I given the steps, I taken steps for the response number 3, my lord. I paid this process.
Full stop. If steps have been taken by the petitioner for service of notice on respond number 3, office is directed to issue notice.
And my lord, memo has been filed. Petition number 1 and 2 has been tied. Their LRs are petition, other petition and respond number 3, my lord. Petition number 1 and 2 has been tied, my lord. Regarding that, I gave filed a memo.
That will pass orders on the other side coming. Yes.
Serial number 3, Amshi Tegade, MS. Serial number 3,
It appears matter is called out. There is no representation for the petitioner. Full stop. However, it appears that the execution case from which the writ petition arises, namely execution petition number 366 of 2017, has been disposed of on (23 to 2023). And therefore, the prayer made in the writ petition has become infructuous. Consequently, the writ petition stands disposed of for the reasons stated above.
serial number 4,
This case, my lordship,
Girish B.
I filed the
Bhattacharya.
writ petition against the dismissal of the impleading application in RA, my lordship. OS is disposed of. RA is pending for adjudication, my lordship. RA 40/2017.
Ah.
In the RA, I make an application for impleading application against which I prefer the writ petition, my lordship.
Howda?
RA is pending, my lordship.
A week's time is granted at the request of learned counsel for petitioner to take steps for service of notice on respond number 2.
Interim order may be extended, madam.
Interim order granted earlier stands extended. ಆರ್ಯನು ಕ್ಲೋಸ್ ಆಗಿದೆಯಲ್ಲ.
ಆರ್ಯ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ ಸರ್, ಐ ವಿಲ್ ವೆರಿಫೈ ದಟ್. ಆರ್ಯ ಬೇರೆ ಕೋಟಿ, ಫ್ಯಾಮಿಲಿ ಕೋಟಿ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ ಸರ್.
Yes.
Serial number 5. Ajesh Kumar, yes. 5.
My lords, I appear on behalf of the petitioner in this matter, my lords.
The suit has been disposed of.
The suit has been disposed of, my lords, in view of the impugned order, which is what I have challenged, my lords. So therefore, the writ petition survives, my lords.
Huh?
The writ petition survives, my lords, because the order which is impugned is the application filed under Section 8 of the Arbitration Act, my lords. My respectful submission is that the Section 8 application could not have been filed because it was a summary suit. And whether it can be filed before the leave to defend is allowed, or it can be filed only after the leave to defend application is allowed, is a matter before consideration, my lords. Therefore, I request for a week's time to
Impugned order is Annexure A, is it?
Annexure A, my lords.
Annexure A.
Please, my lords. It begins at page 9 and at page 17, my lords. The suit is dismissed as non-maintainable in view of the arbitration clause. My respectful submission is that, my lord, I am impugning this order, saying that my dispute is separate from what is contained in the shareholders agreement, and also that the Section 8 application could not have been filed in view of the leave to defend not having been allowed, my lord. So therefore, there's a legal issue involved.
Matter is called out. There is no representation for respond number 1 and 2. Full stop. However, learned counsel Shri Sunil Paul, who has filed wakalat on behalf of the said respondents, is required to comply with the office objections raised on the wakalat. A week's time is granted to do the needful.
6 order pass, serial number 7. Shivkumar V.
Matter is called out. Same avagale ಹೇಳಿದ್ನಲ್ಲ ಒಂದು. However, it is found that the original suit out of which the writ petition arises, namely OS number 176 of 2019, was disposed of on 9/10/2019. ತಿಂಗಳು ಆಗುತ್ತೆ. OS 176. Right, disposed of.
Serial number 8. Vijay Kumara.
Extra paper, the petition, 6 weeks time to take the step.
This petition arises out of execution petition, huh?
Yes, ma'am.
Huh?
Yes, ma'am.
Execution petition has been disposed of.
Petition dead ಅಂತ ಬರ್ತಾ ಇದೆ. I will have to verify them.
Adalri, the execution case itself is disposed of.
I will clarify the things, my lord.
I've got information, sir. That is why we listed all these matters. ಯಾವ ವರ್ಷ ರೀ ಇದು? 87/2000. Huh? Well, disposed of date of decision 8/7/2000. ಯಾವತ್ತು ಕ್ಲೋಸ್ ಆಗಿರೋದು? Learned counsel for the petitioner is requested to find out as to whether the execution case from which the writ petition arises has been disposed of by the execution court. Full stop. Information made available to this court is that the execution case has been disposed of on 8/7/2000. Full stop. Release this matter on 14th of August. Yes.
Serial number 9, order passed. Serial number 10, Narasimhamurthy GV.
1 week time.
Dispose ಆಗಿದೆ ನೋಡ್ರಿ ಮ್ಯಾಟ್ರು.
Proxy counsel.
The suit has been disposed of on 15/6/2018. Illa, this petition is filed in the year 2019. Writ petition file ಆಗಿರೋದು 2019.
19.
ಏನೋ ತಪ್ಪಿದೆ ಇದ್ರಲ್ಲಿ.
Respondent ವಕಾಲತ್ ನೇಮ್ ಟ್ಯಾಲಿ ಆಗ್ತಾನೆ ಅಂತ.
Matter is called out. There is no representation for the respondents. Full stop. However, learned counsel Sri Anand Mutalli is required to comply with the office objections raised on the wakalat filed by him.
Interim
A
arrest.
week's time is granted to do the needful. Interim order granted earlier stands extended till the next date of year.
Serial number 11, Joseph Anthony.
Mr. My lord, I've taken steps in the matter, my lord, but is unable to ascertain the new address.
The suit has been disposed of
No, my lord, it's still pending, my lord.
on 19/6/2024.
No, it's still pending. It's coming upon 27/9, my lord.
What is the suit number? 877. ಯಾವ್ದ ಬೇರೆನಿದು? 877/8/778 of 2015.
No, my lord, 571 of 29.
8778 ಕರೆಕ್ಟ್ ಆಗಿದೆಯಲ್ರಿ? ಅನಕ್ಷರ ಎ.
No, my lord, OS 571 of 2019.
Number 11.
11 serial.
This is serial number 11, sir.
Serial number 11, my lord.
11.
Second list, 230, my lord.
This is WP number
5100.
ಯಾವ್ದು ಬೇರೆ ಇಲ್ಲ, ನೀವು ಕೊಟ್ಟಿರೋದು ಸೀರಿಯಲ್ ನಂಬರ್ 12 ಕಣ್ರಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 11 51003. 51003 ಕೊಡ್ತೀವಿ ಇಲ್ವಾ? ಅದ್ ನೋಡಿ ಚೆಕ್ ಮಾಡಿ. ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ಕರಿ.
13, order passed.
ಅಲ್ಲ 12.
12, order passed.
ಇದು ಅದೇ ಇದು ಹಂಗಾದ್ರೆ ತೆಗೀರಿ ಹಂಗಾದ್ರೆ. ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದೀವ ಇದರಲ್ಲಿ? ಯಾವಾಗ ಮಾಡಿದ್ರಿ?
ಕೊಟ್ನಲ್ಲ. ಎರಡು ಮೆಮೊ.
ಎಲ್ಲಿ ಮಿಸ್ಟರ್ ಎ ವಿ ಗಂಗಾಧರಪ್ಪ ಅವ್ರ ಕೊಲಿಗ್ ಇದ್ರಲ್ಲ ಇಲ್ಲಿ. ಕೊಡಿ. ದಿ ಸೂಟ್ ಆಗೋಗಿದೆಯಾ? ಸರಿ. ಅದು ತೆಗೀರಿ, ಸೀರಿಯಲ್ ನಂಬರ್ 11 ಫೈಲ್ ತೆಗೀರಿ. ಕರೀರಿ ನೆಕ್ಸ್ಟ್ 13
ಧನಂಜಯ್ ಕುಮಾರ್. ಧನಂಜಯ್ ಕುಮಾರ್.
OS number 538 of 2016. Disposed of on 10/11/2023. Yes, disposed of.
Serial number 14, Vijay Kumar K.
I pray for the petitioner in this matter, my lord. I pray for a week's time to take. I pray for a week's time to take steps in respect of respondent number 1 and 4. This writ petition is filed after disposal of the case itself. Impugned order. Impugned order is at page number 33.
Set aside order dated 10/3/2016.
Yes.
What is that order?
A suit for partition was filed. It was decreed. Later, thereafter, I had filed a miscellaneous.
10/3/2016.
Yes, ma'am. This is filed subsequent to disposal of the OS.
You are challenging this, that order itself.
That order itself. (29/10/2014) suit was decreed. Thereafterwards, I had filed a miscellaneous petition that was allowed on 17/10/2015. Thereafter, suit was restored and this impugned order was passed. Agreed by that impugned order, I am before this honorable court.
Who is the contesting respondent?
126 money.
So you have entered appearance.
For 6 days.
Only respondent 6.
Also a purchaser of the.
Respondent number 5 has refused to take notice. And notice is to be held sufficient so far as respondent number 5 is concerned. My lord. So far as respondent number 1 and 4, I will take steps in 2 days' time.
The postal sheriff on the notice sent to respondent number 5 shows that the party has refused to receive the notice. Full stop. Therefore, notice is held sufficiently served on respondent number 5. A week's time is granted to the petitioner to take steps for service of notice on response number 1 and 4.
Interim order may kindly be extended.
Interim order granted earlier stands extended till the next date of hearing.
Serial number 15, Srinivas.
Sorry, my lord, in serial number 12. I had given the memo in the morning.
Yes.
Serial number 15.
My lord, I appear for a petitioner in this case, my lord. My lord, suit is pending, my lord.
Number 3.
Suit is pending, my lord, and next hearing date is also there on 28/8.
Respondent number 5. Who is respondent number 5?
I appear for.
Yes, special land acquisition officer.
I appear for respondent.
Office of objections have been raised on the statement of objections.
I will clear the defects by.
A week's time is granted at the request of learned counsel for respondent number 5 to comply with the office objections raised on the statement of objections.
Much obliged.
16 order passed. Serial number 17, Ravi M. HK.
Appear for the petitioner, my lord. I pray for a week's time to take steps.
It appears that the suit has been disposed of, madam.
No, my lords, it's listed on 30th of October. Next.
30th of October. What is this? This arises out of
Suit for partition and separate position.
OS 36 of 2006, is it?
30.
Huh?
36 of 2006.
Correct, huh? ಇದು ಯಾವ್ದು
Yes.
ಬೇರೆ ಕೊಟ್ಟಿದ್ದಾರೆ? A week's time is granted. A request of learned counsel for petitioner to take steps for service on the service of notice on the unserved respondents.
Please.
Serial number 18, case Narayan Swami.
Invoice number 1914 of 2010 has been disposed of on 19/1/2021. Disposed of.
Serial number 19, Prasanna Kumar, yes.
I appear for respondents, my lord.
Yes.
My lord, both the advocate on record as well as senior counsel are on their legs. If my lords may kindly pass over.
Transferred. The suit has been transferred.
My lords, I may not be in a position to answer, my lords, because I am appearing as proxy counsel.
Release this matter on 14th of August.
Please.
20, order pass, serial number 21, Siddhappa BM.
I'm appearing for the petitioner, my lord.
You are challenging the order passed in the MA, is it?
Oh, yeah, MA, my lord. Because trial court granted injunction, appellate court reversed the same. Therefore, I am before the Samul court. Interim order granted by the Samul court.
Matter is called out. There is no representation for the respondents. Release this matter on 14th of August.
May I request interim order may be extended.
Interim order granted earlier stands extended till next date of it.
Serial number 22, the board B Tumbagi.
No pay for the respondent case, my lords. Date may be fixed, my lords. Short accommodation, my lords. Date may be fixed. I will address my arguments for the respondent in this case. Matter is called out. There is no representation for the petitioner. Release this matter on 21st of August. Much obliged. Much obliged.
Serial number 23, order passed. Serial number 24, Kamraj, yes.
ಇದು ಏನು ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಅಂತ ಹೇಳ್ತಾರಲ್ಲಿ? ಹಾ? ಅನ್ಕಂಟೆಸ್ಟೆಡ್ ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಅಂತ ಹೇಳ್ತಾರಲ್ಲಪ್ಪ. Learned HCGP is directed to secure information as to whether the suit from which the writ petition arises has been disposed of. Full stop. Information available to this court is that the suit has been disposed of on 19/8/2021. Full stop. Release this matter on 14th of August.
Number 25. Kotandapani P. RK.
OS number 25091 of 2019 is disposed of on 3/1/2020. Disposed of.
26, Sachin BS.
Transfer
number 1, please.
The execution case has been transferred.
But I have noticed that it is transferred to commercial court minutes on 7/2/2020. And where, my lord, it is renumbered as commercial execution case number 609 bar 2020. And the said proceeding is pending, my lord, date of appearance is 26/9/2024, my lord. 9/2024. There is an order of stay, my lords, by the honorable court.
This is the recovery proceedings in the execution petition, my lord, the objection was filed. The learned judge had overruled the objections and passed an order to directing the this respondent number 1 to proceed with the execution proceedings. That order is challenged before this honorable court.
The execution case is still pending.
Execution is still pending, my lord. The impugned order, your lordship will find it at annexure
That is
A.
called out. There is no representation for the petitioner. Yes.
The execution case which was filed by the respondent, my lords.
Yes.
Which came to be allowed, my lords, challenged out that execution petition in annexure A, where
You filed an application for?
they have filed an application, my lords.
Ah.
In execution petition, where I have raised the contention that the means which has to be satisfied is for the degree holder. Now this matter pertains to the if my lords.
That's so, my lord, annexure A may kind of be looked into. Yes. My lord, I had filed an execution petition for enforcing the award. They filed an objections. That objection was overruled. Their objection is to the effect that they have no means.
The petitioner is judgment debtor number 1.
Number 1, my lord.
Please, my lord. That objection is overruled by the learned judge. That order is challenged before the honorable court.
Objection?
They filed objection stating that they have no means. The petitioner herein is the judgment JDR number 1. He filed objections to the execution petition, contending that he has no means. That objection is overruled by the learned judge, against which he has filed his writ petition.
Yes.
My lord, the learned judge has not passed any order for
my lord.
attachment or arrest, whatever it may be. Nothing has been passed. Just objection is overruled. His contention is that he has no means.
No
If that
means.
is the case, in the subsequent proceedings, he can take all defenses, whatever is available to
My
him.
lords, and moreover, my lords, the possession of the vehicle has already taken over. I filed an affidavit in last date of hearing, my lords, with respect to the vehicle, which was taken by the respondent number 1, it's taken back, the repossession of the vehicle.
No, it is-
I filed an application, my lords, and I have a
It is an incorrect submission in respect of which I have filed counter affidavit also, my lord, along with the documents.
So now you will have to convince the court what is wrong in the order, impugned order.
the impugned order, my lords. Now the matter is about
Whether you have means or not will be further found out.
Will be proved
On
at the
inquiry.
later stage, my lord.
my lords, the reason why, my lords, we have challenged that impugned order, my lords, where the degree holder, it is for the degree holder who has to satisfy the means, not for the judgment of one. It is for the degree holder who has to satisfy the means to pay the decretal amount. Now, my lords, my contention is,
Degree holder,
it is for the degree holder who has to satisfy whether I have means or no.
he will give the list of information, whether it is movables or immovables or
Yes,
whatever.
please, my lord.
They will give the list of the articles
Assets,
having
assets.
party available with you.
Assets.
If you have any objection, at that point of time, you can raise an objection,
Yes.
saying, no, I don't have all this. Inquiry will be conducted.
Grateful, my lords.
There is no question of considering this interim order at this stage. I mean, impugned order at this
Impugned
stage.
orders. Grateful, my lords. If in that case, my lords, if they have produced any
Perfectly. The petitioner is judgment debtor number 1 before the executing court. Stop. The petitioner sought to raise an objection to the execution petition stating that the petitioner herein has no means to satisfy the award, and it is for the decree holder to satisfy that the judgment debtor has got sufficient means to satisfy the award, before seeking to execute the award by detaining the judgment debtor in civil prison. Full stop. Next para. Learned counsel for the first respondent, decree holder, however, submits that such an objection sought to be raised by the judgment debtor has been rejected by the executing court. Full stop. This would mean that once an application is filed by the decree holder seeking for an order of attachment
Attachment or arrest, whatever it may be.
or an order of arrest, the court will have to seek necessary information from the decree holder as to the assets available with the judgment debtor. Full stop. At that point of time, if any information is sought to be given by the decree holder, then the judgment debtor will have an opportunity to raise objections. Full stop. Next para. The submission of the learned counsel for the first respondent, decree holder, is accepted. Full stop. The petition is accordingly disposed of, granting liberty to the petitioner herein to raise objections at the relevant point of time when information is sought to be given by the decree holder to proceed against the judgment debtor. Please. Full stop. Ordered accordingly.
Number 27,
Grateful.
FR, Chandana, G.
Your Lordship, I'm appearing for the petitioner in this matter.
Common order dated 26/9/2019.
Yes, your lordship, on IA 8 and 3, which rejected my application under section 10 of CPC. Because there's a similar suit pending in the Kolkata High Court for same prayers and between same parties and same agreement.
This is regarding territorial jurisdiction.
Yes, your lordship. Interim is granted by order dated 2/12/2019.
Are you sure the matter is still pending?
Yes, your lordship, it's listed on 23rd of August.
All right. Matter is called out.
My lord, I am appearing for the respondent in this matter.
Ah,
My lord, there is a stay operating where because of that the commercial suit is lying pending before the commercial court since 2 years. And this is the section 10 application which has been by detailed order. The trial court has dismissed the application of the petitioner over here. My lord, may see the para number 10 of the judgment, my lord. My lord, para number 10 of the judgment, which is at page number 35, which categorically, my lord, the trial court has stated the prayer reflected in the suit filed by the petitioner over here against the respondent and the suit filed by me against the
you are the
defendant.
counsel on record?
No, your lordship. I need next
Lord,
date.
prayers are totally distinctly different.
Learned counsel for petitioner release this matter on 14th of August.
Yes, your lordship. Much obliged.
Number 28, order pass 29. GK Bhatt.
Respondents. Petition survives order passed in miscellaneous petition but seeking restoration of the suit has been dismissed. Again, is that order, this writ petition is preferred.
Matter is called out. There is no representation for the petitioner. They release this matter on 22nd of August.
Serial number 13. Sharad Kumar Shetty.
Here we responding. ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪ್ರೊಸೀಡಿಂಗ್ ಅಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆ. ರಿಕವರಿ ಅಮೌಂಟ್ ಮೇಲೆ ರಿಕವರಿ ಅಮೌಂಟ್ 9 lakhs ಕೊಡಬೇಕಾಯ್ತು 14% ಅಲ್ಲಿ. ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕೊಂಡಿದ್ರೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಮೇಲೆ ಇಲ್ಲಿ ಸ್ಟೇ ಮಾಡಿದೆ.
ಎಕ್ಸಿಕ್ಯೂಷನ್?
ಎಸ್ ಮೇಡಮ್. ಪೇಜ್ ನಂಬರ್ 52 ಮೇಲೆ ಅನಕ್ಷರ H ಮೇಲೆ.
Matter is called out. There is no representation for the petitioner. Release this matter on 22nd of August.
Serial number 11. Serial number 11.
Pass over.
Joseph Anthony, serial number 11.
Have been taking steps in that matter, unable to ascertain their addresses. Will file the necessary application to file the
Information. Post of information is there. Illa. Are you sure the matter is pending consideration?
Yes, my lord, it's coming up on 27/9, my lord.
All right.
A week time may be granted, my will.
Time is granted at the request of learned counsel for petitioner for furnishing correct address and to take steps for service of notice on response number 1 to 5.
And interim order may kindly be extended.
Granted earlier and extended till the next date.
Indeed.
Number 1. Serial number 49.
Next stop here for the
BB
petitioner,
Pandit.
my lord.
In respect to the R1, my lordship, I may be permitted to take steps in with respect to the respondent number
At
one.
the request of learned counsel for petitioner to furnish correct address
Please,
and to take steps for service of notice on respondent number one.
I may be permitted to serve the copy on the learned counsel who is appearing for the respondent number one before the trial court, my lordship.
ಅದಕ್ಕೆ ಮುಂಚೆ
Please, my lordship.
the notice sent to response number 2, 3,
7
and 7
held sufficient.
have returned with the postal shara inert commercially refused. Full stop. Therefore, notice is held sufficiently served on response number 2, 3, and 7.
Please.
Huh? Yes.
I have filed an IA for extension of time to deposit the amount which was granted the interim protection on 26/3/2024. This repetition, my lordship, arising out of the execution petition on the interest part, so that I have challenged hearing. Upon hearing, the interim protection has been granted on 26/3/2024, subject to payment of 2 lakhs rupees before on or before 22/4/2024. On the ground, my lordship, my mother, the petitioner mother was paralyzed, so that it was not deposited. In the meanwhile, my lordship, I have deposited the before the trial court. It was taken on record on 18/7/2024, subject to production of the extension order. The memo which was filed by me on today, third page ali this one. The case status ali website status I have produced. Page number 3 ali. The case called out, no representation for DHR, counsel for the JDR number 1 filed a memo stating that the writ petition filed again by him was posted on 15/7/2024 and he was moved an application for seeking extension of time to deposit the amount before the discourt. The memo filed with the DD of rupees 2 lakhs. The JDA number is directed to produce the order copy of the Honorable High Court of Karnataka or registry is concerned by extending the time to deposit the amount on the next date of hearing.
Order on
26/3.
2 of 2024. This application is filed by the petitioner. Judgment data
1.
Number 1. Seeking extension of time to deposit the amount for the executing court, as directed by this court on 26/3/2024. Full stop. Nevertheless, learned counsel for petitioner has today filed one more memo along with
Website copy of the trial court.
the order sheet maintained by the executing court and submits that the petitioner has deposited the sum of rupees 2 lakhs as directed by this court before the executing court on
18/7/2020.
18/7/2024. Full stop. Learned counsel submits, though there is a delay on the part of the petitioner. Nevertheless, the amount has been deposited before the executing court.
Please.
Full stop. Next para. Consequently, this court holds that the petitioner has complied with the directions issued by this court. Yes.
I may indulge this matter. With respect to the service of notice to the respondent number 1, I may be permitted to serve the copy the trial court representing who is representing before the trial court. Writ petition along with annexures. I will furnish the new address and along with the writ petition. I will take steps along with the new address.
A week's time is granted at the request of learned counsel for petitioner to furnish correct address and to take steps for service of notice on respondent number 1. The petitioner is also permitted to serve a copy of the petition along with annexures from the learned counsel representing respondent number 1.
Please.
Before the executing court.
Please. Deeply.
Number 15, Pradeep C. Yadav.
The interim order extend ಮಾಡಬೇಕಾ ಅದು ಏನದು conditional order ಏನದು
There is no conditional order.
ನೋಡ್ರಿ ಇದು order
Subject to deposit of. The interim order was granted on 26/3/2020.
not for a limited period.
It is not further limit. Subsequently, it has been extended. Interim order has been extended. Subsequently.
Till when?
Till today, my lord.
ಮತ್ತೆ
Extension, please.
interim order granted earlier stands extended till the next date of hearing.
Deeply obliged.
50, Pradeep C. Yadav.
Appearing for the petitioner, your lordship.
Photocopy of annexure along with preamble page to be furnished.
Your lordship, I request this court to overrule the.
Photocopy of annexure.
It is downloaded from the e-codes and submitted, your
Which
lordship.
annexure?
Annexure E. At page number 59, your lordship.
But if you are challenging an order of the court, you'll have to furnish the certificate copy.
Your lordship, this is not the order that I am challenging, your
Ah.
lordship. The order that I'm.
Not the order.
No, your lordship. I am challenging the order at annexure A.
Office objection. At serial number 1 is overruled.
Please, your lordship. The remaining office objections have been complied with, your lordship.
List this matter for.
Your lordship, there's an urgency if I may be permitted to make submissions.
Ah.
Your lordship, I am the plaintiff in OS number 274 of 2011. I have filed this suit for declaration
And injunction.
and injunction against the sale deed dated 23/11/2006, your lordship. This is a counter suit that is filed. Earlier, the defendants herein have filed an OS 2286 in 2000.
Yes, 2011.
This
This suit is of 2011.
2011, your lordship.
Yes.
But earlier, the defendants in OS 274 in 2007 filed the same suit for declaration in 2286 of 2007. Both the matters came to be clubbed in the year 2016 by a common order stating that we could leave common evidence in both the matters. In OS 274 of 2011, my lords, the summons was served to the defendants, all the defendants in the year 2011 itself, on 12/10/2011. On 14/12/2011, the defendant number 7, who is the GPA holder of defendant number 1 to 6, have appeared before the court and seeked for permission to appoint a counsel. And thereafter, they have never appeared before this, before the trial
In
court.
the year 2016, the matters were clubbed.
Yes, your lordship.
Ah.
But much before that, in 2011, they were served with the notice. The summons was served duly on all the defendants, and they've defendant number 7 has appeared before before the trial court, seeking time to engage a counsel. The court has granted time, and on 14/12/2011, after giving enough chances for them to appear before the court, they haven't appeared, and the trial court has placed them ex parte. And thereafter, on 31/2024, they have come before the court, filing an application under Order 9, Rule 7, praying to set aside the ex parte order.
All right, madam. If you don't allow them to prosecute the matter, what is the use of clubbing the two matters then?
But your lordship, they were aware of the proceedings in 274, your lordship.
Issue notice to the respondents. The petitioner is also permitted to serve a copy of the writ petition along with annexures on the learned counsel representing the respondent to the trial.
Your lordship, a stay may be granted until further
Oh, madam.
Serial number
Yes.
51. Anandaram K.
Regarding consideration of interim prayer, my lords.
Hmm.
The writ petition, my lord, is filed by the judgment debtor number 1, challenging, my lord, the order passed on 16/7/2024. Now, the suit, my lord, there is a decree. The lordship may kindly turn to, my lord, page number 50 of the writ petition papers, my lord.
Suit filed by?
A suit filed by the decree holder respondent herein, respondent number 1 herein.
You are a judgment debtor.
I am judgment debtor number 1, my lord.
Suit for?
My lord, suit for mandatory injunction, declaration, mandatory injunction, and, my lord, permanent injunction. Declaration that, my lord, a particular roadway, she has a right over a particular roadway, which is marked as RRR in the sketch along with the plaint. Injunction, my lord, is to demolish the compound wall, which I have built, my lord, around my house, and to gain access, my lord, through that demolished portion to their house. Then, my lord, injunction, permanent injunction, restrain me from interfering with, my lord, exercise of rights under in respect of that roadway.
Yes.
Now, my lord, the suit came to be decreed. And, my lord, admittedly, my lord, RA is filed, and that the same is pending before the appellate court, my lord. RA number 38 of 16 before the first additional senior civil judge, Mangalore. Now, my lord, when the RA was, yes,
No stay.
no stay, there was no stay. When RA was pending, my lord, they filed an execution petition in the year 2022, almost 6 years, my lord, after the judgment and decree was passed. Judgment and decree was passed in the year 2016.
Yes.
Then, my lord, I filed a application in the executing court saying that, my lord, insofar as the execution petition was filed only, my lord, to enforce the mandatory injunction, decree of mandatory injunction. So, my lord, I filed an application before the executing court stating that, my lord, the mandatory injunction decree is barred by limitation because under Article 135 of the Limitation Act, my lord, the limitation is 3 years from the date of the decree is passed. So that application, they filed objections, my lord. Now the impugned order is passed. The reasoning of the learned trial judge is that, my lord, since appeal is pending, the limitation has not yet commenced. So therefore, my lord, the question of limitation does not arise. This, my lord, in my humble submission, my lord, is contrary to, my lord, a judgment of the Honorable Court in 2012. Where, my lord, the Honorable Supreme Court has held, my lord, unless there is a stay, I've given it on the last occasion, my lord.
Yes.
Unless there is a stay order, go to the last time. 2012 3 SCC 548. In copy. My lord, here also similar, this was under 136, my lord, where enforceability of the decree has to be seen. But nevertheless, our case will fall strictly under 135. 135, my lord, it specifically states from the date of the judgment and decree, my lord, the limitation will. Lord, kindly come to, my lord, paragraph number 40, my lord. The one of the questions in this case was, my lord, whether, my lord, a final in the partition suit, whether a preliminary decree is executable or final decree is executable. The court held that it is the decree in this case in the partition suit amounts to a final decree, so therefore it is executable. Next, my lord, the court considered the limitation aspect. Paragraph number 40, my lord.
Yes.
We have already held that the decree was a final decree. Therefore, it was immediately executable. The question thus would be, was the time arrested? On a query being made, it was fairly conceded at the bar that at no point of time there was any order by any court directing stay of operation of the judgment and decree passed in PS number so and so of 1962. That question, the question that emanates for consideration is whether period during which the suit and appeal preferred by the appellants remain pending is to be excluded for the purpose of limitation. In this context, we may usefully refer to the dictum in Ratan Singh versus Vijay Singh, wherein while dwelling upon the concept of enforceability of a decree and the effect of an order of stay passed by the appellate court, the bench stated thus: when is a decree becoming enforceable? Normally, a decree or order becomes enforceable from its date, but cases are not unknown when the decree becomes enforceable on some future date or on the happening of certain specified events. The expression enforceable has been used to cover such decrees or orders also which become enforceable subsequently. Filing of an appeal would not affect the enforceability of the decree unless the appellate court stays its operation. But if the appeal results in a decree that would supersede the decree passed by the lower court, then it is the appellate court decree which becomes enforceable. When the appellate court order does not amount to a decree, there would be no supersession, and hence the lower court decree continues to be enforceable. Then, my lord, they refer to Ram Bachchan Rai's case, my lord, and then para 44 minutes. In the case at hand, the compromise decree had the status of a final decree. The latter suit filed by the appellants was for partition and declaring the ex parte compromise decree as null and void. As has already been stated, there was no stay of the earlier judgment or any proceedings emanating therefrom. In the absence of any interdiction from any court, the decree holder was entitled to execute the decree. It needs no special emphasis to state that there was no impediment or disability in the way of the respondents to execute the decree, but the same was not done. Therefore, the irresistible conclusion is that the initiation of execution proceedings was indubitably barred by limitation. Thus analyzed, the reasons ascribed by the learned single judge are absolutely unsustainable. The period of limitation stipulated under Article 136 of the Act could not have been condoned, as has been so presumed by the learned single judge. The reliance placed on so and so is totally misconceived, inasmuch as in the said case, the execution proceedings was initiated for permanent injunction. No exception can be taken to the same, and therefore reliance placed on said decision is misconceived. Now, my lord, permanent injunction, my lord, there is no limitation prescribed. But insofar as mandatory injunction, my lord, kindly come to Article 135 of the Limitation Act.
What is limitation?
Article 135, my lords. For the enforcement of a decree granting a mandatory injunction, the period of limitation is 3 years. My lord, the time from which begins to run, the date of the decree or where the date is fixed for performance, such date. Here, my lord, the date performance 30 days was, my lord, fixed for the performance from the date of the decree. My lord, now, my lord, after those 30 days, after 6 years, my lord, the execution.
Where is that judgment and decree?
My lord, judgment and decree, my lord, is at page 50, my lords, page 50. The judgment is at page 50. The defendant is hereby directed by way of mandatory injunction to remove the newly constructed parallel compound wall, which is situated in front of plaintiff's existing G1 gate, and shift the G2 gate to its original place and provide unobstructed access to the plain scheduled property through G1 gate within 30 days from the date of this judgment. Now, my lord, the date of the judgment is, my lord, on 7th of January 2016. So 30 days would, my lord, get over on the 7th of February 2016. My lord, the present execution petition is filed, my lord, on 21/2/2022. It's almost more than 6 years. On 7/2/2022, 6 years are over.
Which is the impugned order?
My lord, impugned order, my lord, Annexure F, page 108. The reasoning, my lord, at page number 13, para number 13 at page 113. Lord, on perusal of the judgment and decree passed in OS number 785 of 2009, it is seen that suit for declaration and for mandatory injunction was decreed on 7/1/2016. Immediately after the disposal of the suit, the judgment debtors challenged the judgment and decree by filing an appeal, which is numbered as RA number 38 of 16. Admittedly, there is no stay of the decree in the above appeal. The appeal filed by the judgment debtor is nothing but the continuation of the suit. Therefore, the judgment of this court not attain finality. However, there is no bar to file an execution petition to execute the decree, though there is an appeal. If there is no stay of the decree holder can proceed with the execution petition to get it executed. Since the appeal is a continuation of a suit, the limitation not commenced and it will not get expired after the 3 years of the decree of the trial court. But that last portion, my lord, is contrary to the dictum of the Honorable Supreme Court.
Yes.
Grateful, we read only the part of the judgment. Kindly come back to the operative portion of the judgment, Your Lordship. Thank you. I would have felt happy if you had read the previous portion, page 49. There is a declaration relief also. There is a declaration relief, page 49. Declared that the RRR road leading to plain scheduled property is a normal roadway and the plaintiff has got unobstructed easement right over the said road way through P1 gate. Then, my lord, defendant is hereby directed by way of mandatory injunction to remove the newly constructed wall, parallel compound wall, which is situated in front of plaintiff's existing wall, and shift so and so, and provide unobstructed access to the plain scheduled property through gate 1 within 30 days from the date of the defendant is a men, servant, so and so, also injunction. There are 3 reliefs. One is declaration, one is mandatory injunction, other is permanent injunction. They're all clubbed together. One can't be isolated with the other. But this very contention, what happened is this fellow. He filed the appeal. He did not seek stay. He took 26 adjournments. He took 26 adjournments in the appeal. Then we filed execution because that was not implemented too. He was not allowing the appeal to proceed. So he was taking time. The learned judge found that he's been unduly delaying the matter. Then we filed execution. In the execution, several orders are made. One order I would like to point out here, kindly take objection statement that we have filed. It is not as though the first time he has come to this honorable court. He has suppressed the filing of the earlier writ petition. Kindly take page 40, kindly take page 43, my lord. In our statement of objection 44. On the question of suppression only, this petition must be dismissed with cause, exemplary cause. Same contention is raised in the writ petition. This honorable court rejected the writ petition. 44, my lord. Before that, my lord, kindly come to the writ petition. It starts that he filed earlier writ petition, which is conspicuously absent in the present writ petition. He doesn't even make a reference to this writ petition. Kindly come to page 34. There is an order, successive orders to implement the order. 4 orders are made. Now, my lord, this order is challenged by him. Kindly come to page 34, the writ petition. And kindly come to page 40. Same contention is raised. Same contention is raised, paragraph 14. Whatever he is now saying, he has been contended before this honorable court at paragraph 14.
Paragraph 14, no?
The writ petition at running page 40, 40.
No, I am at this order that you pointed out at page number 44.
No, this contention has been raised.
What? Please read it, sir.
Please, kindly come to page 40. The execution
40.
40, Mayor. In the earlier writ petition with the commissioner was directed to remove all that, to carry out the work of removal and all that. This contention, very contention is raised, paragraph 14. The execution proceedings is barred by limitation. Respondent number 1 is seeking to enforce the decree to mandatory injunction. As per Article 135 of the Limitation Act, the execution petition ought to have been filed within 3 years. However, in the present case, now, my lord, this petition is dismissed by the learned judge.
On what is the finding?
Finding is that there is no merit in the contention urged in any of the grounds urged in the writ petition.
Let us see that, sir.
Yes. Kindly come to page 5, paragraph 5, my lord.
Yes. Yes.
A perusal of the page 48, ma'am.
Yes.
Perusal of the impugned order read in conjunction continuation with the earlier order dated 7th and 23. as well as the judgment and decree dated 7/1/26 passed in so and so coupled with the fact that there is no interim order of stay in favor of the petitioner in the appeal filed by the against the judgment and decree. I am of the view that the trial court was fully justified in passing the impugned order, clarifying its earlier order dated so and so, directing demolition of the compound wall and shifting of the gates in terms of the judgment and decree dated so and so. It is needless to state that the executing court cannot travel beyond the decree dated so and so, so long as the court passed the impugned order for the purpose of enforcing, implementing, and executing the same, it cannot be said there's any illegality or infirmity in the impugned order.
Not the earlier
1 minute,
impugned order.
I have not completed.
I'll just clarify.
Please.
Challenge this one.
My lord, no, earlier the impugned order, my lord, there the trial court, my lord, directed a survey.
Sir, let us
My lord-
not go into other aspects. You are only pressing one ground.
Yes, my lord,
That this execution petition filed after 6 years
is barred by
is
limitation.
barred by limitation.
Yes.
You have urged that ground.
My lord, earlier, my lord, in the writ petition,
So
that
separate
ground
an
was taken. My lord, that was not urged, my lord. No findings
sir.
are given, my lord, by the,
Barred by
my lord,
rest
no
of the-
findings are given by this honorable court, my lord. Ultimately, my lord, it's a question of law, my lord, where, my lord, is clearly barred by limitation.
Yes, sir, but if it is urged and it is rejected,
No, it is
you
not
had a
reject-
ground to question that order.
My lord,
You
it
have not
is, my
questioned
lord,
it.
your lordship may kindly see the order, my lord, at page number R13.
Paragraph number 5.
Yes, my lord. Paragraph number 5, my lord, the court, this honorable court holds that the trial court was fully justified in passing the impugned order, clarifying its earlier order dated
Same
7/10/2023.
contention, same contention,
Lord,
they argued. then
That issue raised by you has been answered.
My lord, the issue was, the list before this honorable court was, my lord, the pursuant to an application filed by me before the trial court. The trial court, my lord, directed a survey as to the properties of the plaintiff and the defendant. Then, my lord, another application was filed stating that the court cannot go beyond the decree. So therefore, the question of now conducting its survey does not arise. The map, my lord, drawn by the commissioner is crystal clear. So as per the map of the court commissioner, my lord, execution has to proceed. Then, my lord, this impugned order was passed. Annexure R14, impugned order was passed, stating that since the question of conducting survey does not arise, the trial court clarified its earlier order and directed, my lord, to proceed further with the execution of the decree.
Added to
Now,
that,
that order was challenged by me in this writ petition. Now, my lord, rightly or wrongly, my lord, one additional paragraph is included in the earlier writ petition
yes.
saying it is barred by limitation.
very well.
Now, my lord, that was not the scope of the writ petition at all.
Yes, yes.
You can't.
That was not the scope of the writ petition at all.
Sorry.
So therefore, my lord, there is no finding also.
Perfectly.
My lord, may I make one submission, my lord?
Yes.
My lord, may I make one submission, my lord? My lord, now the appellate court is seized off, my lord, the appeal which is filed by me. My lord,
30 adjournments you have taken.
my lord, my submission is this, my lord. Let the appellate court any date, my lord, tomorrow, day after, or next week. I will argue the first appeal. My lord, otherwise, my lord, your lordship may kindly see, my lord.
Nothing
I'll
will
file
happen.
two documents.
Only gates will be removed.
One second, my lord, I'll
144
submit, my
is
lord, the
always
prejudice
there.
cause to me, my
You
lord.
took
744.
advantage of the fact that
No, my lord, certainly not.
you have filed the appeal, but they didn't press for it. They
Yeah.
thought,
But
they
I
can
have not
argue the
taken
matter.
30 adjournments, my lord. This is an incorrect submission.
Can I show, sir? Can I show?
Security.
My lord, your lordship may kindly see, my lord. Your lordship may kindly.
Can I show that?
Lord,
Can I
your
show that
lordship
to
may
you?
kindly see.
Can I show that to you?
Not argue with me, sir. Please argue.
Can I show that how many times you have
Lord,
taken?
your lordship may kindly see, kindly take a memo, my lord.
Whatever you want in the appellate forum.
My lord, but your lordship may kindly see this, my lord. Kindly see this, my lord, for a moment. Kindly come to the memo that I have filed along with 3 documents, my lord. I'll just point out those, my
What,
lord.
sir?
My lord, to show, my lord, if the execution is carried out, well, ultimately they will come to my, my lord, front yard and then, my lord, take access to their house.
That is the
My lord,
decree.
there is an alternate road. There is
No,
an
that-
alternate road.
You can't argue on the merits of the
My lord, that
matter.
is merits of the appeal. I understand, my lord. That's
Yes.
the merits of the appeal. There absolutely no doubt about it. But, my lord, if once that execution is carried out and compound wall is demolished, my lord, then, my lord, my appeal will become infructuous. Your lordship may kindly see, my lord, a memo that is filed on 5th August. 5th August, I have filed 2 memos, my lord. Your lordship may kindly consider those 2 memos, my lord. Then I will rest my case. I have filed 2 memos, my lord, on 5th of August.
Hmm.
my lord, one is, my lord, along with the sale deed, my lord, which is marked as Exhibit P2 of the plaintiff. Adralli, kindly come to the sketch, my lord.
What is this?
Then, my lord, I'll just
How
point
can
out
this
the
court
way, my
look
lord.
into all this?
My lord, your lordship may kindly see, my lord, your lordship, my lord, this road is, my lord, ends with the property of the defendant. That is the
Sir,
judgment
this-
debtor.
This court cannot go into all these aspects. Why are you pressing it here?
My lord, that is the whole reason, my lord, I'm submitting.
Before the appellate court.
My lord, your lordship may kindly see, my lord, let my lord appellate court proceed with the hearing of the appeal and pass an order within, my lord,
I can't
whatever the
issue
time.
directions, sir. How can I issue directions to the appellate court? Not possible.
My lord, my lord, unless, my lord, such protection is given, my lord, the entire, my lord, appeal will be rendered
Sir, it was
infractuous.
open for you to seek stay.
My lord, I have sought stay, my lord. I have sought stay.
Then
that has been rejected by the honorable
you should have
court.
questioned it before the appellate forum if you had any appeal. Or you should have come before this court.
No, that has not been.
Do not done all that.
My lord, there are two more citations, if I can cite, my lord. So, two more citations.
No.
On the very same lines, my lord, because
For what, sir?
135.
Sir, there is no doubt that the judgment that you have cited
Yes, madam.
is on the point of law.
Yes.
But the problem here is that you have suffered such an order earlier
My lord,
and
there-
you didn't question it.
My lord, my humble submission before your lordships is, my lord, question of limitation was never gone into by this honorable court.
Sir, you have raised it.
It was
and
raised
it has
as a
been
ground.
answered in paragraph number 5.
My lord, it was raised as a ground. I cannot deny it.
That contention has been negative.
No, that is not negative, my lord.
No.
My lord, regarding limitation, there is not even a whisper, my lord, by this honorable court regarding the question of limitation.
Therefore, why did you accept that order then?
My lord, that
You are pressing that the execution petition was not maintainable. Why did you accept that order then?
My lord,
You should have questioned that order.
my lord, pursuant to that only, my lord, the application was filed.
Pursuant to what?
My lord, after this writ petition got dismissed,
Ah.
my lord, then I agitated, my lord, regarding the limitation before the trial court.
Why you should go back before the trial court, sir?
No, because, my lord, the trial court
Should
for
have,
the
you should
first
have challenged
instance.
the order passed by this court.
No, my lord, at the first instance, trial court had not considered the question of limitation at all, my lord, as on the earlier round of litigation.
But you had urged it.
No, my lord, it was wholly not necessary, my lord, to urge that ground. But unfortunately, my lord, that has been raised.
Kindly,
It is not
my lord,
considered by the honorable.
Can I make one
It has not been
submission?
considered by the honorable.
Kindly take the objection filed by him to the EP.
And your lordship may kindly see the photographs, my lord. Kindly see the photographs.
Limitation was never raised as a ground even in EP.
My lord, page
Page
number 10,
28.
along with the memo, page number
All
10,
these sorts of
along
things
with the
are done
memo.
in the
Kindly see,
executive.
my lord, how now they will destroy, my lord, the compound wall. And though they have another, my lord, right of way through the southern side, they just want to, my lord, come into my front yard and then go to their
If you have
property.
been diligent enough, you should have got an order of stay.
ಅಲ್ಲ ಹಾಕಿದ್ದಾರೆ application ಹಾಕಿದ್ದಾರೆ, that application for stay was kept pending.
Ah.
Then, my lord, the original judgment debtor died. His LRs came on record. They filed another application to consider the stay application, and my lord, the stay application had recently been dismissed by the appellate court.
Yes.
I only draw your lordship's attention to.
It passed by a court.
Yes, ma'am.
It has to be executed.
Lord, my only submission is that, my lord, let.
Merits of the case, you have lost it. How can you urge all that before this court, sir? You can do that
appeal
only
pending
before
ಇದೆ.
the appellate court.
Let the appellate court consider, my lord. That is all I am requesting. Let the appellate court consider my appeal. I will not take any adjournments. Now, my lord, I am told that the council has also changed. My lord, I will not take any adjournments. I will argue the appeal. Your lordship fix a date, my lord, day after tomorrow or tomorrow I will argue the appeal.
Council change
Till
ಆದ್ಮೇಲೆ
the appeal gets disposed of.
ಮೂರು
let the
application
execution
ಹಾಕಿದ್ದಾರೆ.
be deferred.
ಕೌನ್ಸಿಲ್
Let the
ಚೇಂಜ್
execution
ಆದ್ಮೇಲೆ
be
ಮೂರು
deferred.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ. Execution
My lord,
court.
nothing will happen if 2 weeks, my lord, if the
Nothing
execution
will
is
happen.
deferred.
6 years, nothing.
It's been 6 years, more
Yes, sir.
than
Very well.
7
144
years now.
144 is there.
All that I am requesting, my lord, any time, any condition may be fixed, my lord, for hearing, arguing the appeal.
And you have not said anything about the previous petition.
Yes, my lord.
Previous
That's the
petition,
suppression
our
of-
objections
that
alle
is-
ಹೇಳಿದ್ದಾರೆ.
that is
Our objections have produced.
ಇದು ನಿಮ್ಮ ರಿಟ್ಟಲ್ಲಿ ಹೇಳಿಲ್ಲ ಅಂತ. It is deliberately not mentioned.
said about
Deliberately not
But
mentioned.
the earlier writ petition copy was not available.
that is
But the writ petition order, my lord, there was no, my lord, analysis of this.
Deliberately all this is
limitation.
done, my lord.
Have you
Is
said
all
that
done
I also
deliberately.
earlier filed a writ petition
Yes, no, nothing is.
No, in the writ petition, I have not stated so, my lord. I have
Nothing is
not
stated
stated so
about.
because the question of limitation was not the point that was gone into in the earlier writ petition.
Lordship may dismiss it on.
That is
the
why I
count
had not
of
stated it.
Suppression of material fact.
But in the objection statement, my lord, they have stated, took this contention. And my lord, the trial court did not, my lord, refer to the earlier writ petition, my lord, while passing the order. That is not the ground also. In the objection that was filed, your lordship may kindly see, my lord, in the objection that they have filed to my application. They have taken the counter or writ petition ಬಗ್ಗೆ ಹೇಳಿದ್ದಾರೆ. Para number 6, it should be 3 at page number 65. And have produced that copy of the objections before your lordships. Regarding the earlier writ petition, in the counter filed to my IA.
Why you have not said?
My lord, firstly, my lord, it was not the ground on which the trial court passed the order. And secondly, my lord, the order did not consider the question of limitation. So therefore, my lord, I had not produced that copy of the order, my lord. That is the only reason. Otherwise, I had no intention of suppressing that order. Because the entire order sheet is produced, my lord, and the entire order sheet of the trial court also speaks about the earlier writ petition that was filed. And, my lord, the intimation given to the trial court, entire the trial court order sheet is produced.
Yes.
So therefore, my lord, my humble submission is, let, my lord, appellant be given an opportunity, my lord, to have his say before the first appellate court. Let him argue, my lord. No, ultimately, my lord, if the appeal, my lord, if appeal is dismissed, they have all the liberty to continue with the execution case.
Berkeley. The petitioner who has suffered a decree of mandatory injunction along with a declaration.
Yes, and also perpetual injunction.
And a decree of permanent prohibitory injunction is before this court. Seeking to set aside the impugned order dated 16/7/2024. Passed on IA number 4, which was filed by the petitioner bar judgment data. Stop. Next para. The suit was filed by respondent number 1. Against the husband of the petitioner herein. Claiming that the plaintiff had a right of way in the suit schedule property marked as RRR roadway leading to the plaint scheduled property. Full stop. The plaintiff sought for a declaration of a rights, easementary right to use the said roadway through gate 1. Full stop. The trial court has decreed the suit filed by respondent number 1, declaring that the RR roadway leading to the plain scheduled property is a Mamul road, and the plaintiff has got an unobstructed easementary right over the said road roadway through gate 1, G1 gate, full stop. The defendant was directed by way of a mandatory injunction to remove the newly constructed parallel compound wall, which is situated in front of the plaintiff's existing G1 gate, and shift the G2 gate to its original place and provide unobstructed access to the plaintiff scheduled property through G1 gate, within 30 days from the date of the judgment. Full stop. The defendant was also permanently injuncted from interfering with the plaintiff's right of user of RRR roadway. Full stop. The judgment was passed on 7th of January 2016. Full stop. Next para. The degree holder filed execution case in execution case number 65 of 2022. Seeking the execution of the mandatory injunction passed by the trial court, to remove the newly constructed parallel compound wall, which is situated in front of the plaintiff's existing G1 gate. Full stop. It is not disputed that the defendant
Execution was for both, my lord, and also for perpetual injunction.
filed a regular appeal in RA 38 of 2016 before the principal civil senior civil judge and CJM, Mangalore, challenging the judgment and decree passed by the trial court. Full stop. The petitioner herein filed an application in IA number 4 . When did you file that IA?
Lord, IA was filed on 9/11/2023.
On
863.
9/11/2023. Praying to pass an order dismissing the execution petition as barred by limitation. Full stop. It was contended by the petitioner that in terms of Article 135 of the Limitation Act, 1963, the period of limitation for executing a mandatory injunction is 3 years, commencing from the date of the decree or any specified date or happening in terms of the decree. Full stop. The trial court dismissed the application and consequently the petitioner is before this court. Full stop. Learned counsel for the petitioner seeks to place reliance on a judgment of the Honorable Apex Court in the case of Bimal Kumar and another versus Shakuntala Devi and others, bracketly 2012, close 3 SCC 548. Full stop. Next para. However, learned counsel for the contesting respondent number 1 submitted that the plaintiff has not approached his court with clean hands.
Petition.
The petitioner. Full stop. It was pointed out from the statement of objections filed at the hands of respondent number 1 that the petitioner herein had earlier filed writ petition number 24010 of 2023. Seeking to assail an order dated 26/10/2023 passed by the executing court. Full stop. By the said order dated 26/10/2023.
Page 32, my lords. Annexure R10.
The executing court had directed the bailiff to remove the newly constructed compound wall.
Parallel compound.
Parallel compound wall situated in front of existing G1 gate and to shift G2 gate to its original position in terms of the judgment and decree passed by the trial court.
As per this case.
And to file a report after executing the said work. Full stop. However, learned counsel for the respondent has pointed out from the memorandum of writ petition.
Paragraph 14, page 40.
At annexure R2, more particularly paragraph number 14.
R12, my lords.
Huh?
R12, annexure
R12.
R. Paragraph 14.
Wherein it was contended that the execution proceedings is barred by limitation. Full stop. It was contended that the respondent number 1 is seeking to enforce the decree of mandatory injunction, and in terms of Article 135 of the Limitation Act, the execution petition ought to have been filed within 3 years. Full stop. It was contended that the execution petition is filed after 6 years, and hence the same is barred by limitation. Full stop. Learned counsel further pointed out to paragraph number 5 of the order passed by this court on 1st of April 2024 in WP number 24010 of 2023 that this court considered such a contention raised at the hands of the petitioner herein and held that the trial court was fully justified in passing the impugned order, clarifying its earlier order dated 7/10/2023 and directing demolition of the compound wall and shifting of the gates in terms of the judgment and decree dated 7/1/2016 passed in OS number 785 of 2009. Full stop. This court noticed the fact that no interim order of stay was passed in favor of the petitioner herein in the appeal filed by the petitioner against the judgment and decree, and therefore no fault can be found in the orders passed by the executing court. Stop. Learned counsel would further submit that the petitioner has not mentioned the fact that she had earlier filed the writ petition before this court, and therefore the writ petition is required to be dismissed solely on the ground that the petitioner is guilty of concealing the writ petition earlier filed, and the fact that similar grounds were raised by the petitioner and this court did not accept such contentions. Full stop. Next para. Learned counsel for the petitioner, however, submits that although it is true that in the memorandum of writ petition, similar ground was raised by the petitioner, nevertheless, the orders passed by this court did not consider the said ground, and therefore the petitioner cannot be held guilty of concealing the filing of the earlier writ petition. Full stop. Next para. Having heard the learned counsel for the petitioner, learned counsel for respondent number 1, and on perusing the petition papers, this court is of the considered opinion that since the petitioner had already raised the grounds sought to be urged before this court and suffered an order the petitioner will not be permitted to urge similar grounds once again. Full stop. Full stop. Next para. Nevertheless, a fervent appeal is made by the learned counsel for petitioner that during the pendency of the appeal filed by the petitioner, if the executing court proceeds to execute the order under challenge, a decree under challenge, the petitioner will be put to irreparable loss and injury. Full stop. It is noticeable that You filed the application after the order was passed by this court?
But along with the appeal, the stay application was filed.
Allah. This application, IA4,
Yes,
urging limitation.
yes,
You filed this application after the order was passed by this court?
yes, my lord. Along with the copy of the order passed by this honorable court, I filed an application on 1911, my lord. Order sheet ಅಲ್ಲಿ ಇದೆ.
It's noticeable that the petitioner herein filed IA number 4 before the executing court after orders were passed by this court.
No. It was filed on 9/11/23, even before. Your Lordship may kindly come to page 63. Annexure D. 9/11/2023.
63 of the writ petition,
Yes, my lord, Annexure D. It was prior to the order.
Prior.
prior.
911, but in that earlier writ petition, there appears to have been a stay, my lord. So the stay order was produced along with this application.
Earlier?
My lord, page 104. 104 ಅಲ್ಲಿ 9/11/2023 ಗೆ my lord, the council also filed IA number 4 under section so and so of CPC, and along with the memo, along with the order in WP number 24010, where my lord passed, the court has stayed until. So there was an interim order in the earlier writ petition along with that.
9/11/2023.
Yes, my lord.
This order is passed, final order is passed in the earlier writ petition on 1st of April 2024.
Subsequent to that application.
That's what?
Yes.
24.
Yes.
24.
1st of April 2024.
24 only that earlier writ.
Earlier, before that you had filed the application.
Filed the application.
I'd only point out to your Lordship one thing. Kindly come to.
Yes. On 9/11/2023. And when this court passed an order on 1st of April 2024, that application was still pending consideration before the executing court. No orders were passed by the executing court on the application.
And stay.
He pressed only after the disposal of the writ petition.
Full stop.
There was a stay, my lord, in earlier writ petition. Earlier writ petition ಅಲ್ಲಿ, there was a stay, that is also noted, my lord. There was a stay of further proceedings. That is noted at page 104.
The learned counsel for petitioner has clarified that since there was an order of stay passed by this court.
Yes, my lord. That is noted, my lord, at page 104. I do not know the date of the stay order. Page 104 of the order sheet, my lord, of the trial court, executing court. Right hand side ಅಲ್ಲಿ.
Staying all further proceedings,
ಹೌದು.
No, only the execution.
Stayed.
Demolition, only the demolition part. Shifting of the gate.
My lord, wherein in WP number 24010 of so and so, wherein proceedings of this court is stayed.
So
ಆ ರೀತಿ ಬರ್ದಿದ್ದಾರೆ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ.
Interim order.
104.
ಇಲ್ಲ ಅದ್ ನೋಡಿದೆ interim order ಇದೆಯಾ?
The executing court, in its order dated 9/11/2023, took note of the order of stay and the application in IA number 4, though filed earlier in point of time, it was not taken up for consideration. Full stop. Next para. In that view of the matter, this court is of the considered opinion that necessary directions may be issued to the First Appellate Court, which is seized of RA number
38 of 2016.
to either consider the application for stay filed by the appellant therein.
ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
Huh?
ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಮೇನ್ ಅಪೀಲ್ ಇಟ್ ಸೆಲ್ಫ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಕನ್ಸಿಡರ್.
ಯಾವಾಗ ಡಿಸ್ಮಿಸ್ ಮಾಡೋದು?
Challenge, that order also.
Subsequently, my lord.
Your lordship will kindly take the order. That is dismissed. Idea is also
ಆಯ್ತು.
dismissed. In
ಏನ್ ಹೇಳಿದೆ?
2022 itself. I have been waiting for something to happen.
To consider and dispose of the appeal within a time frame.
That was on 19/10/2022, my lord. For stay.
Full stop.
Every effort is made to solve the execution proceedings. At page 28, I wanted to draw your lordship's to one attention of this court to only one aspect.
Next
Statement of objection, page 28.
Consequently, the writ petition stands disposed of with a direction to the senior civil judge,
First additional senior civil,
first additional senior civil judge,
Bangalore.
Mangalore, to consider and dispose of RA number 38 of 2016 as expeditiously as possible and at any rate within a period of 4 months from the date of receipt of a copy of this order. Full stop. Till then, the executing court shall not proceed to execute the orders passed by the decree passed by the trial court. Yes.
So the last operative portion, my lord.
No letter.
ಅದೇನಂದ್ರೆ ಆಪರೇಷನ್ ಸಕ್ಸಸ್ ಪೇಷಂಟ್ ಗೈಡ್ ಅನ್ನೋ ತರ ಆಯ್ತು.
Let them
Your
consider the
lordship
appeal.
may,
Let
no,
them
one
consider the appeal.
minute, kindly consider this. Your lordship may make it 2 months.
What
They will not argue. I am telling your lordships. 4 months ಅಂದ್ರೆ 4 months ಹಾಗೆ ಇರುತ್ತೆ, ಮತ್ತೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಬರ್ತದೆ. 2 months ಮಾಡಿ. To show their bona fides.
Expeditiously and ಹೇಳಿದ್ರು.
ಯಾವ್ದು ಹೇಳಿ?
As expeditiously as possible.
4 months ಅಂತ ಹೇಳಿದ್ರಿ, 2 months ಮಾಡ್ಬಿಡಿ. ಅವ್ರು ಮಾಡಲ್ವಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟು. 2016 8 ವರ್ಷ ಮಾಡಿಲ್ಲ. 8 ವರ್ಷ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿಲ್ವಲ್ಲ.
Now the council.
8 years ಏನು ಮಾಡಿಲ್ಲ ಅವರು.
1911
We're asking for 2 weeks.
Yes, only 2 weeks.
I have no objections.
ಆ 1 hour ಅಡಿ ಇದೆ, ಹೋಗಕ್ಕಾಗಲ್ಲ, ಬರಕ್ಕಾಗಲ್ಲ. ಯಾರಿಗಾದ್ರು ಏನಾದ್ರು ಆದ್ರೆ ಬರೋಕ್ಕೂ
The council has changed, my lord. It certainly will.
yes, yes. Council has changed, everything will change.
Yes. Oblige.
Raghunath, HR.
2 months, my lord.
2 months.
Great.
Big time for the complaints.
Yes.
Office objection.
Yeah.
1 week time.
Maintainability of the writ petition.
File.
Huh?
Argued, sir. This case, the respondent filed in a specific for professional suits.
There are 13 office objections and one of it is regarding maintainability.
If you give them 2 weeks, I will complain everything.
2 weeks are granted at the request of learned counsel for petitioner for compliance of office objections.
Much obliged.
Fitri, Shankar Ji.
For petition. But with regard to office objection, I believe there is only one objection with regard to index that's written in hand. ಅದು ಏನಾಯ್ತು ಅಂದ್ರೆ while inserting paper, one more additional paper, it's only handwritten. It's illegible, my lord.
Office objections are overruled.
But on merits of the case, the first respondent is the plaintiff before the trial court. The first respondent is filed a suit for declaration, possession and injunction. Admittedly, I'm in possession of the property. I'm the first defendant before the trial court. Now, the second defendant, the first respondent is claiming title through second defendant, second respondent, the BDA.
Huh?
BDA. Second defendant is a BDA. I'm the contesting defendant number 1 before the trial court.
You have purchased the property from BDA.
From third party, previous landowners. The plaintiff is allotee.
From allotee.
Allotee. There is a dispute, my lord. I will just point out what the actual dispute is.
Not allotee, my lord, from the original landowner, where acquisition was, my lord.
So you have purchased from BDA.
BDA. Yes.
BDA.
You have bought it from BDA.
BDA.
Not the.
Not. I'm from the previous landowners. Subsequently, there was a notification, there was sale, it's so and so. I will come to the merits of the case. They have sought for possession from me, admittedly, in the suit. They got the sale deed from BDA, possession certificate, allotment, everything is there. But my submission is, my lord, in 2011, November, I filed an application, IA number 4. It's Annexure D. I sought 4 documents because although BD is a party, they're not taking any participation in the proceedings. Lead evidence model, because they are the origin of the title, they are creators of the title, through whom the plaintiff is claiming. Now, what was really preliminary notification, final notification, final notification, it's presumed possession is taken. What they take is only symbolic possession, constructive possession. Actual possession, they conduct a mahazar. Mahazarali ಕೆಲವು ಜಾಗ ತಗೊಳ್ಳೋಕಾಗದವರೆ in award they don't give compensation. This is all the official record. It's admitted fact by the defendant also. I filed IA number 4. I summoned a junior engineer BDA, Vijayanagara BDA so complex. I sought 4 documents. Award passed by BDA for acquiring the land survey number 9, Malagalu village. I can run a site to survey number 9 also. Second one, Mahazar report
Application.
IA number 4 son.
Where is that application?
Annexure D.
Annexure
D.
Page
In
number?
page 48, madam. In page 48.
Issue summons.
Summons to this particular witness from BDA, the junior engineer of BDA. BDA, in fact, second defendant idru. Avare voluntary, they have to lead evidence, giving all documents. ಇಲ್ಲಿ ಮಾಡಲಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ there I filed this application. 4 ಡಾಕ್ಯುಮೆಂಟ್ ಕೇಳಿದೆ ಸ್ವಾಮಿ. ಇಲ್ಲಿ ಇನ್ನೊಂದು ಏನಾಗಿದೆ ಅಂದ್ರೆ ಮೈ ಸೈಟ್ ನಾನು ರೆವಿನ್ಯೂ ಸೈಟ್ ಏನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ, ದಿಸ್ ಕಮ್ಸ್ ಇನ್ ಎ ಪಾರ್ಟ್ ಆಫ್ ಎ ಬ್ಲಾಕ್ ಕಮೆನ್ಸಿಂಗ್ ಫ್ರಮ್ ಸೈಟ್ ನಂಬರ್ 401 to 412. ಅಲ್ಲೊಂದು BDA ಲೇಔಟ್ ಪ್ರಕಾರ ಲೇಔಟ್ ಪ್ಲಾನ್ ಅಲ್ಲಿ ಈ 411 ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ 411. ಈ ಎಂಟೈರ್ ಬ್ಲಾಕ್ all allottees got alternative sites. ಅಲ್ಲಿ ಒಂದು ರೀಸನ್ ಇದೆ. ಆ ಪ್ರೀವಿಯಸ್ ಲ್ಯಾಂಡ್ ಓನರ್ಸ್ ದೇ ವರ್ ಇನ್ ಆಕ್ಯುಪೇಷನ್, ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗಿತ್ತು, ಎಲ್ಲ ಆಗಿತ್ತು. ಈ ಸರ್ವೆ ನಂಬರ್ 9 ಅಕ್ವೈರ್ ಮಾಡಿದಾಗ ದಿಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಪೋರ್ಷನ್ ವಾಸ್ ನಾಟ್ ಟೇಕನ್. ದಟ್ಸ್ ಮೈ ಕಂಟೆನ್ಷನ್ಸ್. ಇಲ್ಲಿ ದೇರ್ ಫೋರ್ ಐ ಫೈಲ್ ದಿಸ್ ಅಪ್ಲಿಕೇಶನ್ ಟು ಸಮನ್ ದೋಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಯಾಕಂದ್ರೆ ಮಸಾಲ ಗೊತ್ತಾಗುತ್ತೆ ಯಾವ ತಗೊಂಡಿದ್ರೆ ಯಾವ ತಗೊಂಡಿಲ್ಲ. ಈ ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಆಯ್ತು ಸ್ವಾಮಿ, ದಿಸ್ ಇಸ್ ಅಲೋ. ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಸ್ವಾಮಿ ಇದನ್ನೊಂದು ಗನ ನಮಗೆ ಪ್ರೊಲಾಂಗ್ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ನವೆಂಬರ್ 2021 ಇಂದ ಬೇಲಬಲ್ ವಾರೆಂಟ್ ಆಯ್ತು, ಫೈನ್ ಹಾಕಿದ್ರು 2,000, ನೋ ಒನ್ ಟರ್ನ್ಡ್ ಅಪ್. ಆರ್ಡರ್ ಶೀಟ್ ಕೂಡ ಹಾಕಿದ್ದೀನಿ ಸುಮ್ಮನೆ. ಇದು ಅಲೋ ಆದ್ಮೇಲೆ ಒನ್ ಫೈನ್ ಡೇ ದೇಕೆ ಇಲ್ಲ ಈ ಆಫೀಸರ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗ್ಬಿಡ್ತೀನಿ, ಈ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇವ್ರ ಹತ್ರ ಇಲ್ಲ ಅಂತ ರಿಪೋರ್ಟ್ ಹಾಕ್ಬಿಡ್ತಾರೆ. ದೇರ್ ಫೋರ್ ಒನ್ ಮೋರ್ ಅಪ್ಲಿಕೇಶನ್ ಇಸ್ ಫೈಲ್ಡ್. ಅವ್ರು ಹೇಳ್ತಾರೆ ಇಬ್ಬರು ಡಿಫರೆಂಟ್ ಆಫೀಸರ್ಸ್ ನೇಮ್ ಕೊಡ್ತಾರೆ. ದೆನ್ ಐ ಫೈಲ್ಡ್ IA ನಂಬರ್ 5. ಇಟ್ಸ್ ನೆಕ್ಸ್ಟ್ IS. That's ink page annexure E, ink page 52, 51. That IA was allowed.
IA 6.
IA 5 son. This is IA number 5.
6 ಅಂತ ಬರೆದಾರಲ್ಲಿ.
ಅಲ್ಲ annexure E.
5 ಅಂತಿದೆ.
Annexure E.
E.
Ink page 51. On information furnished by the second defendant, I filed one more application. IA 4 allow ಆಯ್ತು, but they did not comply it. ಅವ್ರು ಏನ್ ಪರ್ಮಿಟ್ ಅಂದ್ರೆ ಫಸ್ಟ್ 2 ಡಾಕ್ಯುಮೆಂಟ್, ದೀಸ್ 2 ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆರ್ ಅವೈಲಬಲ್ ವಿತ್ ಫಸ್ಟ್ ವಿಟ್ನೆಸ್, ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಫೀಸರ್. ಯಾಕಂದ್ರೆ ಮಾಸರ್ ಮಾಡೋದು, ನೋಟಿಫಿಕೇಶನ್ ಮಾಡಿ ಅವಾರ್ಡು ಅವ್ರು ಮಾಡ್ತಾರೆ. ರೆಸ್ಟ್ ಆಫ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಬೇರೆಯವ್ರಿಗೆ ಆಲ್ಟರ್ನೇಟ್ ಸೈಟ್ ಕೊಟ್ಟರು ಈ ಬ್ಲಾಕ್ ಅಲ್ಲಿ ಎಲ್ಲರಿಗೂ. ಯಾಕೆ ಅನ್ನೋದು ಇಟ್ಸ್ ಅವೈಲಬಲ್ ವಿತ್ ಡೆಪ್ಯೂಟಿ ಸೆಕ್ರೆಟರಿ, ಸೆಕೆಂಡ್ ಡಿಫೆಂಡೆಂಟ್, 2 different officers. Therefore, I filed this application. Even this application is also solved. 2021 ಇಂದ ಎಷ್ಟು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಷ್ಟು ಸರ್ಕಸ್ ಮಾಡಬೇಕು ಆಯ್ತು ಅಂತಂದ್ರೆ ಇದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ರು. ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಅಬ್ಜೆಕ್ಷನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಲ್ಸೋ. ದೆನ್ ನೆಕ್ಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ರವಿಕುಮಾರ್ ಅನ್ನೋರು ಬರ್ತಾವೆ ಸ್ವಾಮಿ, SLA. ಕೈಂಡ್ಲಿ ಸಿ annexure DW2 ಅಂತ ಆಗಿದೆ. ಹಿ ಲೆಡ್ ಹಿಸ್ ಎವಿಡೆನ್ಸ್. annexure H, ink page 67. Ink page 67. This is what the affidavit he filed. The third party witness ಆಗಿ ಬಂದಿರೋ ಸ್ವಾಮಿ. It's a third party witness. Ravikumar is the ink page 67. ಇಲ್ಲಿ ಅವ್ರು ಒಂದು ಹೇಳ್ತಾರೆ, 2 ಡಾಕ್ಯುಮೆಂಟ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಇಲ್ಲಿ ಫಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ ಹೇಳ್ತಾರೆ ದಿ ಆಥರೈಸೇಷನ್ ಲೆಟರ್ ಇಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಬಿಫೋರ್ ದಿಸ್ ಡಾಕ್ಯುಮೆಂಟ್ 1. ಆಥರೈಸೇಷನ್ ಲೆಟರ್ ನನ್ಗೆ ಬೇಕಾಗಿಲ್ಲ, ನಾನು ಕೇಳಿದ್ದು 2 ಡಾಕ್ಯುಮೆಂಟ್. ನೆಕ್ಸ್ಟ್ 2 and 3 ಅದು ಅವಾರ್ಡ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಅಂತ ಹೇಳ್ತಾರೆ. ದಟ್ ಈಸ್ ನಾಟ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ ಐ ಸಾಟ್ ಇನ್ ದ ಅಪ್ಲಿಕೇಶನ್. ಸಮ್ ಹೌ ದೇ ಆರ್ ಮಿಸ್ಲೀಡಿಂಗ್ ದ ಕೋರ್ಟ್. ದೇ ಸಿ ಇಟ್ ವಿಲ್ ನಾಟ್ ಬಿ ಪ್ರೊಡ್ಯೂಸ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್. ಮಹಾಸರ್ನ ತರ್ಸೋಕೆ ಯಾರ ಕೈನಲ್ಲೂ ಆಗ್ತಾ ಇಲ್ಲ. ಇದಕ್ಕೋಸ್ಕರ ಇನ್ಫ್ಯಾಕ್ಟ್ ಇಲ್ಲಿ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಪ್ಲೇಂಟಿವ್ ಇಸ್ ಆಲ್ಸೋ ಮಿಸ್ಲೀಡಿಂಗ್. ಇಲ್ಲ ಅದೇ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಕೋರ್ಟ್ ಮಿಸ್ಲೀಡ್ ಮಾಡ್ತಾ ಇದ್ರು. ದೇರ್ ಫಾರ್ ಎ ಲಿಮಿಟೆಡ್ ಪರ್ಪಸ್ ಐ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ದಿಸ್ ವಿಟ್ನೆಸ್. ಆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಪೋರ್ಷನ್ ಐ ವುಡ್ ಲೈಕ್ ಟು ರೀಡ್. ಇಂಕ್ ಪೇಜು 68 to 67. 68. across ಓದ್ತೀನಿ. I want to show how they are avoiding these documents. ಕೆಳಗಡೆ ಲೈನಲ್ಲಿ second para. I do not know whether witness summons was issued to our department. Your lordship got it. I have been orally instructed to appear before the court by our panel advocate. I have personal knowledge about the documents 1 and 2 sought for in IA number 5. It is true to suggest that I have not produced the copy of the award passed with respect to survey number 9 as sought in the application. Admission, clear admission. I can produce a said award copy available in our department. The document which I have produced is the extract of award obtained from the ledger. It is true to suggest that
ಇಷ್ಟೊಂದೆಲ್ಲ ಸರ್ಕಸ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ನೀವು
Swami, ಈ ಕೋರ್ಟಲ್ಲಿ
filed an RTA application
ಅಲ್ಲಲ್ಲ ಅದನ್ನು observation
asking whether they have allotted alternative sites to those allottees who are
ಅದು
allotted sites
admission ಅದು
in
ಬಂದಿದೆ.
this survey.
It's admitted fact. They admit.
ಮತ್ತೆ ಇನ್ನೇನ್
ಇಲ್ಲ ನನ್ನ ಪರ್ಟಿಕ್ಯುಲರ್ ಸೈಟ್ ಗೆ ಬರಲಿಲ್ಲ.
ಅದನ್ನೇ ಅವ್ರು ಮಾಡ್ತಾ ಇಲ್ಲ ಅವರು.
ನಿಮ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಸೈಟ್ ಅಲ್ರಿ, ನಿಮ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಸೈಟ್ is given to him.
Given to him.
Therefore, the other sites that were allotted in the survey number,
Yes,
you are saying
Yes.
they were given alternative sites.
Yes, my lord.
You
Admitted
should
fact.
have got that information is more than enough.
ಅಲ್ಲ ಬಟ್ ನನ್ನ ಪರ್ಟಿಕ್ಯುಲರ್ ಸೈಟ್ ಗೂ ನಾನು ಇಟ್ಸ್ ಎ ಟ್ರಯಲ್ ಮೈ ಲಾರ್ಡ್.
ಹೆಂಗಾಗುತ್ತೆ ನಿಮ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಇವ್ರ ಹತ್ರ ಇದೆ, he has not sought for allotment of alternative site.
Apart from that,
ಅಲ್ಲ ಅದಕ್ಕೆ ಬರ್ತೀನಿ. ಐ ವಿಲ್ ಕಮ್ ಟು ದ
original landlord
ಏನಾಯ್ತು ಹೇಳಿ ಇವಾಗ? What is it that you are agreed
ಈ
on?
ಅಂಡರ್ಟೇಕನ್ ಟು ಪ್ರೊಡ್ಯೂಸ್ ದ ಡಾಕ್ಯುಮೆಂಟ್. ನಾನು ಕೇಳಿದ್ದ ಹಾಕಿಲ್ಲ, ಹಾಕ್ತೀನಿ ಅಂತ ಒಪ್ಕೋತಾರೆ. ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಇಲ್ಲ ಇದು ಎನ್ಕ್ವೈರಿ ಹೋಗಿದೆ, ಸೂಪರಿಂಟೆಂಡೆಂಟ್ ಆಫ್ ಪೊಲೀಸ್ ಹತ್ರ ಹೋಗಿದೆ, ಲೋಕಾಯುಕ್ತ ಹೋಗಿದೆ. ದಿಸ್ ಇಸ್ ಕ್ವೈಟ್ ನ್ಯಾಚುರಲ್ ಇನ್ BDI. ಆಲ್ ದಿಸ್ ಇಸ್ ಹ್ಯಾಪನ್ಡ್. ಇಷ್ಟು ಅಂಡರ್ಟೇಕನ್ ತಗೊಂಡ್ಮೇಲೆ ಅಗೈನ್ ಒನ್ ಮೋರ್ ಪರ್ಸನ್ ಕೇಮ್, ಸಂಜಯ್ ಅಂತ ಬರ್ತಾರೆ ಫಾರ್ ಸೆಕೆಂಡ್ ವಿಟ್ನೆಸ್ಗೆ DS. ಇನ್ಸ್ಟೆಡ್ ಆಫ್ DS ಈ ಸೆಂಡ್ ಸಮ್ ಸೆಕೆಂಡ್ ಡಿವಿಷನ್ ಅಸಿಸ್ಟೆಂಟ್. ಇಲ್ಲಿ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಐ ಆಮ್ ಅವೇರ್ ಆಫ್ ದಿ ಫ್ಯಾಕ್ಟ್ಸ್ ಅಂತ. ಒಂದ್ ಪ್ರಶ್ನೆಗೂ ನನಗೆ ಗೊತ್ತಿಲ್ಲ.
ಆಯ್ತು,
ಇದನ್ನ ಹೇಳ್ತಾರೆ. ನನಗೆ ಬೇಕಾಗಿರೋದು ಸೊ ಇಲ್ಲಿ ಒಂದು ಆಕ್ಚುಯಲ್ ಡಿಸ್ಪ್ಯೂಟ್.
agreed of what sir now?
IA ನಂಬರ್ 8 and 9 ನಾನು ಐ ಫೈಲ್ಡ್ ಅಪ್ಲಿಕೇಶನ್
Order.
ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ ಇಸ್ ಅಟ್ ಅನೆಕ್ಸರಿಯನ್ಸ್. ನಾನು ಇದು ಬ್ರೀಫ್ ಹಿಸ್ಟ್ರಿ ಯಾಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂತಂದ್ರೆ ಐ ಫೈಲ್ಡ್ ಅಪ್ಲಿಕೇಶನ್ ಯಾಕಂದ್ರೆ ಕ್ರಾಸ್ ನಾನು ಪಾರ್ಟ್ಲಿ ಮಾಡಿದ್ದೆ. ಐ ವಾಂಟ್ ಟು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಆನ್ ಮೆರಿಟ್ಸ್ ಆಫ್ ದ ಕೇಸ್. ಐ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಓನ್ಲಿ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದೀಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಯಾಕೆ ಸಿಕ್ಲಿಲ್ಲ, ಯಾಕಿದೆ, ಎಲ್ಲಿದೆ ಅದೆಲ್ಲ ಬಂತು, ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡಿದ್ರು. ಇನ್ಫ್ಯಾಕ್ಟ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಆಲ್ಸೋ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಬ್ಸರ್ವ್ ದಟ್ ಕೋರ್ಟ್ ಕ್ಯಾನ್ ಡ್ರಾ ಅಡ್ವಾನ್ಸ್ ಇನ್ಫರೆನ್ಸ್. ಇಟ್ಸ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಅಂತೂ ಆಯ್ತು ಸ್ವಾಮಿ. ಇಲ್ಲಿ ಇನ್ನೊಂದು ಅದ್ರ ಜೊತೆಗೆ ಇನ್ನೊಂದು ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡ್ಬಿಡ್ತಾರೆ. ಯು ಕ್ಯಾನ್ ಇಟ್ಸ್ ಅ ಪಬ್ಲಿಕ್ ಡಾಕ್ಯುಮೆಂಟ್, ಯು ಕ್ಯಾನ್ ಅಪ್ಲೈ ಫಾರ್ ಇಟ್, ಯು ಕ್ಯಾನ್ ಪ್ರೊಡ್ಯೂಸ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್. ಅಲ್ಲ, ಇಲ್ಲಿ ನನ್ನ ಸಬ್ಮಿಷನ್ ಸ್ವಾಮಿ, ಕೋರ್ಟು ಸಮನ್ಸ್ ಕೊಟ್ಟು ಬೇಲಬಲ್ ವಾರೆಂಟು ಫೈನ್ ಎಲ್ಲ ಹಾಕಿ ಕೋರ್ಟ್ಗೆ ತರ್ಸ್ಕೊಂಡು ಕೊಡದೇ ಇರೋ ಡಾಕ್ಯುಮೆಂಟು. ವೇರ್ ಇಸ್ ಕ್ವಶನ್ ಆಫ್ ಅಪ್ಲೈಯಿಂಗ್ ಇನ್ RTA ಅಂಡ್ ಗೆಟಿಂಗ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ಸ್. ಕೋರ್ಟ್ಗೆ ವಿಟ್ನೆಸ್ ಆಗಿ ಕರೆಸ್ಬಿಟ್ಟು ಇಟ್ಸ್ ಅ ಸ್ಟ್ಯಾಚ್ಯುಟರಿ ಬಾಡಿ. ಕೋರ್ಟ್ಗೆ ಸಮನ್ ವಿಟ್ನೆಸ್, ಕೋರ್ಟ್ ವಿಟ್ನೆಸ್ ಬಾಕ್ಸ್ ಅಲ್ಲಿ ನಿಂತ್ಕೊಂಡು ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ ದ ಡಾಕ್ಯುಮೆಂಟ್. ಅಪ್ಲೈಯಿಂಗ್ ಒನ್ ಸೆಕೆಂಡ್ ಅಂಡರ್ RTA ಗೆಟಿಂಗ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಇಟ್ ಡಸ್ ನಾಟ್ ರೈಸ್. ಒಂದು ಆಸ್ಪೆಕ್ಟ್ ಸ್ವಾಮಿ, ಅದು ಒಂದು ಥಿಂಗ್. ನಾನು ಸಮನ್ಸ್ ಮಾಡಿದ್ದು ಎರಡು ಪರ್ಪಸ್ಗೆ, ಫಾರ್ ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂಡ್ ಟು ಸ್ಪೀಕ್ ಆನ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಇಲ್ಲಿ ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ ದೇ ಫೇಲ್ಡ್.
To reopen the case and to recall DW2 and 3
for cross examination. ಅಷ್ಟೇ
further cross examination.
That is all my prayer. ಈಗ ಅವರು ಇನ್ನೊಂದು ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ನಾನ್ ಕ್ರಾಸ್ ಮಾಡಿದ್ಮೇಲೆ ದ ಪ್ಲೈಂಟಿಫ್ಸ್ ವಿಟ್ನೆಸ್ ಆಲ್ಸೋ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ದೀಸ್ ವಿಟ್ನೆಸಸ್. ಅಲ್ಲಿ ಫ್ರೀ ಸ್ಟೇಟ್ಮೆಂಟ್, GP ಸೇಲ್ ಡೀಡ್ ಮಾಡಿದ್ವಿ, ಪೊಸಿಷನ್ ಕೊಟ್ವಿ ಎಲ್ಲ ಹೇಳ್ತಾರೆ. ಇಲ್ಲಿ ಆಕ್ಚುಯಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಬರೋ ಸ್ವಾಮಿ ಡೆಲಿವರಿ ಆಫ್ ಪೊಸಿಷನ್, ಪೇಪರ್ ಪೊಸಿಷನ್, ಫಿಸಿಕಲ್ ಪೊಸಿಷನ್ ಅನ್ನೋದು ಡಿಫರೆನ್ಸ್ ಇದೆ. ಪ್ರಿಸಂಪ್ಷನ್ ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ ಬರೋದು ಇಟ್ಸ್ ಸಿಂಬಾಲಿಕ್ ಪೊಸಿಷನ್. ನಾನು ಆಕ್ಚುಯಲ್ ಪೊಸಿಷನ್ ತಗೊಳ್ಳೋದು ಮಹತ್ವದಲ್ಲಿ. ಆ ಮಹತ್ವ ಬಗ್ಗೆ ಮಾತಾಡಕ್ ಹೋದ್ರೆ somehow the plaintiff and the defendant second avoids it. ನಾನು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ಗೆ ಫಸ್ಟ್
What is the use of calling them from cross examination once again?
ಅಲ್ಲ, ಕೆಲವು
They
ಆಸ್ಪೆಕ್ಟ್
will do the same thing.
ಅಲ್ಲ ನಾನು ಪಾರ್ಟ್ಲಿ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಐ ಜಸ್ಟ್ ಪಾರ್ಟ್ಲಿ ಕ್ರಾಸ್ ಆಗಿ ಪೊಸೆಷನ್ ಬಗ್ಗೆ ಡಿಫರೆಂಟ್.
There are other modes in which you can get the documents, and the court has also made the same observation.
ಅಲ್ಲ I would like to read also. I would like to read.
Let them draw adverse
ಅಲ್ಲ ಇದರಲ್ಲಿ ಅಲ್ಲ ಅಡ್ವರ್ಸ್ ಇನ್ಫರೆನ್ಸ್ ಒಂದು ಆಸ್ಪೆಕ್ಟ್ ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ ಮೈ ಪೊಸಿಷನ್ ಇನ್ಫ್ಯಾಕ್ಟ್ ಐ ಕ್ಲೈಮ್ ಅಡ್ವರ್ಸ್ ಪೊಸಿಷನ್ ಆಲ್ಸೋ. ಯಾಕಂದ್ರೆ ಪ್ಲೈಂಟಿವ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ಹರ್ ಶಿ ಗಾಟ್ ಸೇಲ್ಡ್ ಇನ್ 2002.
adverse position
ಎಲ್ಲಿ ಕೌಂಟರ್ ಕ್ಲೇಮ್ ಇಲ್ಲ ಅವ್ರದ್ದು.
ಇದೆ
ಎಲ್ಲಿದೆ?
ಇನ್ ಮೈ ರಿಟನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಟ್ ಇಸ್ ದೇರ್.
ತೋರಿಸಿ. Where they have paid the court fees.
ನೀವು ವಾದ ಮಾಡೋದು ಬೇಡ.
required to fulfill 3 conditions
ಅಲ್ಲ
for
sir.
adverse possession.
ನಾನು
ಹೆಂಗ್ ಬರುತ್ತೆ ಈ
ಅಲ್ಲ
case?
ಮೈ ಸಬ್ಮಿಷನ್ ಇನಿಷಿಯಲಿ ವೆನ್ ಐ ಕ್ರಾಸ್ ಎಕ್ಸಾಮೈನ್ ವಿಟ್ನೆಸ್ ಮಿಸ್ಲೀಡ್ ಮಾಡ್ತಿದ್ರು ಕೋರ್ಟ್ಗೆ. ಡಾಕ್ಯುಮೆಂಟ್ ಇದನ್ನೇ ಬೇರೆ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕ್ಬಿಟ್ಟು ಇದೆ ಅಂತ ತೋರಿಸಿದ್ರು. ಸೊ ಐ ಕ್ರಾಸ್ ಎಕ್ಸಾಮೈನ್ ಐ ಪಾಯಿಂಟೆಡ್ ಔಟ್ ದಟ್ ದೀಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆರ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್. ಆಮೇಲೆ ನಾನು ಸಮನ್ ಮಾಡಿದ್ದು ಈವನ್ ಫಾರ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಟು ಸ್ಪೀಕ್.
It will be a futile exercise, sir. I don't think
There are
there's any-
several aspects I have to put in the.
May I kindly come to annexure P, my lord. The original landlord has filed petition before.
ನಾನು ಅದ್ರ ಬಗ್ಗೆ ನಾನು ಹೇಳ್ತೀನಿ. ಐ ಹ್ಯಾವ್ ನಾಟ್ ಸಪ್ರೆಸ್. ನಾನೇ
Quashing the acquisition proceedings on the ground that, my lord, possession was not taken out. My lord, kindly come to annexure P, page number 124.
And this is what happened in trial court also.
Para, my lord, 120.
I mean,
In the RTA application,
Togo-
if you give the proper question, if you say
my lord, that will take its
in
own
this-
time, my lord.
in this survey
ಅದರಲ್ಲಿ
number,
appeal ಹೋದ್ರೆ ವರ್ಷಾನ್ಗಟ್ಲೆ ಆಗ್ಬಿಡುತ್ತೆ.
which were the sites that were carved out and what were the allotments initially made by the BDA, and thereafter whether those allottees were given alternative sites. ಇಷ್ಟು ಕೇಳಿ ಸಾಕು.
ಅಲ್ಲ ಇದೆ
ಇನ್ಫಾರ್ಮೇಶನ್ ಬಂದೇ
ಅಲ್ಲ
ಬರುತ್ತೆ.
ಇದರಲ್ಲಿ
ಕೊಡ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಆಸ್ತಿ ಕೋರ್ಟ್ ಡ್ರಾ
my submission means ಇದು cross examine defendant. No matter is already posted for arguments. ನಾನು ಅಪ್ಲೈ ಮಾಡಿದ್ರೆ 30 days minimum ಇದೆ ಸ್ವಾಮಿ RT ನಲ್ಲಿ. If they don't produce, I have to file appeal. That will take a long process. ನಾನು ಕೋರ್ಟ್ಗೆ ಸಮನ್ ಮಾಡಿದಾಗ my submission is applying under RT and getting endorsement not necessary. ಕೋರ್ಟ್ಗೆ ರೆಸ್ಪೆಕ್ಟ್ ಕೊಡ್ತಿಲ್ಲ 2 ವರ್ಷ.
I will make an observation that this is the information that you want. I will permit you to file an application under RTI and I will direct them to issue all that information that they have.
And
Within a
moreover,
time frame.
ಅಲ್ಲ ನಾನು
Till that time, court will not proceed.
ಅಲ್ಲ ನಾನು ಒಂದು ಸಬ್ಮಿಷನ್ ಸ್ವಾಮಿ.
Yes.
The second difference of BDA, they are
ಅವ್ರನ್ನ ಕರ್ಕೊಂಡ್ಬಂದು ಬಾಕ್ಸ್ ಗಳಿಗೆ ಹಾಕೋರು ಮತ್ತೆ ಅದೇ ರೀ ಆಗೋದು ಏನು ಆಗೋದಿಲ್ಲ.
ಅಲ್ಲ ಇಲ್ಲಿ
You are not going to get that information.
they are the root cause for all the several litigations, my lord.
I will.
My lord, there
I
are
will
several
enable you to get
litigations.
the information.
I would like to show one more point, my lord.
Correctly.
My lord, just one submission, my
The
lord.
petitioner who is a
ಅಲ್ಲ ನನಗೆ ಕ್ರಾಸ್ ನೋಡ್ಬೇಕಾಗಿತ್ತು ಅದಕ್ಕೋಸ್ಕರ. I
the
would
contesting defendant before the trial court is aggrieved of the impugned order
12-7.
passed on IA number 8 and 9 in OS number 4412 of 2017. Stop. Next para. Learned counsel for the petitioner submits that although the Bangalore Development Authority through its commissioner is arrayed as defendant number 2 in the suit filed at the hands of respondent number 1 herein, nevertheless, the Bangalore Development Authority has not diligently participated in the proceedings. Full stop. It has therefore become necessary for the petitioner to file several such interlocutory applications seeking issuance of summons to the competent officer to come before the court and produce
and to speak
many of the documents
and to
that
speak
are sought by the petitioner hearing.
and to speak also.
Full stop.
ಎರಡು ತರ ಇದೆ ಅದಕ್ಕೋಸ್ಕರ.
Nevertheless, instead of the competent officer, such as the special land acquisition officer
And deputy secretary.
and the deputy secretary, the Bangalore Development Authority sent a first division assistant, second division assistant
SLO ಬಂದಿದ್ರು.
to answer the queries of the court and of the petitioner hearing. Full stop. Despite putting many such questions to the witness of the BDA, evasive answers have been given by the witness. Full stop. Although several of the documents which were sought by the petitioner are available in the records of the BDA, nevertheless, no such information or documents are made available to the trial court. Full stop. In that view of the matter, learned counsel for the petitioner submits that the petitioner filed the 2 applications in IAS number 8 and 9, seeking to reopen the case and to recall DW 2 and 3. Bracketally, the witnesses on behalf of defendant number 2 BDA.
Third party witness ಆಗ್ತಾರೆ. because BDA
The
ಅವರು
different number 2 BDA.
BDA.
BDA, but ನನ್ನ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ಆಫೀಸ್
Correct. ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ
BDA ತಾವೇ ವಾಲಂಟ್ರಿಗೆ ಯಾರು ಬರಲಿಲ್ಲ.
Close bracket. For the purpose of further examination. Full stop. Next para. On hearing the learned counsel for the petitioner, learned counsel for respondent number 1, plaintiff, and on perusing the petition papers, this court is of the considered opinion that although the impugned order cannot be set aside, nevertheless, having regard to the predicament of the petitioner hearing, necessary directions will have to be issued to the Commissioner, Bangalore Development Authority, to ensure that the documents sought by the petitioner hearing is made available before the trial court. Full stop. Next para. Accordingly, the writ petition stands disposed of, permitting the petitioner hearing to file necessary application.
Right to information act antane.
Before the second respondent, Commissioner, Bangalore Development Authority, seeking for the information as already sought in the earlier applications filed by the petitioner before the trial court.
Number 5.
Full stop. The Commissioner shall ensure that all the information which are sought by the petitioner are made available before the trial court through the concerned officer of the Bangalore Development Authority. Full stop. The petitioner is permitted to file such an application bar request to the second respondent, Commissioner, BDA, within a period of 1 week from today. Full stop. The Commissioner, BDA shall ensure that all the documents which are sought by the petitioner is either furnished to the petitioner directly or
court capital
shall be placed before the trial court through a competent officer of the Bangalore Development Authority as witness on behalf of the second defendant. Full stop. At any rate, all the information shall be made available as expeditiously as possible, and at any rate, within a period of 1 month from the date when which the application would be filed by the petitioner before the Commissioner. Full stop. Next para. Till then, the trial court shall not proceed
ಅರ್ಜೆಂಟ್ ಮಾಡ್ಲಿ ಅಂತ ಹೇಳಿ.
shall not proceed with the matter.
We will also inform Miller.
Full stop.
And time limit to Miller dispose of suit. Miller ಖಂಡಿಸಿ 2011 ಅಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೋಗಿದ್ದು. We also did not object. ಅವರ EML ನಾವೇನು ಅಪೀಲ್ ನು ಹಾಕ್ಲಿಲ್ಲ.
2017
ಎಲ್ಲಾನು ಆಗಿದೆ.
Not 11.
21 ಅಲ್ಲಿ ಹೋಗಿದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಗೆ.
21 ಇಂದ
They have also been filing applications after applications.
2021.
They are also not keeping quiet. They have also done what they want to do.
2017 11
ಅವ್ರ ವೆಂಡರ್ ಆಲ್ರೆಡಿ this court has said Miller acquisition is upheld.
However, having regard to the fact that the suit is of the year 2017, the trial court shall also expedite the process after securing the necessary information.
3 ವರ್ಷ ಅವರೇ ತಗೊಂಡಿದ್ದಾರೆ. ನಾನು I have not dragged it.
Endeavor to dispose of the suit as expeditiously as possible and at any rate within a period of 6 months after the information is made available at the hands of the second defendant, Commissioner, BTA.
Much obliged.
Your Lordship.
Serial number 64, Milord.
56, Your Lordship.
Friday, Milord. Serial number 64, Milord. Friday, Milord. ಅದರಲ್ಲಿ ಕೋರ್ಟ್ ಫೀ ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ಗೆ ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಬೇಕು ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ಗೆ ನೋಟಿಸ್ ತಗೊಂಡಿದ್ದೀನಿ. ಅವ್ರು ಹೇಳ್ಬೇಕು ಅಷ್ಟೇ ಸುಮ್ಮನೆ. ಶಾರ್ಟ್ ಪಾಯಿಂಟ್ ಫಾರ್ ಕನ್ಸಿಡರೇಷನ್. ಅಲ್ಲಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಹೋಗ್ತಾ ಇದೆ. ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪ್ರೊಸೀಡ್ ಆಗ್ತಾ ಇಲ್ಲ. ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
64.
64 ಸರ್.
ಏನಮ್ಮ ಇನ್ಫಾರ್ಮೇಶನ್ ಇದೆಯಾ?
Only record ಇದೆ my lordship. They have submitted the order ಆಗಿರೋದು. ಅದೇ ಇದೆ. Information
number
I'll get
64 released this matter on 21st of August.
Serial number 60, my lord. Serial number
56, Your Lord. Serial number 56. It was referred to the mediation. The file has come back. Serial number 56, Your Lord. It is a brother and sister's dispute. So shorted, it can be disposed of by virtue of because that's why.
Who is on the other side?
56 mediation ಗೆ ಅವರು ಬರಲೇ ಇಲ್ಲ ಅವರು. They didn't turn up at all, Your Lord. File has come back. 56, Your Lord. 7th. 56, Your Lord. It was referred to the mediation.
56 disposed ಆಗಿದೆ.
7 June 2020 it was.
56 has been disposed of.
Serial number 60, my lord.
I am not. Okay.
My lord, serial number 60.
Disposed ಆಗಿದೆ.
Please.
My lord, serial number 55, my lord. Entry mod extension.
ಮ್ಯಾಟ್ರ್ ರೀಚ್ ಆಗಿಲ್ವೋ ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡೋ ಪ್ರಶ್ನೆ ಇಲ್ಲ.
My lord, serial number 55, my lord.
Next, sir, ಇದು ಯಾವಾಗ ರಿಪೀಟ್ ಆಗುತ್ತೆ?
Entry mod extension ಆಗುತ್ತಲ್ಲ.
Next 2 weeks, sir.
Next week ಆಗುತ್ತಲ್ಲ.
ಸರ್ ಮೆಮೊ ಹಾಕಿದಾರ ಸರ್?
ಬೆಳಗ್ಗೆ ಸಬ್ಮಿಷನ್ ಮಾಡಬೇಕು.
ಗೊತ್ತಾಗಿ ನಮ್ಗೆ ಹೇಳಿ. ಆಯ್ತು ಬಿಡಿ. ಸರಿ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್
Entry ಮಾಡಿ extension ಆಗುತ್ತಲ್ಲ.
ಎಲ್ಲ ಇದೆ ಆಸ್ ಇಟ್ ಇಸ್ ಆಗೇ ಇರುತ್ತೆ ಸರ್. ನೋ ಚೇಂಜಸ್.
ಡೇಟ್ ಆಗಲಿಲ್ಲ ಸರ್. ಡೇಟ್ ಇಲ್ಲ. ನೋ ಡೇಟ್ಸ್.
Next week, sir, all matters.
ಆಲ್ ಮ್ಯಾಟರ್ಸ್.
Sir, 7 dispose ಆಗಿದೆ ನನ್ನ ಹೆಸರು. 7.
ರೀಚ್ ಆಗದೆ ಇರೋ ಮ್ಯಾಟ್ರ್ ಯಾವಾಗ ಬರುತ್ತೆ ಸರ್?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಸರ್ ಎಲ್ಲ ಮ್ಯಾಟರ್ಸ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 66.
ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ನೆಕ್ಸ್ಟ್
ಆಲ್ ಮ್ಯಾಟರ್ಸ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ನಾನೇನು ಸ್ವಲ್ಪ ಅದೇ ತರ ಅಂತೆ ಮಕ್ಕಳು ಕಳ್ಸ್ಬಿಟ್ಟಿದ್ವಿ ಸರ್ ಅಂತ ಹೇಳಿದ್ರು. ಆಯ್ತು ಬಿಡಿ, ಸೋಮವಾರ ನೋಡ್ಕೊಂಡು ಆಗ್ತದೆ. ಒಂದು ಫಾರ್ಮೆಟ್ ಕೊಡೋಣ.
ವೇಟ್ ಮಾಡಿ ಸರ್. 3 ಸರಿ ಹೇಳಿದೆ ನಾನು. ಏನು ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್? ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್. ಒಂದೇ ಸೆಕೆಂಡ್.
21 ಆಗಿರ್ಬೇಕು.